We have taken consent.
Hmm?
We have taken consent.
You have informed them. Acha, government side has filed affidavits.
Yes, SS Roy,
Okay. Heard Mr.
M. Kurmi.
M. Kurmi, learned counsel for the petitioner.
Yes, my lord.
Petitioner who prays that the standing counsel, CGC, that the opposite party has filed their affidavit and she wants some time to file her written reply. Prayer is allowed. List this matter when?
After 2 weeks,
List this matter on 22nd of June. Okay. Will it be too long? Or 15th of June?
of license.
15th of June. Wait, yeah.
Please, your lordship.
Hmm.
Lordship, for item number 28, 29, and 30, your lordship.
20, 29, and 30.
Lordship, I pray for an adjournment, your lordship.
Acha.
In this case, madam, I am for a petitioner, madam. In this case, madam, pleading are completed, lordship. There is a urgent.
Item 20.
28, 29.
Acha, 20, what happens? 20, Miss Mushari, you are taking time.
Lordship, they are the petitioner side.
And
20.
28, 29, and
These are all
30.
Oh, acha,
The
acha.
series matter.
20 you are not mentioning.
No,
No,
no, no.
28, 29, 30. lordship.
Acha, acha, these are analogous matters.
Analogous matters.
Okay, so you being a standing counsel taking
Lordship,
time.
lordship.
And you are for the petitioner.
I am for a petitioner, lordship. Madam, in this case, madam, pleading are complete, my lord. Ready for disposal, lordship. There
Then
is
why
my
are you
lordship.
taking time?
Lordship, the conducting counsel, Mr. Vedanta Kaushik is unwell, your lordship.
Okay.
May I therefore on my lord Monday, lordship, if possible.
Next Monday.
Monday, next month.
Next Monday will be 8th of June.
Lordship.
Is it okay?
Lordship.
Okay. Ms. D. Mushahari, learned standing counsel for secondary education, prays for a week's time, which is not objected to by Mr. D. Gogoi, learned counsel for the petitioner, list accordingly on 8th of June.
Lordship.
Obligation.
By please, your lordship, daily list item 19.
19.
19.
Yes.
Weeks needed, lordship, kindly date may be fixed.
Why not today?
Actually, sudden demise of Mr. S. Rava, senior
Acha,
advocate, needs some preparation.
Who died?
S. R. Rava. Sorry,
S.R. Rahman.
S. R. Rava. He was.
S.R.
yes,
Rabha,
yes,
Rabha, yes. Okay. 19 not likha, Mr. Miss Miss
D. Kolita.
D. Kolita prays for an adjournment on the ground that the conducting counsel has unfortunately expired. Prayer is allowed. List this matter on 26th of June.
22, 23, 24, any date, lordship.
Okay. 22nd of June.
Highly obliged.
Item number 1, my lord,
50?
52 and 53.
Acha. Supplementary? No. 52, I'll just take out, yes, 52, 53, hearing matter,
Hearing matter, my lord.
2018-17.
18 matter, but some, on last occasion, Honorable got directed to submit some instruction. The BTC council told me now that instruction is not.
BTC Council. Yes, miss?
Lordship, may kindly fix this matter on a hearing day as my 16th of senior colleague has already talked to my senior.
Acha, acha. But then 2017-18 is a very old matter.
Let the matter come on 16th with instruction on that day.
Instruction was supposed to be brought by her.
Yes.
Okay, okay. Acha, as a last chance, huh?
At the last.
Yes, Mrs. A. Bujabura, learned counsel for the petitioner, submits that the instructions from the BTC authorities have not yet been received, which is acceded to by Miss Bipasha Bora, B. Bora, learned standing counsel for the BTC. Prayer is allowed. List this matter when on a fixed date.
16th on a hearing.
Acha. Okay, list this matter on 16th of June. On which date matter will be taken up for disposal.
So, my lord, I have a prayer for item number 23, my lord.
23.
She is the petitioner, my lord.
Yes.
Lordship, in that matter also, my lord, instruction is awaited, my lord. So kindly some time may be given, my lord.
Ms. B. Bora, learned counsel for the BTC, prays for an adjournment on the ground that instructions are awaited. Prayer is allowed. List this matter on 18th of June. No, but
File an affidavit.
you are also there.
Yes, my lord.
Acha, yes, yes. Mrs. A. Bujapurwa is present, huh? You are supposed to file an affidavit.
Yes, my lord, but instructions are awaited, so.
List this matter on list this matter on 17th of June, by which date the learned standing counsel for BTC would get the instructions and file affidavit, if any.
My pleasure, Lords. I'd like to mention item number 14 and 15. Lords.
14, 15.
I have taken consent of the petitioner in item number 14.
Hmm.
Yes, he is there, Lordship. And regarding item number 15, I was under impression that the same petitioner is there because the name of the petitioner is same. So I'll inform him, Lordship. Otherwise, the item number 15 has become infructuous, but his presence will be required. So may I pray that matter may kindly be taken up next week, Lordship.
Both 14 and 15.
14 and 15.
15 otherwise has become infructuous.
In my understanding, because I don't know that 15 Lordship, they sought for provincialization and their service has been already provincialized.
So it's
And
okay, it's done.
Same person.
But the counsel are different. A.R. Bhuya.
So I was under impression that the same, so I took consent of them only. So I'll inform.
You inform him.
I'll inform.
Okay, Mr. A.H. Tavildar. A.R. Tavildar, learned standing counsel for higher education. Prays for an adjournment. Prayer is allowed. List this matter on
10th of my
10th of June.
Lordship.
Both the matters are 14, 15.
Lordship. Oblige, Lordship.
Yes.
Please, Your Lordship, I beg to mention item number 22, Lordship. I pray for some times to file the affidavit in reply, Lordship.
Acha. Your miss, you have
Honda,
A. Mohanta, learned counsel for the petitioner, submits that she requires some time to file affidavit in reply. Prayer is allowed. List this matter when?
10,
List this matter on 10th of June. Yes, Mr.
Item 49, my lord. Can it be taken up at 2, my lord?
59.
Yes, 49. There is a
49.
IA, my lord.
49 at 2.
Yes. ma'am.
Okay.
Some urgency, I have taken the consent of the petitioner also. ma'am.
Huh. 49 call at 2, huh, Vehemenda?
Oblige, ma'am.
Yes.
My lord, with the consent of the other side, I have spoken to senior counsel M.K. Chaudhary, my lord. Item number 10.
10.
Item number 10, my lord, we are seeking adjournment, my lord.
Hmm.
I was supposed to get some instruction from the department, my lord. They have filed an additional affidavit
Hmm.
to that. So, my lord, I'm
Okay.
seeking some accommodation.
Mr. Ardhar, learned standing counsel for handloom and textile department,
Yes, ma'am.
seek some time to file the, to get the instructions. Prayer is allowed. List this matter on when?
My lord, sorry for the question.
List this matter on 18th of June.
My
Oh,
lord,
that's a Thursday. 17th of June.
my lord, Thursday,
19th of June,
my lord.
Friday.
Friday will be difficult. Hearing
Acha,
online.
acha.
My-
Then 22nd of June.
My lord, my lord.
I beg to mention for listing of a petition. Listing of a
You can speak to the court master, he'll do it.
My lord, item 47 was supposed to mention today. They have informed me that.
Item 47, wait, I'll see. Anyone has mentioned? No, no one has mentioned.
Okay,
Let
my
the
lord.
matter reach.
Then let the matter come. Let the matter come. my lord.
Okay, today is the day for online, right?
Yes, my lord.
Online issues, yes.
Preferably online, my lord.
Preferably online, yes.
Lordship, with consent of the other side, I beg to mention item number 47.
Oh,
we are
47, yes, she's
We are
mentioning.
filing our affidavit
Hmm.
in opposition.
Ach.
My lord, I don't have any objection because we will also file the rejoinder then. Meanwhile, my lord may fix it in the next week, my lord. Then
Acha, who is for the petitioner? You?
I'm for the petitioner.
You're for the petitioner, yes, okay. Your name, please?
Miss Ritamani Bora.
Miss
Ritamani Bora.
Ritamani Bora, learned counsel for the respondent number.
Responding.
For the respondent, prays for an adjournment so that she can file her affidavit in opposition. Prayer is allowed. Mr. Medhi, right? Mr.
BM Deka, my lord. BM Deka.
Learned counsel for the petitioner, also submits that he would also file an affidavit, a rejoinder affidavit. Prayers are allowed. List this matter when?
11th, my lord,
11th of, okay.
June,
That's a Thursday.
Thursday.
Okay, 11th of June? 11th of June.
Much obliged, my lord.
Okay, Mr. Decker. Yes. No response by the other side.
Otherwise, here, whatever is lordship, this excess drawal, and in accordance with the last drawn basic pay, the department has already submitted the proposal for regular pension, and on that basis itself, that DCRG was paid, and lordship, that provisional pension was also paid. It is only the pension department. On verification, they found that excess drawal, and the Department of Pension has directed to recover the excess drawal.
Achha.
It is not the department. Department has already sent the proposal for regular pension on the basis of the last drawn basic pay. Therefore, it is perhaps the Department of Pension will.
Otherwise, your relief is ought to be granted, but then excess drawal is there, that they have to recover.
One portion, my lord, this is the problem.
Excess drawal in terms of that
Yeah,
wrong fixation.
Very well.
Because of wrong fixation.
Because of wrong fixation, my lord, okay, my lord, now my lord, proper fixation, they will pay pension, it's all right.
Mm.
But whatever I got, my lord, due to wrong fixation, that was also recovered from me. This is the.
And that will have to be recovered because it was due to wrong fixation.
We will file our affidavit.
As per my lord, judgment of the Honorable Supreme Court and our court also, my lord, which is, my lord, due to their mistake, I got, my lord, that should not be recovered. But at present, they will,
But then, okay, that their mistake, but you are not entitled for that amount.
no, because it is principle, because it is my.
Okay, I will see what the judgments are.
Let the affidavit.
Okay, let them file an
Lordship,
affidavit.
lordship.
Okay, heard Mr. A.R. Barbhia. A.M. Barbhia, learned counsel for the petitioner, and Mr. Sharma,
PN Sharma,
P.N. Sharma, learned
standing counsel,
standing counsel for
elementary.
elementary education, and Mr. A. Choliha, learned counsel for the pension, finance department. Mr. Yes, you are appearing for pension. Miss M. Burman for pension. P.D. Burman for pension. Mr. Sharma submits that he has the instructions with him and that he would like to incorporate the same in a form of an affidavit and prays for some time. Prayer is allowed. Let's just,
After 3 weeks. After
Long
3 weeks.
pending matter, my lord.
2020 matter.
Lordship,
Let's this
represent-
matter on the 17th of June.
Lords. Obliged.
Keep long.
You please file it before that because 6 years have gone.
Mr.
2020 matter.
My lord, I am MP from IIT Gauhati, but I understand the respondent number 4 is the one who has to reply in this matter, my lord, because
But what about the petitioner side today? J. Kolita and J. Gogoi P. Tamule?
it is otherwise a matter, my lord, where they
Ah.
have filed a writ petition because the
Hmm.
salaries were not paid by the respondent number 4. Respondent number 4 was a vendor of mine, but we have cleared all their contractual dues. That is my instructions, my lord. So if they have some submission, probably respondent number 4 will be able to.
Otherwise, you have cleared your dues,
We
only
have
that
cleared your
respond
dues.
number 4 is not
Respondent
giving.
number 4
But let
probably
the
they have-
petitioner side come and affidavits are filed.
My lord, my affidavits are not filed, my lord. Otherwise, we are ready. Well, we will file within some time, my lord. Grant
1,
us.
2, 3 we're supposed to file.
Yes, my lord. We are.
You are for 1, 2, 3.
Yes, my lord. I'm for a 1, 2, 3, my lord.
Acha. So 2 weeks time was granted in 21.
My lord, otherwise, my lord, the relief is not against me, my lord. That relief is against. But my lord,
Ah.
will give us a short time. If
Okay.
because it is their matter to contest, my lord. Otherwise,
Hmm.
I am respondent for lordship. And matter part of the personal financial matter, which is may not be lying in court lordship.
Acha, may not lie before the writ court. But let the petitioner side come,
I
okay?
think that was the thing.
In their absence, like, oh, they are workers under the private respond number
Yes, all
4.
the private
Contractor.
regarding salary, and the main thing is that regarding tender, 2020, lots of
Mm.
tender workers there, and that is the issue only.
Okay, let that
Yes,
come.
yes,
if my lord will fix it on 17th, my lord. By this time, we will also file our affidavits.
And try to inform the petitioner side.
I will try to inform.
Do you know them?
I
NJ Gogoi, J. Kolita. J. Kolita is perhaps, he is,
18th, my lord.
okay. None appears on call for the petitioner. Respondent sides are represented. list this matter on 18th of June. For the ends of justice, list this matter on 18th of June.
I will intimate.
Try to.
Lordship, in this matter, we have to file our affidavit. We will file.
File your affidavit.
No, we will file, Lordship.
Oh, you have filed.
No, Lordship.
You will.
Lordship.
Okay, let them file affidavit.
Lordship.
What?
2 weeks time.
Hmm.
It's a matter of provincialization, Lordship.
But see, last time I said only week's time will be given because, yes, rejecting the petitioner for provincializing her services.
Lordship.
So now today you are again seeking for time.
My learned colleague has already is preparing. So Lordship may allow 2 weeks time. By the time we will ensure that the affidavit is.
Mr.
PN, sir.
PM Sharma, learned counsel for the learned standing counsel for elementary education, further makes further praise for some time to file the affidavit in opposition. The prayer is not objected to by learned counsel for the petitioner. List this matter on, but this is last chance, okay?
Same day, Lordship.
List this matter when?
On 17th, your Lordship has fixed the first item 1,
17th,
17th.
17th of June,
Lordship.
not beyond that.
Lordship. Much obliged, Lordship.
As a last chance, we'll
Sure.
take it, yeah. As a last chance. Hmm? Yes?
Lordship, as instructions, the matter has already been in first stress, kindly dispose of the matter.
Is it infructuous?
Yes, my lord. I have submitted my instructions on the last occasions, my lord.
Huh.
So
Has placed an instruction, the petitioner has returned the money taken by him for Medica Chacha,
all the money has been recovered.
which
my-
was found to be fake. And that the disciplinary proceeding was initiated against and a penalty of deduction of and as such, he submit that the matter has become Acha, last time only you have said, right?
Yes.
Submit that she is yet to get, okay. Miss
D dash.
D dash, learned counsel for the petitioner, submit that she has instructions that the matter has become infructuous. As such, Mr.
B dash, my lord.
B dash and B dash.
D dash.
D dash, huh? D dash likhe ba? Mr. B dash, learned standing counsel for APDCL.
My lord.
APDCL is present. Matter is closed as infructuous. What about this IA? Oh no, there are 2 writ petitions.
Similar, my lord.
Similar.
Duitate, huh?
Obliged.
Closed as infructuous. Ouch. Yes,
May-
Miss Wapangla.
My lord, kindly pass off for time being.
Acha,
Time being.
after some time.
Lordship, this matter may be taken up after some time. My learned colleague, Mr. B. Talukdar, will be appearing.
Acha.
Lordship.
After some time, Mr. Counsel?
May I please? Your-
Hmm. Tag matters?
Yes, ma'am. We are grade 4 employees.
Acha, wait.
There is the.
Just a minute. Acha, some additional documents you have brought on record.
Yes, yes.
And what about response from the other side, Mr. Dhar? Yes.
For finance, we have filed an affidavit. The petitioners are claiming minimum of the pay scale.
Hmm.
Now, initially in the year 21, we had rejected the case
Hmm.
because at that time there was a sunset clause on the basis of which it was rejected. Pursuant to that, that notification was set aside. So pursuant to that, Lordship, if their names have been forwarded for consideration, that has to come from the government, the employers. That will be, I think, they were the employees under Lordship. Uh, Social welfare, yes, that will be the government, yes.
Hmm.
So, and now, Lordship, recently there is a judgment where Upendas has been set aside and they are asking for the benefits of Upendas only, Lordship.
But
So-
Upendas is set aside.
It has been set aside, but Lordship, those who were supposed to get the minimum of the pay scales, if their name has been included, then the government is supposed to take a decision for those left out workers.
Hmm.
Now, if the name of the petitioners have been forwarded by the department, if they can confirm, Lordship, then there is a decision to be taken whether those petitioners are to be granted minimum of the pay scale or not. If my learned friend can,
Minimum of pay scale.
yes, Lordship, as per the Upendas judgment, Lordship, because that has
If
been,
their names are forwarded, they will be entitled.
they'll be, Lordship, they'll be eligible for consideration.
Uh-huh.
And then the cabinet decision has to be taken regarding the cases of such pay. They are not the only ones, Lordship. They are
So
all
many.
over Assam. There are a lot of
Mm.
cases going on. So if my learned friend can just apprise the court if whether or not the names have been submitted, because if they've been left out, Lordship,
Page
So, Mr.
24.
Dhar, are their names forwarded?
My lordship, page 24 maybe, page 24.
Hmm. Yes.
no, Lordship, this, my learned friend is relying on a 21 letter that at that point of time it was rejected,
Alright,
Lordship.
let me complete.
Oh,
the
sorry.
submission.
Sorry. Sorry.
This is
Let me-
20.
Let me.
I apologize.
My lordship,
Yes.
Page 24 maybe, my lordship.
Page number 44.
24.
24. Yes, 24.
Yes.
Hmm.
The submission
24.
of reports
Hmm.
along with particulars regarding master role work charge, casual and similarly placed employees under Al Kapoor ICTS project Hailakan.
Hmm.
Here three names has been proposed, my
Hmm.
lordship. One is Sajjadur Rahman Barbaiya, second
Hmm.
is the petitioner, my lordship, in the this
Yes.
item number, and third is the next item is Habibur Rahman Barbaiya. So they three of the persons has been forwarded. my
Hmm.
lordship. Date of birth and everything has been.
For what? For
Now-
minimum pay scale?
Yes, my.
Hmm.
Now come to page 23, my lordship.
23.
23.
Yes.
Here also,
Hmm.
our names are there.
Hmm.
Sri HR Mazharbuya, AU Barbhuya,
Hmm.
and SR Mazharbuya. Now, my ladyship, I'll rely and affidavit in reply, my lordship.
Hmm.
Page 66, maybe.
Hmm.
Page 66.
Sixty-six.
Page 66.
56.
66. 66.
6 pages not there.
Yeah. Affidavit in reply.
Affidavit in reply.
Reply.
Affidavit filed by respond number 3.
Petition, yes. And we have submitted reply. So page 60.
Your
running page
your affidavit.
Yes. Running page 66.
66 not there. Maybe it's in the front. No.
In reply, which was
No affidavit has been received by the section till today. That is the office report. It is not
no,
tagged with
it
this.
has been filed. It has been
It is not tagged with this file.
filed.
Page 58 is the last here. And there is an office note, no affidavit.
Or we have filed, my.
Lordship, finance department's affidavit will.
No,
be-
his affidavit is saying.
Yes, affidavit in reply.
Affidavit in reply is not there. Affidavit in reply to whose affidavit?
It's a petitioner's affidavit in reply.
To whose AO?
To the affidavit in opposition to respond number 2 and 3.
Oh, two respondent, the affidavit by respond number 2 is the last one here.
Affidavit.
You check in this file. Yes. Writ petition 7305. Are you holding that file?
Yes, 7305.
7305, Hemanda. There is no affidavit by you.
It was filed on 7/9/2026.
See?
Almost 4 months, 5 months. 9/2/2026.
You heard Mr. SB Loskar. learned counsel for the petitioner, and Mr. R. Dhar, learned standing counsel for,
The next item also maybe there.
next item also it's not there.
Same, similar, it was similar.
But then your affidavit is not there here. Respond number 3, affidavit by R3 is the last.
It was filed on 9/2/2023.
No, it was R2. No. Yes? You verify with the registry, okay?
9/2/2026 we have filed.
No, it's not there in the other file also. And Mr. R. Dhar, learned government advocate, Mr. Dhar, learned government advocate, and Mr. A. Choliha, learned standing counsel for finance. Mr. Laskar submits that he has filed an affidavit in reply to the affidavit in opposition filed by respondent number 2, but the same is not found in the records. As such, the learned counsel is directed to verify with the registry and registry, full stop. List this matter on when?
Any short date maybe because.
List this matter on next Monday, 8th of June,
I leave. Both the petition.
in both the petition. Both the petitions, your affidavit is not
Yeah,
there.
yeah.
Same is the case here. He said that he had filed an affidavit, but
Yes,
it
sure.
was not in the records. And he was supposed to file, wait, let me see. Acha. So now that is in record,
Yes,
but the counsel is not there. None appeared on call for the petitioner. However, Mr.
And Bora, Your Honor.
N. Bora, you're for
Respond number 7, 8, 9, and 10.
learned counsel for respond number, you are there?
I'm there
Acha.
for the petition. My senior is on current on legs. It
After
may-
some time?
Yes, after some time.
After some time. Yes.
Yes.
Your affidavit is there on record.
Yes, my lord.
Hmm.
Filed an affidavit, my lord.
What was this matter about?
My lord, initially we have filed an application for my lord inclusion of my name as a first wife in the service pension book of the my lord, the respondent.
Acha, acha. These
was-
affidavits are exchanged.
Yes, my lord, it
Yes,
is
Your Honor.
complete now.
Pleadings are complete.
Yes, my lord. In
Okay.
fact, if I may take my lord to the last additional affidavit which I have filed, the matter has already been compromised as the my lord respondent number, my lord.
Your affidavit, additional affidavit.
Additional affidavit, there is a compromise, my lord, agreement which have been arrived between my lord the first wife and the second wife
Mm.
after the demise of the my lord husband.
Hmm.
That is respondent number 4, if I'm not.
Mm.
wrong. 6. Respondent number 6, my lord.
Yes.
My lord, if I may take my lord to the affidavit, my
So
lord.
after the demise of the husband, respond number 6, this first wife and the second wife's name were not there in the.
My lord, the name of the second wife was there in the, my lord, whereas the statute provides that the recording of the wife, name of the wife has to be there. As my lord, no divorce and or any other, the marriage was still there, my lord. So the name, inclusion of the name of the second wife, that by aggrieved by that we have approached this honorable court. But in the meantime,
Name of the second wife was there in
It was
the
there.
service book.
it was there in the service.
First wife, it was not there.
First wife, it was not there. Whereas the statute says that, my lord, that the name of the wife has to be there, but admittedly the second wife. is not
Wives,
Wife, my lord.
both
Only-
the wives,
Only the wife, my lord.
only the wife.
Only wife, because
So both I mean, they are the two wives. He had two wives.
he has two wives. rule. Admittedly, the second wife, my lord, as per the,
First marriage was not annulled, was not.
it was not.
So second wife will not be a valid
Yes,
wife.
my lord. That was the sole, my lord,
And
issue
then-
in the case, my lord.
yes.
In the meantime, my lord, the respondent number 6, that is the husband has already left for heavenly abode. And my lord, there has been a compromise which has been arrived at by the petitioner herein, that is the first wife and the second wife. That is, I have put before this honorable court, my lord, by way of.
Now, what is the requirement? I mean, what is the procedure? 50-50%
My lord, like
divided?
that, we have an arrangement that has been made between both the parties and the matter can be disposed of on this particular count, my lord, that we will approach the concerned authority, my lord, And we'll share it, my lord. That is the arrangement that we have come.
That sharing thing is allowed.
It is, my lord. We'll share it, my lord. Certainly, it is not allowed, my lord. It has to be deposited in the name of the first wife or the
First wife.
second wife.
The PPO
In
is
the name
PPO
of the first wife.
will be issued in the name of first wife, lordship.
The
Then-
PO will be in the name of first wife,
And-
definitely,
and then-
obviously.
Then we'll
And
share.
their own arrangement, lordship, the 50 or the whatever may be, lordship, they have their own arrangement.
You are for the first wife.
I'm for the first wife.
But
We have arrived at, my lord, an agreement.
Release in the name of first wife.
And then she will give something to her.
Yes, ma'am.
So that is their arrangement.
So matter can be disposed of count, my lord.
Okay. Where is the agreement? Page 59?
58, ma'am.
Huh. Hmm. Okay, all right. Heard Mr. R. Sensua,
My lord.
learned counsel for the petitioner, and Mr.
And Bora, Your Honor.
Ann Bora, learned counsel for respond number 7, 8, 9, and 10. And Miss Barmont P. For respond number 3. By this application filed under 226 of the Constitution of India, the petitioner has prayed for a direction to the respondent authorities. Who are the 7, 8, 9, and 10? These are children and wife.
Yes, Your Honor.
Oh,
When is
acha.
the second wife, my lord?
Acha, acha. Acha. Mr. T. Thakuria for respond number 3 and 4. 2 and 4, huh? Pisfale gulu no? Yes, directing the authorities to include the name of the petitioner as nominee in the service/pension book of respondent number 6, who retired as a assistant teacher from Tulsibari Bahumukhi Higher Secondary School and who had expired on
16/7.
and who had expired. The full stop. The petitioner has also prayed for deletion of the name of respondent number 7 to 10. That was a prayer, but then now you don't want. From the as nominee from the service pension book. The case of the petitioner is that respondent number 6 was working as an assistant teacher of the said school, and petitioner is was married to respondent number 6 on 26/8/1974. And since then, the petitioner and the respondent number 6 are husband and wife. Hey, that way to me কাম কৰ সেইটো আগত দিয়া marriage to, because he got his service after marriage. এনেকে আৰম্ভ কৰা. The case of the petitioner is that she got married to respondent number 6 on 26/8/1974, and since then they are staying as husband and wife. Thereafter, respondent number 6 joined as a Hindi teacher at Makhi Baha Higher Secondary School. Makhi Baha. And that after 1 year, he joined as an assistant teacher at Tulsibari Bahumukhi Higher Secondary School. The petitioner further states that out of the said wedlock, 2 girl child were born in 1979 and 89 respectively, and that both the daughters are married now. Where is the second marriage written here?
Second marriage, my lord, I'm not.
You have not written anything yet, Chacha. The petitioner, however, submits. Oh, no. After that, you write. Yes. On 30/9/2011, respondent number 6 retired from his service as an assistant teacher from the said school. And that he expired. Expired date is not there.
16/7/2025. It's in the affidavit, my lord.
16/7/2025.
Page 60, my lord. First
That-
line, whereas,
That he expired on where?
first line, my lord, it's page number 60, and whereas during the
Yes.
pendency of the so.
Which is expired on 16/7/2025. Thereafter, it is submitted by the petitioner that the names of respondent number 7 to 10 were included in the service book / pension. That was during his lifetime, right? Their names were included as a family pension. No.
I'd say as if, because he was alive, so no question of family pension, but the name of the second wife was there in the, my lord, as a nominee,
Service
it was
book.
there in the.
Name of respondent number 7 to 10 were included in the service book / pension after the demise of respondent number 6. Respondent number 7 to 10 are the second wife and children of respondent number 6. The petitioner states that the name states that she being the first wife, she is entitled for the pension, but her name was not included in the service book pension book / pension book after the death of her husband. Aggrieved, but thereby she filed the instant writ petition with the prayers mentioned above. However, during the pendency of the instant petition, petitioner and the second wife of respondent number 6 entered into an agreement which was annexed with the additional affidavit filed by the petitioner. Full stop. In the said deed of compromise agreement, it was stated that petitioner is the first legally married first wife. Petitioner is the legally married first wife of respondent number 6. And that respondent number 6, during his service period, remarried the second party. That is respondent number 7.
7.
Respondent number 7. And that respondent number 6 had put her name, that is respondent number 7's name, as the nominee in his service book. Acha, husband expired during the pendency of
During
this.
the pendency. Otherwise, he was a party to this particular.
It is further stated in the said agreement that agreed by the said inclusion of respondent number 7 as nominee in the service book, the present writ petition was filed, and that during the pendency of this writ petition, the husband expired. The petitioner also states that she and respondent number 7 have amicably settled their disputes with regard to entitlement of family pension of respondent number 6 in the following terms. 1 dear, the petitioner and respondent number 7 would divide the family pension equally amongst them. Nalage 1 koribo lage, etai ase. So they have agreed to divide amongst them. With the further decision that the petitioner would regularly provide. But whether this will help you in including your name in the pension book.
So the pension anyways certainly will have to be released in my name because I am the wife, my lord, and that has been agreed here.
But
also,
then your name was not there in the service book
my lord.
as a nominee.
Yes, ma'am. It was not there, but
So whether that amount will be given to you or to her.
we'll have to approach the concerned authority, my lord, and thereafter they will correct the record and then it will be credited in my name.
Okay.
Later on, when it is in my account, my lord, then I'll provide 50%.
Okay. Ki kolo? With the further decision that the petitioner would transfer 50% of the said family pension to the respondent number 7. Full stop. It was further decided that the petitioner would make appropriate application before the banker with regard to the same. However, it is seen, however, it is seen that the petitioner's name was not included in the service book / pension book, although she was the first wife of respondent number 6. As such, it is directed that the petitioner would make an appropriate application before the appropriate authorities, claiming the pension amount, and on receiving the same, the apportionment would be done amongst the petitioner and respondent number 7, as per the agreement mentioned above. With this direction, petition is disposed of. Yes, Mr. Counsel, I'm seeing you newly. I mean, you are appearing for? 7, 8, 9, 10, he is there?
Yes, Your Honor.
Okay, you can appear for respondent number 6 who died. Likhida, you are agreeable, right? Acha. It's okay. There is an agreement reached between the first wife and the second wife. And so, of course, she will have to make application before the authorities to include her name in the pension book. And thereafter, they will share it. So there is an agreement reached.
Our name should not be deleted because they have paid for deletion of our name. So our name will not be deleted.
Yes, that will not be done. That is not there in the agreement also. Okay. But the fact remains, you are not actually entitled, you being the second wife. So she will be entitled. If she is divorced and all, that we do not know.
But they expired.
Divorced, they are not divorced. So she is entitled for the pension. But divorce proceeding is going on, was going on.
Going on, my lord, what
But
has
then-
happened, my lord, if I may clarify. He was appearing earlier, my lord. for the
Before he died.
But he has recently filed his wakalat
Yes.
appearing for the same party, my lord. They were being disengaged and he is appearing, my lord. That is.
Let his name be there, and then as far as deletion of name, that is for the authorities to consider. Because you cannot be in the nominee book unless she gets divorced. She'll have to be there, right? And then there will be apportionment 50-50%. Okay. Petition is disposed of. Although there was a divorce proceeding going on between petitioner and respondent number 6, but the same had not reached its finality. And as such, petitioner is still the first wife of respond number 6. Etu didle hol mazot. Yes, Mr. Medhi. Etu kiman number dila? 7. Acha, time
Lordship,
being. Acha, what happened here?
Lordship, we have already filed our affidavit
Hmm.
stating the position. Now the petitioner is claiming that one of the respondent has already resigned. So
Huh.
in his place, he wants that provincialization. But according to the provincialization, there is no such norms, Lordship. This provincialization was done and this appointment, that post was created on personal nature. Once that
Person
any
dies, it that post
dies or
goes.
resigns, then that post gets adjusted. So
But
there-
yes, that is there. But provincialization in respect of one subject teacher in one school. So if he is the only,
That the earlier occasion, the honorable court has proposed, because that the respondent number 8, he has making a communication to the headmaster. He's saying that he has already resigned from service. Honorable court has proposed that can it be possible
we have already,
to consider the
that
petitioner?
instruction we have already provided. Now, Lordship, there is a provision for appeal under section 14 of the Act, 2017 Act.
before
Let him prefer an appeal
commissioner,
before the commissioner, because his name was not recommended by the district scrutiny committee.
My lord, herein the matter pertains.
you can approach the.
Yes.
No, my lord, there
there is
is
a
no
provision
any,
for
my
appeal.
lord. Here the fact is that, my lord, that the appeal, so far as my lord, that appeal is an statutory right, my lord. It has not, my lord, inherent rights.
No, of
the
course, that's
act-
an alternative remedy that you
No,
can always come to the
There's
High
no any
Court.
alternative remedy.
For a
What
moment,
I understood.
for a moment, may I take your Lordship once to that appointment order, that provincialization order? Page number 41 of the writ petition, Lordship.
Acha, I'll listen to you. Let
No,
me go through.
Because why?
41.
41. One of
Yes.
this provincialization order.
Huh.
This terms and conditions, Lordship, may kindly come to
These
clause
are
3.
same.
Clause 3.
3.
3. Page
Yes,
number
that I
41.
know, personal,
As
post shall be personal to the incumbents.
Lordship.
And these posts shall stand abolished on cessation of the services of the incumbents
Lord.
for any reason whatsoever, including retirement, resignation, death, etc.
Lordship. Therefore, he cannot claim that.
No, my lord, my lord, he's reiterating the same thing. With my lord, my lord, due respect,
tell me,
I'm saying
yes,
that
tell me
I'm
this.
not claiming he's against his post, my lord.
Huh.
That is the, my lord, the honorable courts propose. Honorable courts has, my lord, said, can it be possible, because on what basis the court has, my lord, assumed that I'm, my lord, that is not.
Acha, place your case first, I'll go
Yes,
through.
my lord. Exactly. So far, my lord, if he is going, my lord, he want to, my lord, submit on the, my lord, that, my lord, the section 14, the provisions, then I will argue on that matter. Because, my lord, herein, my lord, the very distinction is that, my lord, that the recommendations and, my lord, appointment is, my lord, totally different. The Act very clearly says that the appeal lies against the recommendation, not against the appointment order, my lord. Here, the recommendation, non-recommendation, that process has already expired. And, my lord, the another significant point is that, my lord, prior provincialization, they have not served prior recommendations. They have not served us any notice. These are the list, my lord, the generally administrative practice that has been done by the director, my lord, elementary education department, is that, my lord, and on the, my lord, the earlier occasions, they used to publish the list of recommended teachers. Then the teachers has come to the knowledge, and, my lord, they can prefer an appeal if they found that their name were not recommended. But here nothing was done. And, my lord, so far the catena of judgments are there, my lord. As for instance,
Your name was never recommended.
my lord, my name was not recommended. I am not aware, my lord, that thereafter the service of the private respondent were provincialized. The list of provincialized were services, my lord, published. And
But again, your grievance is non-recommendation.
no, my lord, I'm not challenging. Recommendation is a part, my lord. When I'm challenging that the impugn appointment of the my lord, private respondent, whatever legalities and illegalities the authority has observed, everything is under challenge. I'm not against the recommendation, because the recommendation, non-recommendation are already offered, my lord.
So what have you challenged then?
I am challenging the impugn appointment order of the private respondent, my lord, of the private respondent, 6 and 7.
But what is your grievance? Only against him?
No. My grievance is that, my lord, one person is junior to me, and, my lord, another, my lord, science teacher, his name was not in the 9-10 test data. As per the section 2.
The natural corollary is that you are not recommended.
No, no.
And
I'm-
others were recommended.
Yes.
So
Now-
if for non-recommendation, you can always go before the appellate authority.
No, no, my lord, a recommendation, and not recommendation is prior to provincialization.
Mhm. Even-
Prior
Prior to provincialization.
I'm challenging before the honorable court the appointment order of the
Provincialization order.
provincialization order. Exactly, my lord. Provincialization is order. My lord, act does not nowhere provides that, my lord, this is the
You are
provincial-
taking it indirectly, but
No,
the
no.
fact remains you are not recommended.
I may not be recommended, my lord, but they have not, my lord, published any list. Prior provincialization, the principal, my lord, the Wilford Corporation judgment was there, and there are catena of judgments. If, my lord, there is,
Place me what the documents, you are not able to place your case properly.
my lord,
What is the problem? Let me see. You have prayed for what? Provincialization with immediate effect.
my lord,
Quashing
setting aside of the impugn provincialization order.
appointment, you said.
Yes, my lord. Their appointment. I'm challenging their appointment, my lord.
Recommend the name of the petitioner for provincialization.
Yes, that can be as a
By
consequence.
DLC is not, if not recommended, and forward the same by appropriate authority. These are your prayers.
Yes, my lord. Well, unless and until
Hmm.
provincialized order, my lord, my prayer is the, my lord, to set aside the impugn provincialization. And as a
To
consequence,
provincialize your service,
yes, my lord.
not only setting aside.
No, because they are occupying my place. They are
But
occupying
then
my.
see, you are under 226. You have to place your case. You cannot just go against others.
No, my lord, I'm not. No, my
Huh.
lord, that, my lord, that the prayer I'm making is that, my lord, what is I'm challenging is that, my lord, so far as this, my lord, they are preferring section 14. As I have already, my lord, already
So
submitted.
show me the documents. Show me the documents. What you have annexed.
Lordship may kindly turn the page 23, my lord.
23.
23.
Yes, 23. Yes, 21.
23, my lord, here. Bakasam bag, my lord.
Hmm.
1, 2, 3, 4.
What is
Serial
the
number 12,
petitioner's name? Petitioner's name is what?
Bakasam bag, my lord.
Mm-hmm.
Bakasam bag.
Acha, Bakesan Bag.
My lord, his date of appointment, my lord, will file on 9th of year of joining is 1999, my lord.
Hmm.
Thereafter, my lord, thereafter, my lord, some limbo, Vistusing limbo,
Huh.
is 2000.
Yes.
His junior.
Okay, it is after you.
Yes, my lord,
Then,
thereafter, my lord, on bottom number 6.
yes.
Naren Chandra Mahato, it is handwritten, my lord, he is 2008.
Hmm.
Herein, my lord, these two persons has been appointed as an assistant teacher, even though both are junior to me.
Hmm.
And my lord, this name of another teacher, Vishnu Hatsa, not appearing here. His name is not appearing in the 2009-10. That is a mandatory requirement under section 2(1) X and B. So that is a mandatory.
So your name was there in the dice data?
Yes, my lord. Bakason Bag, my lord, petitioner. 1, 2, 3, 4. Serial number 4.
Hmm.
Serial number 4, my name is there in 1999.
Hmm.
Now, my lord, whatever they are submitting,
Hmm.
lordship, that
So what you are saying that those posts, the persons have resigned or retired?
no, my lord, that, my lord, immediately after provincializations, I have received, my lord, that the respondent number, that Naren Chandra Mahato 7 has made a communications to his, to the headmaster. That, my lord, will find on page 31. And so far as my lord, personal, my lord, instruction, he was not in fact serving in the school, he was serving somewhere else. But this name was forwarded, but these documents are not available, I cannot substantiate. That, my lord, will find on page 31, my lord, that is.
So show me your entitlement that your services are required to be provincialized.
My lord, on the ground of seniority, I am entitled, my lord.
Seniority, you are there in the dice data.
Yes, ma'am.
But why was your name rejected? Why not recommended?
My lord, that the district level committee can, my lord, apprise. the
Acha,
board.
so
They can
you
decide.
are challenging your non-recommendation and provincialization of private
No,
respondents,
no,
right?
recommendation, I will have to, at any consequence, I will have to challenge. Because that is a consequence of provincialization of my service. But I am challenging here in that, my lord, the main challenge, vital challenge is the, my lord, setting aside, my lord is correct. I'm to setting aside the provincialization order that has been passed by the competent authority by, my lord, Jing there, sir.
Acha, Mr. Goswami, whom are you appearing for?
I got 8 and 9.
Private respondents.
Private.
So, what is your case? Why was he left out?
Why was he left out, my lord? Because they found us similar to him.
But then DIAS data shows that.
As the no, my lord. That is very.
And I think what, of course, I subject to correction.
My lord.
In a particular school, there has to be one teacher teaching one subject, and then his services will.
Three other
It
teachers.
cannot be 2, 3 or something.
No, not like that. And
So-
the respondents have cleared in India affidavit, my lord.
This my lord is correct.
Section 311, there are 3 teachers to be appointed. One is for language, one is
Yes.
for science and math, and
Social-
one is for social
Social-
studies.
Ah.
Now, this is applicable
No,
when
but-
the enrollment position, the school is less than 100.
Acha.
And thereafter, if it exceeds by 30, for additional teacher for additional 30 students. That
can be arranged. It will go up.
This is based on the enrollment position of the school.
So what about the enrollment position of this school?
2,216, madam.
So more teachers can be provincialized?
Yes, madam, ratio is 32 as per the schedule, my lord, under section, in the RTA, there is schedule, my lord, under section 25. But I apologize, my lord, that act was,
Okay.
that was there, my lord, the schedule is there, my lord, ratio is to be 33:1.
Our affidavit, Lord, page number 65.
65.
65.
Yes. Yes.
Page number, this is a affidavit filed by the director.
Huh.
So 65, paragraph number 5,
Hmm.
we have stated that with regard to the statement made in paragraph 4 of the writ petition, the answering department states that as per DICE data verification report submitted by the SSA, because the DICE data has to be verified by the SSA.
Hmm.
Assam, the enrollment of the school during 2016-17 is 160.
Hmm.
So based on this enrollment position, Lordship, 5 teachers were recommended.
162.
160.
So 5 teachers were recommended.
Lordship, that with regard to the statement made in paragraph 5 of the writ petition, the answering department states that that as reported, Golaghat in the parawise comment so and so, that is so and so, the district scrutiny committee, Golaghat, decided in their meeting held on 21/12/2017 to recommend 3 teachers from recognized upper primary schools as science, maths, one Hindi as language teacher, as the name of the headmaster is included as one of the teacher of social science. And as per resolution of so and so dated, 5 teachers as tutors against the so and so school on the basis of the enrollment against 216 students in the year 2016. So therefore, this has been clarified.
Wait. 2016 students.
2016 students.
As of 2016.
Lordship, as
Then
of
how come there is a
2016.
difference in enrollment number?
And this enrollment 2016-17, it was 160, and again here it is 2016 to against 216 students. The names were Arun Kurmi, Bitu Hatsa, SGT Nandeswar Kurmi, Hindi teacher so and so, Limbu and Naren Mahato, assistant teacher. And the DO Golaghat has submitted as per the decision and proposal of the district scrutiny committee to the director. Therefore, the name of the petitioner was not there in the recommendation list of district scrutiny
Why?
committee. Lordship.
Why his name was not there? Admittedly, he is senior 99 and these people were all 2000, 2008.
Lordship, that has to be clarified there itself, the district scrutiny committee. If his name was not recommended by the district scrutiny committee, Lordship, I have just placed that provision, Lordship, section 14. Your
No, no.
Lordship, may kindly peruse. If his name is not recommended by the scrutiny committee, section 14, that
Appellate authority.
appellate authority.
Hmm.
So there is a provision for appeal. He could have approached the state level
my lord.
committee for non-recommendation of his name. So
May I
there is a
submit my-
provision, Lordship.
Yes. Hmm.
May I submit, madam?
Any recommendation by the DSC will be applicable towards SLSC.
SLSC, my lord. The SLSC section 6, it is not like a, my lord, compassionate appointment, that someone's name has been recommended and SLC is bound to, my lord, follow that recommendation. Here, my lord, DSC has to recommend that as per the strictly, my lord, as per the section 3111, maintaining that ratio, and so far as, my lord,
3111
section 3111, my lord,
of this 2017 Act.
2079. That is,
Three-
3111, that is requirement of, my lord, 1 maths and science,
Mm.
one social study,
And one language.
one language.
Mm.
And my lord 13, there is, my lord, that,
But against any recommendation of the district scrutiny committee, we can go to the
No,
state level.
my lord is correct. But procedure here is that any recommendations, my lord, that recommendation, non-recommendation, only I have come to the knowledge, my lord, after provincialization. But the procedure which is required to be followed is that, my lord, DSC has to, my lord.
It's okay, even if provincialization is done, you
No.
can always challenge the recommendation.
No, my lord, just let me clarify, my lord. My lord, let us, that, my lord, the DSC has made the recommendations. That is not, my lord, strictly in accordance with the provision of this act, because the seniority prevails. Now, my lord, it is the duty of the SLSC to verify every documents and to, my lord, scrutiny whether it has been strictly in accordance with the 2007 Act or not.
Mm.
Now, my lord, that the power of civil court has been vested to the SLSC. And there is, my lord, the provisions that if, my lord, there is any difference, my lord.
Then what
appears-
did the SLC do?
My lord, SLC upheld the illegal recommendations made by the DSC instead of recommendations.
Mm.
That has already been, my lord, passed through the SLSC. Now, my lord, SLSC illegally, my lord, without, my lord, rectifying that upheld the illegal recommendation, then that has been forwarded to the joint committee. Joint committee also verified, they have not rectified.
Joint
it-
committee has given the order, they have given the
Yes, my
recommendation.
lord, joint committee has given the approval. As a consequence, my lord, that provincialization order has been come up.
Mm.
Well, everything was verified.
Mm.
Everything was verified, recommendation, non-recommendations, and this, my lord, all the authority, including the joint committee.
So you can go to the state government.
Yes, Lordship.
No, my lord, joint committee is the, my lord, is joint committee, the government has issued the order. So government is very much aware. Joint committee has, my lord, there is a committee, joint committee, my lord, is joint committee is
Okay.
constituted. They have verified.
So there is
They
no
have verified.
purpose of going before the appellate authority.
Yes, my lord, they themselves, my lord, passed the order.
Acha, now Mr. Sharma, you must say why he was left out.
Lordship, maybe.
According to Mr. Goswami, he is junior.
Lordship, that has to be clarified, and moreover, Lordship, he is a science teacher.
Mm.
So there is only one science teacher is to be
No, I'm not
appointed.
saying
I am a science teacher, my lord. Response
My
number
lord,
8
with-
is a science teacher.
all due respect, my lord, may
He
I,
is
my
a-
lord, just one thing. My
Which
lord,
subject were you teaching?
I'm language.
Language.
I'm language, my lord. With all due respect, what I'm, my lord, just, my lord, suggesting is that, my lord, there as, my lord.
Hindi teacher Nandeshwar Kurmi is given.
Yes,
Yes.
He is Hindi teacher. Now, my lord,
He's
He is also
is-
senior to him.
no, ek minute.
Hindi
My lord.
teacher is appointed is senior to him. Then
So
the
language
science
teacher is Hindi teacher same.
No. Hindi is not a language, man.
Hindi is not
It's
language.
language, it's a language.
No.
It's a
look,
language
I know,
teacher.
There is
It's
a
a
problem.
language.
If, my lord, that is after, my lord, complying with the section 3111, if there is more enrollment, Hindi is, my lord, Hindi can be, as an additional subject can be provincialized. And I'm not disputing whether it is a language or not. But those teachers who remains on basis of seniority, they can be, my lord, they will have to appoint. Herein, my lord, two assistant teachers has been appointed.
Hmm.
What assistant teachers are junior to me? My lord, all due respect, my lord, why I can, my lord, suggest is that, my lord, in this,
See, in 3111,
my lord,
there shall be minimum 3 teachers or tutors, at least 1 teacher each for science, mathematics, social science and languages.
exactly, ma'am.
So 1 teacher in language, minimum.
Let us, even if it is assume the Hindi, my lord, that is language.
Hmm.
If we assume.
So
that-
language teacher, Hindi, Assamese, whatever will come within that fold.
Yes, man. My lord,
So
now
you
they
are also a language teacher.
And that's why I'm saying, my lord, this, the Mahato is also, my lord, there is nothing to substantiate which teacher very specifically teacher what subject. My lord, in this affidavit, my lord, they are not annexing any record. My lord, lordship may, my lord, I'm praying.
You're confusing all the things.
No.
Difficult. Hmm.
No, my lord, what I'm trying to say is that there is a teacher's performer.
Okay, let him make a representation and you consider.
No, my lord, lordship, I will, my lordship, may kindly one thing that recommendations made by the DLC, 2000 recommendation, that record may be called for. Because there is very specifically, everything is there, who taught what subjects, why, who has been recommended against what subject. Because they are hearing this affidavit, they are not annexing any record. They are making only the averments to ascertain those, my lord, that recommendation.
Acha, who is teaching what you bring those informations?
Record.
Malad, that record may be called for, everything
There
will
is
come
no
out.
issue, lordship, the record can be.
Then that malad,
Let's
that can
before
be
your
malad,
lordship.
that malad considering.
Could
that-
have said that in the
that-
beginning.
That matter would have been
Recommended
solved
let-
once he preferred this appeal before the
No,
state
they
level
are,
committee. They will
they are-
verify everything because it requires
No, no,
verification
let
again.
us- but
So
they
let
are
me-
not,
let me-
malad, they are not interested to adjudication before this honorable court. Malad, only malad, they are interested to go to the officers. who
Acha,
have-
okay, you bring the records.
Lordship,
Is also not very clear.
no issues, lordship. We will.
Mr. Goswami,
There is a clear alternative remedy.
No, malad, that is not
available
remedy.
law.
That is against recommendation.
alternative remedy, why?
Not interfere, my lord.
No.
No, what he
Malad,
said
this
is,
is 2021
wait a minute. You keep on saying when the others say.
My lord, the end point is, my lord, with the extension of this proceeding, my lord, day after day, my lord, my salary has been stopped on absolutely on an order which was passed on wrong pretext, man.
Your salary
He
has been
is
stopped.
claiming, my lord, yes, my lord, from June 2023, man.
In spite of the fact your service is provincialized.
Yes, man.
There is a stay granted by this
Yes.
court. Acha, so what is you are saying that he's junior.
My lord,
I'm
my lord, the
senior.
documents will show,
Wait,
my lord.
you please take your seat. I'll hear him and then I'll come back to
My
you.
lord, I have filed my affidavits, my lord.
Huh.
8, my lord, respondent number 8, affidavit filed by respondent number 8.
Mm.
These two Hasda, that may.
Yes.
be, my lord.
Hmm. Yes.
Your lordship will kindly see page 50.
Hmm. Hmm. Yes.
This is his appointment order, letter, my lord,
Hmm.
page 50, dated 27/11/09.
Hmm. 2009.
09, my lord, yes, 2009.
But then in the DIAS data, you are shown of
My
a
lord,
different-
because Dias data was sent, my lord, why he was left out, there is a reason. But it is not to say that I did not qualify, my lord. My lord, but Dias data was prepared for the year 2009 and 10 on 30th of September.
Hmm.
30th of September 2009.
Hmm.
From this date, that 6 years that which I require to, my lord,
No, what is your name?
I am Bistu Hasda.
Hasda's name is not here.
Not in the right.
Not in a DIAS data, Mr. Goswami.
My lord will kindly come to page 46, my lord, if I may be allowed to read it out.
Yes, 46.
Yes, my lord.
Hmm.
About the second sentence from top, my lord. The deponent, has your lordship, but
Hmm.
the deponent states that his service was provincialized in due process after fulfillment of all criteria laid down for provincialization. The deponent begs to state that it is a fact that his name did not figure in the district information system for education DICE 2009-10 dated 39/2009.
Hmm.
Since the deponent was appointed as science teacher in Simanta Sorupani ME School in pursuance of order dated 27/11/2009.
So 2 months
It
thereafter.
preceded.
No,
Yes, my lord, that DICE,
DIAS data dated 39/2009.
that preceded my joining, my lord,
Hmm.
issued by the school managing committee of the said school. Further, deponent denies the
But no, this DIAS data also shows services much beyond that. Oh, 2006, right?
my lord, kindly come to next page, my lord.
So petitioner joined in 1999.
Yeah.
And you joined 10 years later.
My lord, science teacher is away, my lord, the period that I need to come, my lord, spend that 6 years, my lord, that from this date, if your lordship calculates, my lord, I have qualified.
But the fact remains you are a junior.
My lord, I am a science teacher.
Okay,
That
you are
there
a
is
science
opening
teacher.
for a science teacher post, tutor or postman or whatever.
Yes, yes. One post for science teacher has
Yes,
to
my
be
lord,
there.
that's what was given to me.
So there your seniority, juniority will not
It
matter.
will not count.
And okay, that is your case.
My lord.
Respondent number 8
My
was a science teacher.
Yes, my lord.
And so his name was not there because he was appointed much later, 2009. And you were a language teacher.
My lord, if we come to, my lord, the provisions of section 4 of the act, my lord.
Hmm.
Has your lordship got that portion?
Yes, 4.
4, my lord.
Hmm.
Or, my lord, I'm reading out.
Hmm.
Or one, subject to fulfillment of all other provisions of this act, the services of the teachers and the tutors of all venture education institutions eligible under section 3 shall be deemed to have been provincialized on the date of publication of the provincialization order by notification in the office gazette and official gazette, and they shall become employees of the state government with effect from such date. The teachers and the tutors to be provincial under this act. One must have been working as a teacher in the concerned venture educational institution that have been fully recognized up to the last and highest class required for such institution by the competent authority on or before 2006, my lord. That is the standard there. Then, my lord, 3.
Hmm. Must have rendered at least 6 years continuous service.
Yes, my lord. Must have rendered at least 6 years continuous service as on 1/1/2017. So therefore, I qualify from the date of joining in the concerned.
So you
website.
joined in 2009 and you have qualified 6 years of service.
Yes, ma'am.
So in that basis,
As science teacher, ma'am.
as a science teacher.
Science teacher. And I was given the science teacher post.
And what about the other respondent? You are saying that 2 respondents.
Yes, my lord, yes, respondent number 7.
Respondent number 7, you are appearing, Mr. Goswami?
Page 20.
No, the 9.
20.
Correspondent Mahato.
He is appearing for respondent number 7?
R9, that will be R9, my lord. Respond number 9.
Hmm.
Nondeso Kurmi.
Ishtu Hatsa, they are appearing. 8 and 9, they are appearing. 7.
So what about 9?
Yes, my lord. Page 23.
23 years?
Your lord-
Nondesh Lawrence
Yes, yes,
Mahata.
yeah, that is 3 at serial 3. Above Bukasan Bag, above the name of the petitioner.
Nondeshwar Kurmi.
Yes, ma'am.
So he also joined in 1999.
And he's senior.
And he is what teacher?
He is, my lord, language, Hindi teacher.
He is a Hindi teacher,
Hmm.
language teacher. So you are also a language teacher. So provincialization of 2 language teachers will be required on the
If only
basis
the
of
ratio-
enrollment.
If only the ratio permits, only then.
It depends on their enrollment.
Considering the enrollment,
So enrollment, it is said 216,
216. Considering
more than 100, much,
That-
much more.
the 6 is required. That's why, my lord, my lord, praying before on the.
So Mr. Sharma, 2 Hindi teachers, 2 language teachers services can be provincialized depending on the enrollment. So enrollment is higher here.
Yes.
So why not his case be considered?
No, my lord, how can he be returning this?
No, that claiming against respondent number 7 is not a pleaded case, whether he has pleaded that.
No.
My lord, he gets some, on his submission, my lord, the instructions were brought from the
That
learned
honorable
friend, my
court
lord.
proposed, my lord. In the prayer, my lord, I am nowhere stating that, my lord. That is, my lord, some narrative they are creating. Honorable court proposed.
Heard learned counsels for all the parties. Mr. Sharma, P.K. Sharma, P.N. Sharma, learned counsel for learned, standing counsel for elementary education praised that he may be given some time to produce the records of the case, which would be necessary for the education of the present case. Prayer is allowed. List this matter on 8th of June, next Monday,
Well, including the recommendations of the DSC, ma'am.
8th of June. I already heard. I've heard it for more than half an hour on 8th of June.
Obliged.
Lordship,
Yes.
Lordship, I apologize. Lordship, I could not file the affidavit. I require 2 weeks more time because I also have to obtain some more instruction from the department, Lordship.
Okay, 2 weeks time.
2 weeks time, Lordship.
Ms. MS M. Bhattacharya, learned senior government advocate, additional senior government advocate, submits that in spite of best effort, she could not collect the required instructions and has prayed for a further time. Prayer is allowed. List this matter when? List this matter on 17th of June.
They are telling after vacation, Lordship.
No. 17th of June as a last chance.
Maybe, can it be on 19th, Lordship?
Okay, 19th of June on
Lordship.
Friday.
Deeply obliged, Lordship.
Lordship, kindly pass over for time being, Lordship.
Time being. Mediation failed.
And they take up this matter at 2 p.m.
2 p.m. 2
My lord-
p.m.
My lord.
Already
it's come
something is-
for Reading is complete.
Hmm.
It can come for hearing, my lord.
Acha, who is appearing? A.D. Chaudhary, Mr. A.D. Chaudhary. Okay, it went for mediation. I think it failed, right?
It will fail, I knew, my lord.
Because of the drive, it was sent. But there is no report from the mediator.
He's coming, Honor.
Uh-huh.
He's coming.
Last time that order was, there is no office note with regard to the same, 69/25. Oh, it was long back. Yeah, let him come. There is no service, there is no office note on this mediation thing.
Report.
No report also.
And then it is called again.
Acha, check the file if you can get any mediation report. Okay? I'll call it after some time. After some time, huh?
My lord.
Not two. Yes, Mr. Datta.
The last occasion, my lord, the departmental counsel was asked to file an affidavit.
Hmm.
Here, what had happened, my lord, the petitioners, my lord, are working as, my lord, postgraduate teachers, my lord, this
Hmm.
similar responsibility.
So affidavit is filed.
My lord, the affidavit was, my lord,
Mr. P.P. Datta appeared. You are
piece-
Mr.
basis, my lord, affidavit was filed, but that's not, my lord, comprehensive, my lord. It doesn't cover the main issue as to whether, my lord, we are entitled to the scale, number one. And number two, like only says that there's some proposal. The finance department is disputing receipt of the proposal.
Ah.
Finance department saying we not received.
So whether you'll file a comprehensive affidavit or that will do.
Lordship, we
You're for secondary education, right?
secondary, sir. We need 2 weeks time, Lordships, for collect the current status, Lordships.
For
Actually,
collection
Lordship, actually, Lordship, what happened, Lordship, already proposal has been sent to the government, Lordship. But Lordship, finance department has required some data of the petitioner.
So you
And
have to send it again.
Yes, Lordship. Commissioner.
Mr.
My lord,
T. Thakuria.
T. Thakuria.
time is being taken again and again, my lord.
Ah, that is
But
also there. You see,
There are two things here, my lord. One, my lord, is with regard to their, my lord, the recommendation of the pay commission. That has not been implemented. And secondly, my lord, we are asking for the postgraduate teacher scale, my lord.
Yes.
That is the second part. With regard to the second part, there is no answer in the affidavit that are filed.
Yes, Lordship.
So for the affidavit filed by the department is concerned, they are only saying that we have sent the proposal. So they have been sending this proposal for the last 3 years, my lord.
Yes.
But nothing has materialized thereafter.
So only
Again,
2 weeks
it's
time,
back to
Lordship.
square one.
again you'll have the same prayer
No,
after
Lordship,
2 weeks.
Only 2 weeks time, Lordship. Only 2 weeks time.
What proposal have you sent?
Actually, Lordship, in our affidavit, Lordship, paragraph number 5, Lordship,
Page?
running page 173, Lordship.
Hmm?
Running page 173, Lordship. Letter makes to state that the change the department.
It is within their department, my lord. They have
Yes, yes,
sent it
yes,
to the,
yes,
my lord,
yes.
the
Commissioner
commissionerate, my lord.
Yes.
Finance department, no, it's not lying
The
there.
petitioners have also been claiming they are entitled to
Yes.
both ADR and current salary as per 7 pay commission. In this regard, a proposal has been submitted before the government in 23. See,
23,
23.
Lordship.
And the finance department says the proposal has not been received, my lord.
Present instruction is.
And then President Finances, Sandhya.
Finance in their affidavit is very clear stand that proposal has been received from the parent department.
Proposal is
Simply
proposal what?
dealing with the matter.
First and final. Regarding proposal for equalization of pay. No. You are otherwise working on ad hoc basis.
No, we are regularized now, my lord.
You are regularized.
Right, but then the difficulty is not, we are not getting the scale, we are not getting the intermediate scale, number one. So as the pay commission recommended, my lord, the graduate scale plus some 3 increments. My lord, we are claiming a PGT scale.
You are
Postgraduate scale.
Postgraduate.
The difficulty is, my lord, even the part which the pay commission had recommended, they are not implementing even that also. So our prayers are twofold. First, give us what are the pay commission has recommended.
additionally, we are also entitled to the postgraduate scale because we are not only similarly qualified, we are discharging similar duties. So therefore, the second part has not been addressed at all. So where the first part is concerned, they're saying we have been sending proposals since 2023, but the finance department said we have not received any proposal.
That's 7 pay commission.
7 pay commission recommendation. That will be a part of the relief, my lord, not the entire relief. Even then, my lord, they'll give us some succor.
You are doing it district wise or what?
Yes, Lordship.
For all the teachers?
Yes, Lordship.
Lordship, may kindly turn to the
Wait, I'm reading their instruction. The director has informed that information are being compliant in the state level and in uniformity. Are being examined for clarity. No, they have not furnished it to the finance department. They
Yes.
have said here
Yes.
that they are collecting district wise.
Yes.
So there will be so many teachers.
Yes.
So that will take a long
no,
time. But then 23 they are doing. From since 23 they are doing.
petitioners are before
The
Lordship,
latest,
my lord.
latest instruction is that.
Petitioners are how many numbers?
How many petitioners, my lord, are
Are the district different
No,
or from the same?
Same district, my lord. They're, sorry, my lord, districts are different, man, of course. They are different districts, my
So
lord.
along with these
Nine
petitioners,
petitioners, man, 9.
so along with these petitioners, others are also considered.
That's true, man, but then
And so that's taking long, but 2023, the process is on.
Lordship, may
They should have
Lord-
completed by now.
Lordship, may kindly take up 131 and 132 per moment. Just that will things make very clear, make things clear.
130?
1 and 132.
Hmm.
Now, this is, my lord, the Pay and Productivity Commission report, my lord.
Hmm.
Lordship, you see, my lord, paragraph 5, my lord.
Hmm.
The commission
Hmm.
recommends that the pay scale of the vocational teachers, pre-senior madrasa and junior college teachers should be inserted in the next ROP. Regarding the pay parity claim, the vocational teachers, that is vis-a-vis the teachers having same entry qualifications, this commission observes the department has decided not to appoint vocational teachers any further, and therefore this issue can be decided if and when the department decides to appoint the vocational teachers. However, the existing vocational teachers with PG degree be paid PGT scale. There is a postgraduate scale.
Hmm.
Having said so, of course, they stop short. In page 32, what they recommended is Lordship will find at page 132, serial number C we are concerned with. Mela.
Pay, serial number C.
C. The teachers who have the basic equivalent qualification equivalent to the post graduation shall be given the grade pay of 3,300 plus additional
This
3
is what
increments.
you are showing. This is some guidelines. What?
This is the Pay and Productivity Commission report.
A report.
So, Mela, what this proposal is all about, my lord,
Hmm.
is with regard to what is in page 32.
Hmm.
So they have, this is a proposal which is not circulating or within the department.
So vocational teachers who are working now should be given postgraduate scale.
Our claim is that we are claiming postgraduate scale, but the pay commission recommended only that grade pay plus 3,300.
Hmm.
That also they are not implementing. So there are two parts to it. First, whatever has been recommended, they have to implement. And secondly, as regards our claim for higher scale, PGT scale, that your lordship is considered. But then the affidavit should be clear whether they are willing or not willing, whatever is reason.
As far as the first contention goes, that the decision should have been taken.
That's one thing. That will give us some benefit.
Okay, heard Mr. M. Datta, learned counsel, senior counsel assisted by Mr. Smith. P. Roy, learned counsel for the petitioners, and Mr. Thakuria, T.
T.
Thakuria. T.
T. Thakuria.
T. Thakuria, learned standing counsel for
Secondary.
Secondary Education Department. Mr. Datta, learned senior counsel, has pointed out that there are two prayers in the instant writ petition. One, the petitioners are claiming the benefit of 7th pay commission. And secondly, the petitioners are claiming the salary scale of, pay scale of postgraduate teachers.
PGT teacher.
Mr. Datta has already placed the report of the 7th pay commission.
Yes, but seven pay and Assam Pay and Productivity Pay Commission.
7th Assam Pay and Productivity, huh?
Pay Commission.
Pay Commission, wherein it was suggested that the petitioners and other similarly situated vocational teachers who were working as such should be given postgraduate scale of pay. And along with that, the report also suggests that the
No, well,
teachers
but-
who have equal who have basic qualification equivalent to the postgraduate teachers shall be given the grade pay of rupees 3,300 and 3 additional increments, which according to Mr. Datta has not been given till date. Mr. T. Thakuria, learned Standing Counsel for Secondary Education Department, has said that the affidavit has been filed. One affidavit has been filed,
Yes.
but the same does not include the required replies. And as such, he praised that he may be given some time to file an additional
Yes, sir.
affidavit in opposition to include the the required informations. Mr. Thakuria has placed an instruction dated 28/4/2026, by which it was intimated that informations are being furnished from the teachers district-wise. No, are being called for. Informations are being called for from the teachers district-wise, but few informations lacks clarity and few informations are yet to be received in a complete manner. As such, some time is sought for so that a proper report can be submitted to the finance department. Full stop. It is also seen that the issue is pending before the government since 2023. Until then, no concrete decision has been taken. And time is being taken a number of times, on number of occasions, dear. However, on the prayer made by Mr. Thakuria, another 2 weeks time is given and no time would be given after that. Okay, list this matter on, yes, you want to say?
Yes, a date maybe.
List this matter on 19th of June,
Yes, Lordship.
on which date the learned counsel would file their affidavit without fail. Or if on account of any failure, this court will proceed with the present documents, whatever is available.
Developed.
Master.
This is a matter, my lord.
Hmm.
I retired on, my lord, 31/10/2021. I'm an employee of municipality. But my
Affidavits filed, pleadings complete, Ms. Bhattacharya?
It is filed, my lord.
My lord, I am appearing for respondent number 4 and 5. On last occasion, Ms. M. Bhattacharya sought for time to file an affidavit on behalf of respondent number 1 and 3.
Lordship, affidavit, but somehow it could not be placed on record, Lordship. Kindly allow me on Monday, next Monday, the matter may continue.
Otherwise, it's
Even
filed.
Friday also.
It's filed.
No, it's not filed. Everything is done, but it's not filed.
Okay, Mr. Dhar.
My lord.
So it's already ready. She's saying that she'll file it. So next Monday
Friday, my lord. Maybe Friday, my lord.
or coming Friday,
No issue.
Ms. M. Bhattacharya, learned additional senior government advocate, submits that the affidavit is ready but not filed as of yet, and she requires some time to file the same. As such, list this matter on 5th of June 2026 for further consideration.
Obliged.
Deeply obliged.
20 adjourn is around. 20.
I am appearing for the respondent number 2, 3, and 4, my lord.
2,
And-
3, and 4.
And we have filed our affidavit in opposition on 19/5/2026. But in the record, my lord, that is not available.
Okay, you
maybe-
verify with the registry then.
Yes, ma'am.
Okay.
I've got the copy, Lordship.
He got the.
So it's not placed in the records. We'll take it up next week.
Yeah.
Yes.
So he'll verify with the registry. Okay. You are Mr.
DK Roy.
The D.K. Roy, Mr. D.K. Roy, learned counsel for the respondent number 2, 3, and 4, submits that the affidavit has been filed and a copy of the same has been given to the learned counsel for the petitioner, to which the learned counsel had acceded to the submission, but the said affidavit is not found in the records. As such, Roy, as such, it is directed that Mr. Roy would verify with the registry and get the affidavit in records.
Yes.
List this matter on 8th of June, next Monday.
Lordship.
He may file his.
Yes, I will
response
file
on-
reply, Lordship.
Oh, acha, তেতিয়াহ'লে বাদ দিয়া, সেইটো নিলিখিব।
Yes, Lordship,
Okay, let the affidavit come in records. Okay. In the meantime, the learned counsel for the petitioner submits that in view of the affidavit that he has received, he would like to file an affidavit in reply. Accordingly, list this matter on
after vacation, Lordship.
after vacation, no, on 22nd of June.
22nd.
Lordship.
Oh, acha. I'll just come back in 2 minutes time. Yes.
Writ petition.
Hmm.
I have challenged the impugn office order dated 30.
Affidavits are exchanged?
Yes, it is ready to be. heard.
Pleadings are complete?
Yes, ready to be heard. ma'am.
Ms. Bhattacharya, you are appearing, or Mr. Dhar? Oh, PNRD, who's appearing? Who should be here? Just call them. If they are ready, they might not be again. PNRD department has filed their affidavit.
Yes. I have also filed my affidavit.
Hmm?
I have also filed. my
Affidavit in reply. Okay. Go ahead.
The impugn order is on page 33.
Page 30.
33.
3?
33.
33. Yes.
Mary.
Hmm.
Whereas in pursuance of Gov letter number such and such dated 5/1/2023, along with inquiry report submitted by the IC Deputy Commissioner Kachar by letter number such and such dated 23/9/2022, Sri Surajit Rai.
Surajit Rai is the petitioner.
Petition.
Hmm.
The accredited engineer of Rajatilla GP under Katigoda Development Block Kachar have been found involved in gross irregularities and misappropriation of government fund.
Hmm.
Whereas on the basis of inquiry report, a show cause notice was issued against Sri Surajit Rai,
Hmm.
the then accredited engineer Rajatilla GP under Katigoda Development Block Kachar by letter dated such and such dated 6/5/2023. Whereas reply to show cause notice is submitted on 19/5/2023 by Sri Surajit Rai, the then accredited engineer Rajatilla GP under Katigora Development Block.
So he's
Kachar.
terminated.
Here only it is stated that it not found satisfactory.
Hmm.
My lordship, in the inquiry report, there is no specific charge, my lordship, against me, my lordship. Not a single-
He should be placed under suspension. Why terminated?
My lordship, it is a contractual employee.
Departmental proceeding has ended.
My lordship, there is no department, we are, I am a contractual employee, my lord.
Hmm. Oh.
And I was reinstated, my lordship, then kindly see.
Yes, Mr. Counsel, you are appearing for PNRD. Hmm?
Yes.
Yes. You have filed your affidavit.
Yes, affidavit has been filed. They have also filed a reclaim.
So things are ready?
Yes.
Okay.
My lord,
Hmm.
kindly see.
So he was terminated on 13th of July 23. Then?
23, my lord.
Then?
23. Now, my lordship, going to the background, my lordship, kindly see page 20, my lordship, it's the order, my lordship.
This petition is of which year?
This petition, my lordship, it's a 23, my lordship.
Acha. Hmm. Then?
My lordship, this is the order, my lordship. Earlier also I was terminated, my lordship.
Hmm.
I approached before the Honorable High Court.
Hmm.
Honorable High Court set aside the termination order. Pursuant to that termination order, my lord, this order was passed, my lordship.
Hmm.
This is annexer 2, page 20, my lordship. It was issued on, kindly see the date, my lordship, 1st February 2021.
Huh. Hmm.
The
Yes.
1st February 2021, my lordship, this order was issued, and here is specifically stated, in the light of above facts, Sri Surajit Rai acting is hereby reinstated the post and posted at Kathigora Dablam with immediate. He is not entitled for any salary wages for the period from other such and such, my lordship. So, my lord, after I joined on 1st February 2021, my lordship, within 1 month, my lordship, I was for only 1 month I was doing my service there. And at that point of time, my lord, some certain bills has been, I was out inside a particular room, my lordship, from certain people.
That was in March 2021.
21, my lordship. And then I submitted complaint before the BDO, my lordship, that such and such incident had happened, my lordship. In fact, due to this, my complaint, my lord, this all these things became surfaced, my lordship. But nothing has been done against my complaint. The bill was not stopped. Even the block development officer, the honorable court, on several occasions in the earlier order may be referred, my lordship, asked the respondent authorities what action they have taken against the block development officer and other officials, my lordship, who are permanent employee, my lordship. And being I am contractual employee, without any reason, my lordship, I have been terminated. My reply,
Show me the so cause.
my lordship. So cause notice, my lordship. Page 30.
30.
Here. There is no specific allegation, my lordship. Specifically what I have done, my lordship.
Wait 1 second. Okay, where is your reply?
My next page, annexon 9, page 31. No, my lord. Kindly page 27, my lord. First, my lord, ladyship, I was called to give witness, my lord. There was no allegation against me. This is the first letter which I received. That is the from to. I was called as a witness. Appearance as witness in hearing related to DP proceedings of Sri Nilutpal Datta, IC accountant, Katigora Development Block. With reference to the subject cited above, I am directed to state that it has been revealed during the course of hearing related to departmental proceeding drawn against Sri Nilupal Datta, that then accountant, Katigora Development Block, that you were found to have been involved in maintaining and furnishing of relevant documents, MR, MB, bill vouchers, etc., in execution of schemes under.
But then one of his duty is to maintain the bills and all, and to also revise.
Yes, yes.
So
I
he
submitted-
he had his duty, but otherwise he is under the engineer as well as the BDO.
Yes,
He is a contractual accredited engineer.
engineer.
So his duty is he doesn't have any financial power.
Yes, no.
His duty is only to keep the bills, to
and
maintain the bills, or sometimes revise.
And the departmental officers, they have to verify all this. I have submitted complete, all have been reinstated, my lordship. Even Nilulpal Datto, they have been reinstated because they were not contractual employment. The Honorable High Court, time
He
and
is in
again-
charge accountant.
in charge accountant. He was,
Acha, show me the order of this court by which he was reinstated.
my lordship. No, my lordship, this is my information that he has been reinstated. Earlier, the Honorable High Court directed the state respondents to produce the documents as to what actions they have taken against the block
BDO and all.
development officer
Acha,
and
this
other
is
officials.
page 17, the High Court's order.
Yes, ma'am. But, and in their affidavit also, they have stated, they have admitted, I have submitted the complaint, my lordship, that I joined in the office, my lordship, on 21st February.
Acha, wait.
Immediately after that, my
Acha,
lord-
just a few minutes. I'll just go through this. Okay. So,
My only grievance is that there is no specific charge against me. I have submitted complaint, my lordship. That was not entertained. BDO and other officials, they have been reinstated, my lordship. I joined just in February, and within that March, my lordship, I was not involved because I have submitted the complaint.
thereafter an inquiry took place, and after that, the
Inquiry took place
2022,
because
you are
they have
terminated.
They have not, they have ignored my complaint, my lordship. I appeared as witness first. And the show cause notice.
You participated in the inquiry?
No, my ladyship, then in the inquiry, I have submitted my reply also. And in the show cause notice, there was no specific allegation what I have done. And my reply also specifically I have submitted.
No, show cause notice there is that your negligence and you have been engaged to implement the various works under Manrega program.
which program I have, which act I have done, that is not specific. And I have also specifically answered, but the impugn termination order, just one line that your the so-called the prior to show cause notice is submitted on 19/5/2023 by Surajit Roy, the then accredited engineer, and it is not satisfactory. Kachar is not satisfactory. This is not reasoned order.
Okay,
Let
so,
us pass a reasoned order.
sir, what do you have to say?
And all other employees has been reinstated.
On different facts, yes.
Chief, with your permission, I'll just re-narrate the facts in gist. So initially there was a PIL which was filed before the High Court, that there was a direction to consider the representation that was filed by the PIL petitioner. According with that, an inquiry was conducted by the additional
PIL filed by whom? For what?
Lordship regarding some misappropriation of fund which is relying upon. Accordingly, ADC a team was conducted which was headed by the Deputy Commissioner. ADC conducted the on-field inquiry. Report was submitted. DC passed a speaking order saying that since DC is not the authority empowered to take necessary action against the likes of the petitioner, a speaking order was forwarded to the Principal Secretary to the PNID department. PNID Principal Secretary then asked the Commissioner to take necessary action. Accordingly, show cause was issued.
That was in consideration of a PIL.
Lordship, yes. This all flows from a PL, the direction of the PL, the misappropriation of
And
funds.
at that time, I was not in service in that particular claim. I was in another read petition.
You were terminated.
Terminated, and I pursuant to that order, I was just appointed in the in Rajat Jila.
In between, you were not there in the
No,
service.
no.
And that time PIL was filed according to
Yes.
you. Acha, then what happened?
Lordship, thereafter, show cause was issued. In that show cause, a copy of the inquiry report which was conducted by the additional deputy commissioner was enclosed and submitted, furnished to
It
the-
was furnished to him.
Yes, it was furnished to him. What you may peruse the.
Acha, along with the inquiry report, yes, by
Yes.
in charge deputy commissioner.
Yes, Lordship.
Okay, then
Thereafter, he files a reply. Show cause reply. In that reply, he admits that he had to, although the initial bill was 3 lakh rupees, but under duress, according to the petitioner, he had to revise the bills, which amounted to an exorbitant price of 29 lakh something. Thereafter,
we submitted for an amount of rupees so and so under tremendous pressure.
yes, Lordship.
Okay.
My lord, before
But then the fact remained he submitted. Okay,
sanction-
let him finish. I'll come back. You can have the reply.
Thereafter, perusing the inquiry report as well as the show cause reply, the commissioner took a decision as to terminate the services of the petitioner. Now, regarding the petitioner's contention that he had submitted a complaint before the BDO, that BDO itself was a part of this misappropriation, all this thing. That BDO was also proceeded against, although the documents which are not annexed in neither in our in the petition nor in the affidavit. But he was proceeded against, he was suspended and necessary action has been taken against him. Now, and one thing to point is also that in the inquiry that was conducted by the ADC, he submitted a para-wise reply to regarding the PIL, wherein also again he admitted the fact. Now, further to that, I have 3 contentions. Firstly would be that what is the status of the petitioners? Vis-a-vis.
It's of course a temporary, but then 311 he gives him the right.
No, Lordship, 311 wouldn't be applicable to the case of the petitioners because the likes of the petitioners who are governed by the terms and conditions of the contract. The contract had to explicitly incorporate in itself that the rules, that is Assam Services Disciplinary Appeal rules, will be applicable in the case of the petitioners, and only then the rigors of Rule 9 will come into applicability of the petitioner, which is not the case herein. The contract doesn't speak any of that. So, regarding that, I want to rely on a division-based decision of the Honorable High Court. If I may just.
specific charge should be framed first, my lord. There is no specific charge against him.
Yes. We may come to para 10, 11, 12, and 15. The facts of the case was that in this case.
Okay, fixed term contractual basis.
Yes, Lordship. In this case, the contract actually incorporated that the service rules would be applicable in the case of the petitioners. All clarifying this position in the division bench, the division bench held that at the, if I may read, para 10.
10 years I've gone through.
Yes, Lordship.
If 1964 rules were incorporated.
Yes, that
Hmm.
necessarily corollary would also imply that in the case, since the rules had not been incorporated in the contract itself, the case of the petitioners cannot be governed by the Assam Services Disciplinary Appeal Rules to that extent.
Hmm.
The second part would be whether in a case of contractual employee, whether a disciplinary proceedings which is envisaged in case of a regular employee can be done or not. To that I rely.
There are some decisions on
Yes,
this.
I have two decisions of the High Court. Lordship, one-
Supreme Court judgment there is, and it also finds mention in the order of this court. I've just read one of the judgment in Justice K.R. Surana's judgment, by which he was reinstated. Where was that? Yes. You see page number 19. Madan Gopal.
Page number 90 of the petition.
Petition, yes. There, the Supreme Court judgment is mentioned. It is now well settled. Page number 19, you take out. Have you seen it?
Page
Madan Gopal. It is now well settled that protection of 311(2) of the Constitution applies to much as temporary public servants as to permanent public servant. By virtue of 311, have been liable to be dismissed or removed until he had been given an opportunity. Regard to him, the appellant was given no such opportunity to be complied with.
Lordship, reasonable opportunity has been given in the case
Yes,
of the
he
petitioner.
participated in the inquiry and
Yes,
all, right?
participated, he furnished a reply, and then
Hmm.
if I may just highlight the two decisions of the High Court.
So apart from paragraph 10, you also said some few more paragraphs. What was that?
Lordship, 10, 11, 12, and 15 of the division bench judgment. Very 15 would be the relevant part.
My lordship, kindly.
Wait, one second. Actually, same judgment even you are placing.
Yes, yes.
Hmm. Yes.
Lordship,
Page 40, my lordship. Of the
No,
rapid-
he is placing two judgment, Jammu Kashmir.
Lordship may come to Ajay Kumar versus State of Jharkhand, a division bench judgment.
Hmm.
Lordship may come to para 20.
Hmm.
May I read it?
Hmm. Yes.
So far as the issue of initiation of departmental proceeding is concerned, this court is of the view that the said argument is having no basis. Reason being that the nature of appointment was purely on contract basis. Then as per the settled position of law, a contractual engagement is to depend upon the terms and conditions as stipulated in the offer of appointment, and there cannot be any deviation therefrom. Since the parties of the contract, after going through the terms and contract has entered into the contract, therefore cannot be any deviation anywhere, and no addition or alteration can be made in the said contract. Further 21, I rely on again 24, 25 and 26. Further, he needs to refer herein that so far as the nature of engagement on contractual basis is concerned, the Civil Services Rules 1930, which is applicable to employee working under the regular establishment, will not be applicable. Since the next paragraph, since the Civil Services Rules is applicable under the regular establishment and not for contractual engagement, rather for contractual engagement, the terms and conditions of the offer of appointment is to be made available. And then 26 and 27,
If
Lordship.
it is punitive, then natural justice.
Lordship.
Okay. Then this is division bench. That is single bench.
Then the single bench is of Jammu and Kashmir High Court, para 12.
But admittedly, in this particular case, it is punitive.
Lordship. This was also punitive, Lordship. the judgments I'm relying upon.
So natural justice has to be followed.
Natural justice has been followed, Lordship. Shokus has been given. He furnished the reply, and since the rigors of Rule 9 are not applicable in the case of a contractual employee.
And 1964 rules has not been
No,
incorporated, not
in this
been
contract,
adopted.
there is, yes,
Where are the terms of contract?
Lordship, that is at page 24 of the.
Terms of contract has already elapsed, my
Lordship,
lordship.
yes.
They have continued the service, my lordship. And the without.
In the terms of contract, there is nothing.
No.
1964 rules, service and appeal rules, not been adopted.
No, Lordship.
The terms of, initial terms of contract, it was already elapsed, my ladyship. After that, they continued the appointment, my lordship, by acquiescence, and they have, paid the salary.
But then the terms of contract is what? Extension.
No, my lord, extension, there is no, extension was done, my ladyship, without there being any contract. Without there being any written contract, extension one was done, my. If you go by the, even more than 10 years, my lordship, I was servicing, more, it took me more than 10 years. First initial appointment, my lordship.
So they are subjected to 1 month's notice or 1 month's pay.
Lordship.
First appointment was made on 31/12/2010. So more than 10 years continuously I was serving. If you go by the casual employee rights of casual.
Whether you are given 1 month's notice before termination or so.
Before termination,
In
one
the
notice was
initial
given. I submitted reply and they have simply said that it is not satisfactory. My ladyship, kindly see their stand in the affidavit. They have stated in para 40, kindly see.
Paragraph?
Para 40. Para 40, there is a. small-
Affidavit by R2.
Yes, right. Page 40, running page 40.
Yes.
It is pertinent to mention here in that as per the statement of the petitioner in the pleading that he had to revise the bills and resubmit the same under duress from the local leaders, and same was reported by the petitioner to BDO Katigoda Development Block by the letter dated 1/3/2021 is totally baseless as these officials including.
No, but this fact remains,
My lord.
the fact remains that you have submitted
Yes,
under duress, for which you have filed a complaint before the BDO.
BDO.
BDO is also a,
Nothing has been done against the BDO and the permanent employee.
BDO is also an accused.
My lordship.
And proceeding was also against him.
My lord, Honorable Court time and again requested, directed the respondent authority to submit as to what action they have taken against the BDO and other officers, but.
BDO, the proceeding is pending. That has come to an
He has
end.
been already reinstated, no proceeding, my ladyship.
Reinstated?
BDO accounted only the contractual employee, those who don't have the permanent job structure, they have been terminated.
In his affidavit, when was this affidavit filed? 2025, September, July.
Honorable Court earlier occasion also directed them to produce before court whether any action was taken against the BDO. This statement they are making that BDO also collectively involved. But what the action they have taken against the BDO?
No, that is a separate issue. The departmental proceeding was initiated.
Article.
Thereafter, inquiry was done.
An inquiry was done. If everybody is involved, my lordship, why only the contractual employees are selectively picked up, my lord?
This is for the inquiry.
In
This
the
is for the
departmental
inquiry officer to reach to that conclusion.
My lord.
We are not with the entire facts. We are only against the termination order, your termination order. And it preceded with an inquiry that was given to you. And then you had submitted a reply.
There is specifically, there is no indication.
Whatever it is, in the reply you said that yes, I have submitted a revised bill. And then under the pressure. Why will you come under the pressure?
My lord, that was a complaint, my lordship, before the inquiry started, my lordship. Then and there I submitted that complaint, my lady. Then and there, not that after the.
No, see your reply, see your reply.
Then and there I submitted my.
The material bills and other documents of rupees so and so was duly submitted
Dated my-
to the category as per volume of work available in the field. However, I compelled to revise the bill and resubmit it for an amount of rupees 29 lakhs under tremendous pressure of the local so-called leaders and oral instruction, pressure of the then BDO. I prepared the revised bill under duress. The local leaders kept me locked in a room.
Complaint dated 1/3/2021. It's not that after the matter was brought to notice after inquiry. Before inquiry, I have filed a complaint.
So this was before the order of this court?
Yes.
March 21?
Yes.
No. The order was of 2020. 2021, your reinstatement order was January.
January. Then I was just posted there 1 month back.
After 1 month only this happened.
Yes. I
And-
posted I was a new employee there.
Same department?
Same department. Just I took the charge. And before inquiry, my ladyship, I submitted the complaint. It's not that after everything has been come.
Yes, yes. Before inquiry, you submitted a complaint. And then there was also complaint against the BDO and all, and it was investigated, it was inquired. And what action has been taken, that is not our concern.
Ignored my complaint, my ladyship.
You never know what BDO might not have taken anything. BDO is himself involved.
Yes. But nothing has been done against them. Only
You submitted representation before them. Otherwise, all other formalities are complied with.
Reasoned order at least.
That it be amounting to setting aside the whole inquiry. that-
Because I have submitted, nothing has been done against the BDO or other officers. I have submitted complaint.
He has been working since 10 years, and then there are other complaints against the BDO and other officials.
Okay.
There you have taken action, whatever it is, not our lookout. But the fact remains, you pass a speaking order, let him file a representation.
Yes.
With these things has to be set aside.
Yes.
Lordship, that termination order itself is an order in the recent
See,
order.
termination order. On the basis of the inquiry report, a show cause notice was issued. You have submitted a reply. Reply was not found satisfactory. That is the only basis.
Lordship, that is the only procedure that is to be adopted in the case of the likes of the petitioner. Look, because if his period is accepted that a reason order be passed, that means saying that he will be setting aside the whole inquiry itself, Lordship. Although that cannot be done, Lordship, because of principles of natural justice. has
Inquiry
been-
report was given to him.
Lordship, yes. He submitted in the preliminary inquiry also.
Take no allegation against him.
But the fact remains, you had done it. It's not that you have not done it.
Let them give a reasoned order, my ladyship. I will submit representation. Let them reconsider my grievance. Because I have submitted a complaint before the inquiry. In fact, on the basis of my inquiry, that misappropriation was came to the fore.
Lordship may consider this judgment.
And all other permanent employees, they were not, nothing has been done against them. They are doing service. They have been reinstated. Even in fact,
But
the
your
videos,
reply was not found satisfactory, but
at least they should say that why it is not, even what they have done to my complaint 1/3/2021.
where is your complaint?
My lordship, I have complaint filed, they have admitted that.
Where is that?
approach all the
Where is your complaint and their admission?
My lordship, that is page 40, my lordship. They are telling that
Where?
it is page 40, my lordship.
40.
40. They have also annexed the complaint also. Complaint. Because I don't have the received copy of the complaint, I didn't annex that. I have the Xerox copy of the complaint.
No, where is your complaint before the BDO?
That is not annexed, Lordship.
Not annexed.
No.
My lordship. In my Shoko's reply, my lordship.
And in your reply, you have stated about the complaint filed by him before BDO.
Yes, Lordship. No, that was in rebuttal to his statement in the writ petition, which he said that he had submitted a complaint.
So what is your rebuttal?
So we have only said that the page 40, Lordship.
Yes.
40.
Yes.
Acha, baseless.
Yes, it is baseless, and because the BDO itself was a party to those misappropriation.
See, you have already filed your reply and all, it was not considered. There will be no purpose in again giving an opportunity to
Well,
file
at least this
representative.
will reconsider my plea that I am innocent. We will give a result order, nothing. They
Mm.
can again.
You are not
trans-
innocent, okay? You have done it under duress. You have done it under the force.
Filed before my lordship 1/3/2000, just after taking charge, my lordship. Within 1 month, my lordship. I was suspended, then again within 1 month. And the PI was filed regarding the incident.
Okay, heard Mr.
Lordship may also consider the third judgment that I have relied upon, Abu Hurira. Similar fact arising from the PL 80/2021 case has been dismissed, considering all the.
That fact is different.
No.
my lordship. Because all the allegations, only after I have filed the complaint, all those allegations came to the notice of the respondent authorities and PIL was filed.
Where is the reinstatement order? Where was that?
My lordship. Reinstatement order.
20.
Hmm.
20.
20,
two.
my lordship.
20.
Order dated 1/2/2021.
Page number 20.
Lordship.
Yes. And here the department has said that. I have
So
not
how
done-
many months you have been again extended or what? You are appointed till?
In the light of the accredited engineer, he has been reinstated to the post of AE and posted at category development with immediate effect. He is not entitled for any salary wages for the period from 8 to 2018 till the date of his reinstatement. The entire period of absence shall be treated as dies not.
So you are reinstated for how many months? It is not reflected here.
There is no contract existing as on date.
Contractual employee, he has
There
to be
is no
given a
contract.
period, then again extension. How is he employed?
Lordship, initially there is a contract that
Huh.
is signed by both the parties.
This one I have seen. Where is that? That
Lordship,
was for a fixed period of how many months and all?
3 months or 4 months, I believe. That is page 22.
So that has expired.
That has expired, and after that, in that similar case which I have relied upon, it was the instruction on oral instruction. It was stated that although the department wanted to get them into the contract, but the petitioners and likes of the petitioners of contractual employees, they didn't want to sign any contract, because of which there is no written contract existing as on date.
So
But
here
they-
also
they were-
same case.
but
He
they have
did
been
not
appointed.
sign.
Lordship?
He also did not sign.
No, they didn't sign.
And so it was not, no agreement was entered
There is
into.
no agreement.
And that agreement expired, or there is any chance of, revival of the same? Show me that agreement.
No, page 22. So page 23 starts from 24.
23.
Yes, starts from 24.
This was made for how many months? Where is this written?
Lordship, that can be, that is at page 22.
22?
Yes. 2, 3.
Hmm?
Fourth line and fifth line.
This
From-
was after the agreement.
Yes, Lordship. From the date of joining or date of signing, the terms of contractual engagement, which is later up to 33/2011.
To 33, 2011 it was made.
Yes.
And this contract was dated? It is 30/11 only.
That is
31st
31
of December
No, that is 31/2010.
2010. So this was 31/12/2010.
Yes.
So for 3 months.
Yes.
Thereafter, it was extended without any formal agreement.
Where are the extension orders?
My lord, without any extension orders, my lordship, I was given job like casual employee, my lordship. Condition. More than 10 years continuously, I have been doing job.
Okay. Okay, I'll
Or
examine
they
this and
finished
pass orders.
the contractual employee, but it took the form of casual employee.
No.
Daily,
No, it was a contractual, that agreement was there.
but that was extended time. They have also paid me salary also.
Lordship, they are not here claiming for regularization or any parity.
Okay, I'll consider the judgments and all, and pass orders. Disposed of.
Apologies.
Highly.
Chamber did you? I'll have to see the judgments that you have placed. Oh, Nambu did you? Heard Mr. 1 second, 1 minute, was Mr. SB Loskor. Learned counsel for the petitioner and Mr.
A.K. Ghosh on behalf of Mr. K. Kumar.
A.K. Ghosh on behalf of Mr.
K. Kumar.
K. Kumar, Kumud Kumar.
And
Okay. ठीक है.
Lordship, my surname may be reflected properly. Ghose.
G-H-O-S-E, Ghosh.
Ghosh.
S, not
Not A.
F-H. Okay.
May please.
So what happened to the mediation?
Mediation, we have not agreed for mediation.
No, there is. There is an order.
No, it has been. Directed to be listed for admission agreement.
Acha. Unwilling and unagreeable to refer. That being so, released the matter for admission after 2 weeks. Okay, fine. They did not agree.
Yes, ma'am.
Yes. Pleadings are saying,
Pleadings are complete, my lord. My lord will fix for hearing, my lord.
not today.
Not today, my lord, because I'll have to get to, they have contradicted. We relied upon two judgments of this court. We said that we passed an order basing on one CR, civil rule 93. It's a order of 93 of this honorable.
So you want to go through those?
My lord, they have contradicted. Now I have to get this rule. So yesterday I tried in the system, but it's not showing, my lord. Maybe I'll have to get a certified copy now.
I have annexed the order, Lordship, in my.
Okay, let them go through. We will take it up on some other day, hearing day. Today is a motion day.
Yes.
2017 retired, Lordship. Let them pay the provisional penalty in the Lordship.
Okay, we will hear it on Thursday.
My lord,
Thursday.
Thursday, Lordship.
As prayed for by Mr. R. Dhar, Learned Standing Counsel for
handloom and textile.
Elementary Education.
No, my lord, handloom and textile, man. Handloom and textile.
Handloom and Textile. List this matter on 4th of June. Coming Thursday.
My lord.
Please, Lordship.
My lord, more one time may be given, my lord. 1 week time may be given, my lord, for instruction.
And the petitioner side is not there? 24. FL, Oscar, Baudelaire, so many of them are there. None appears on call for the petitioner. However, Miss
DS Neog correspondent number 2 and 5.
is DS Neog,
Yes, sir.
Learned Standing Counsel for Irrigation
Yes, madam.
Department.
2 and 5.
Prays for a week's time to file her affidavit in opposition. Prayer is allowed. List this matter on
My lord,
15th of June.
clear, please.
Acha, Miss P.K. Bora, D. Bora, Learned Counsel, appears for respond number 3. Mr. Dhar, you are there? No.
Yes, my lord. PW.
Oh, Mr. Dhar for PWD. Mr. Mohanto, you are there for which matter? Mr. Mohanto, you are there for which matter? 26. 26. Oh, it will reach soon. Just a minute. Yes, Mr. Chauhan.
Well, the
Affidavit's not filed?
Not file, Lordship. We have to file.
Okay.
the second read petition, my lord, earlier read petition direction was passed, my lord. Directing the Director of Education, my lord, elementary.
Okay, let them file their affidavit. I'll give you a reasonable time.
Let them file, my lord, but urgency is there because my lord is not getting salary, my lord. Long time, my lord.
You are otherwise a regular employee.
Yes, regular. My service was regularized, my service was confirmed also.
Then your salary is not paid.
Yes, not paid.
This
You-
is the second round of litigation. Lordship, may kindly peruse the speaking order.
Of the first round.
Page number 58.
58.
In the earlier litigation, there is a direction to pass a region order by the department. The department has passed the region order citing the grounds, Lordship. This page number 58. So our affidavit is required, Lordship.
So his name was not there in the permission, retention list.
CEO could not produce document.
Hmm.
It is the finding.
Even the petitioner himself also.
My lord,
Okay, we will hear it after they file the affidavit. Or affidavits are not required.
Required, otherwise.
Otherwise, whether this order is in terms with the High Court's order,
Not-
that will have to be seen.
in terms of High Court.
In terms of the order, the hearing was conducted, petitioner also appeared.
Where is the High Court's order? Just show me.
My list. My lord, the debate portion, my lord. The page, my lord, 51. Para 4 with the operative portion.
But otherwise, here in the High Court's order, it is said that the services was confirmed.
Right, my lord, documents are there, my lord.
You see the, I have not gone through the entire order, but the operative portion. Hmm.
Para 4, yes.
See the last paragraph.
Yes.
From the case record, it is seen that the petitioner was confirmed in his service by order dated 9/8. Under such circumstances, the court is of the considered view that the petition can be disposed of by directing respondent authorities to verify the claims of the petitioner for grant of area scale of pay only pursuant to the order by which his service was confirmed, namely so and so.
My lord, if you.
In 9/8 from 9/8/2011, his claims has to be seen for area salary.
Lordship.
Otherwise, fact remains his service was confirmed. Now you have given a different order showing that his name was not there in the retention list.
Lordship.
So as if his service was not regularized, not confirmed, nothing. Confirmation,
Yes.
regularization is a two different thing. It's okay. But then service was confirmed.
My lord.
Let me find detailed affidavit paragraph wise, Lordship. Here affidavit is required, Lordship.
This doesn't seem to be in consonance with the High Court's order. The order, the impugned order.
My lord, their officer failed to produce document, my lord. Documents or, my lord, I have included all the documents. How, my lord, they failed to produce document?
Mr. Sharma, it can be disposed of at this stage.
Lordship, perhaps our affidavit is required, Lordship. Let me file the affidavit, Lordship.
My lord,
What will you say in the affidavit? These
30.
are the things he will say. His
No, Lordship.
name was not found in the retention list.
We will controvert paragraph wise, Lordship. We will controvert paragraph wise. It is required, Lordship.
The regulation order, my lord, page 31, kindly see, my lord. My lord, this was the regular right.
Okay, we'll give
Regular-
him 1 week's time. 1 week's time would be enough. You
10
please.
days, 10 days required, Lordship.
Okay, heard Mr. S. Chauhan, learned counsel for the petitioner, and Mr. P.N. Sharma, learned Kika, standing counsel for elementary education department. Mr. Sharma submits that he will file a detailed affidavit bringing into record as to how the case of the petitioner was rejected. Prayer is allowed. List this matter on 10 days time, right?
Lordship.
List this matter on 12th of June,
Lordship.
on which date the case will be taken up for final disposal. Mahanta, you are for the respondent, yes?
26 and 27 are similar matter, Lordship. Here, grievance of the petitioner has been sorted out, Lordship. And petitioner was allowed to appear in the examination, Lordship. Accordingly, he appeared, Lordship.
What examination?
APSC, conducted by APSC examination. APSC, Lordship, with regard to Junior Legislative Council, Lordship, legal assistant and under secretary to the government of Assam Judicial Department. Lordship, in this case, what has happened, Lordship? Pursuant to an advertisement, Lordship, that petitioner.
That case is ready for hearing.
Lordship,
Yes, Mr. Mahanta
I
has
mean, no,
appeared
we
before.
have filed our affidavit, my lord, actually what happened, my lord, they are rejected on the ground that, my lord, they have not produced the, produced the COP.
Hmm.
That certificate of practice, that is not been produced, my lord, on that ground. they were rejected.
Certificate of practice you want the,
That was, yes, that was, he has not been produced, my lord, but after filing this much, he was allowed to sit in the appearance subject to production of the COP. So he produced, my lord, not only him, my lord, those who are on the same ground rejected, my lord, all are allowed to, my lord, participate.
Hmm.
And in fact, my lord, some of them are interviewers also going on now. Probably like at the end of this month, my lord, also. So all that those.
so your grievance has been rather looked into.
Lordship, better now.
Oh, so you are not pressing this petition anymore, or what?
Lordship, a small observation is required, Lordship, that his certificate of that his experience should be counted from the date of enrollment. That must.
That is always there. It can be, my lord. If there is
That
doubt.
will be done from the date of enrollment. From the date of enrollment, you may not have practiced. Certificate of practice is required.
And Lordship, from the date of enrollment, as discussed by the Honorable Supreme Court of India in All India Judges Association case, Lordship, I have the case.
Acha, there it is said that from the date of enrollment, it has to be considered. Okay, Mr. Mahanta, you can consider. Right. It can be disposed of. Okay. Heard, Mr. You're Mr. D. Gogoi? No.
P. Bordeloi.
P. Bordeloi. P. Bordeloi, Learned Counsel for the petitioner, and Mr. T.J. Mohanta, Learned Senior Counsel, assisted by
P. Sharma.
P. Sharma, Learned Counsel for the
1, 2, and 3.
1, 2, and 3. By this application filed under Article 226 of the Constitution of India. Acha, give me that second judge's case or what?
Lordship.
226 of the Constitution of India, the petitioner has prayed.
Para 85 and 88.
Has prayed for a writ in the nature of certiorari for setting aside, quashing the impugned list of rejection for the impugned list of rejection for the post of junior legislative counsel and under secretary. Acha, okay. For quashing of the impugned list dated 1/6/2024.
Lordship.
No, that is advertisement.
Lordship, rejection list is at page, Lordship,
41.
41. Lordship.
190.
1/9/2025.
41.
Page 14.
3 rejection list of 3 different posts, Lordship.
But same ground, no?
This you have pasted it or what? Acha, where is that rejection list? 1/11/24.
1/11.
No.
1/9/25.
Where is that? 1/9/25? 1/9/25. Huh?
Page 40, my lord.
Dated 1/9/25, by which the petitioners were rejected.
On the ground that none.
Rejected to appear in the examinations.
No, he's
Rejected to
criticized
appear in the examinations for the post of Junior Legislative Counsel and Under Secretary to the Government of Assam Legislative Department, as well as to the post of Legal Assistant to the Legal Remembrancer and Under Secretary to the Government of Assam Judicial Department, same, huh? And Under Secretary to the Government of Assam.
Lordship. Judicial Department.
Full stop. The petitioner has also prayed for a direction to the respondent authorities to select the petitioners. To consider the petitioners as duly qualified and selected for interview pursuant to the advertisement dated 1/6/2024 for the said post. It is the case of the petitioner that it is one petitioner, there is only one petitioner. It is the case of the petitioner that he is an advocate by he was an advocate. He is an advocate practicing before the Honorable Gauhati High Court as well as other courts since the year 2020. And that he has cleared the All India Bar examination on 30/3/2021 and was issued a certificate of practice to that effect. Full stop. He has also stated that he has been practicing independently since 1/2/2024. Full stop. Para. It is the further case of the petitioner that APSC had issued an advertisement on 1/6/2024 inviting applications from advocates enrolled under the Advocates Act of 1961 with the minimum experience of 3 years of practice for the post of Junior Legislative Counsel, and Under Secretary to the Government of Assam, comma, post of Legal Assistant to the Legal Remembrancer, and Under Secretary to the Government of Assam, Judicial Department, and a post of Secretary, Under Secretary to the Government of Assam, Judicial Department, as mentioned above. The petitioner states that being qualified, he applied for the post advertised as above, and that the Deputy Secretary APSC, by notification dated 1/9/2025, had published the dates for interview for the 3 advertised posts. And that with the said notification, the Deputy Secretary APSC had released 2 lists or 3 lists for the said post, POSTS, post, showing the rejected candidates. And the ground mentioned in the said list was that no certificate of practice was submitted by the petitioner. However, the learned counsel for the petitioner submits that the petitioner had his practice certificate of practice as stated above, and that on representation being made, or what? They allowed you to appear in the examination.
Being aggrieved, the petitioner approached this honorable court of filing this writ petition.
By way of, because of the interim order, they were allowed to, my lord.
Oh, by interim order.
Interim order. And my lord, in the meantime, my lord, I filed an affidavit and other candidate also, my lord, that is a one circular notification is there, that will be your lordship kindly mention that. Page 72 of my.
Okay, likha. Aggrieved by their non-inclusion in the said list, aggrieved by their rejection, aggrieved by the rejection of their candidature in pursuance as reflected in the said list, the petitioner approached his court by filing the instant writ petition. Where is the interim order?
8/9/2025, Lord.
Full stop. This court, by order dated 8/9/2024,
5.
this court had allowed
Paragraph 13, Lord.
Huh.
10th March.
This court, by way of an interim order, directed that the petitioner be allowed to appear in the interview viva voce scheduled on
9, 10, and
to appear provisionally, Bridia, to appear provisionally. In the interview viva voce scheduled on 9/9/2025, 10/9/2025, and 11/9/2025. Full stop. In view of the said interim order, the petitioners appeared in the interview viva voce held by the department and had submitted. You have not submitted it.
In the meantime, my lord, yes, he was allowed to, yes, he submitted, but in the meantime, my lord, one notification published by the APSC that page 72.
72.
Page 70.
His results were kept in seal cover.
No, my still going on.
Oh, still going.
going.
Acha, 72 years.
Page 72, my lord, that is a notification published by the IPSC, my lord.
This was on 10th of March, after
Yes.
the exams.
No, exam, my lord, again, my lord, reschedule.
Oh,
Examination-
rescheduled. Oh, that was not held in September.
That was held. Thereafter, my lord, similarly seated other candidates also allowed to,
Oh.
by your lordship, kindly everything will be clear by,
Acha, acha,
if
acha.
your lordship kindly go through this, that.
This was in 2026. And you appeared in 9, 9, 10, 9 and all that.
My lord.
10, 11.
Hmm.
So yeah, here, my lord,
Accordingly, the petitioners appeared. But on which date? 9, 10 and 11.
Lordship,
9, 10 and 11 of September
2025, Lordship.
2025. Acha, the COP was directed to be placed on 18/3,
my lord,
right?
my lord. By this notification, my lord, in respect of the other, so he also, yes, he is also
So
clear.
and so. Thereafter, on 10th of March 2026, the Deputy Secretary to the APSC issued a notification
There is an end.
notifying that the candidates who were previously rejected on the ground of non-submission of certificate of practice were directed to submit the copies
Of the full
of certain documents for scrutiny on 18/3/2026,
including COP,
including COP,
my lord.
including the certificate of practice. The list of documents were mentioned in the said notification. And then the petitioner had also submitted.
My lord.
Lordship, may I submit one thing? I have submitted already on 9/9/2025.
Already submitted, but eventually it was regulated.
এই তাতে যে মই কৈছিলো নিলিখিলা নেকি? And the petitioner had submitted his COP.
Ma'am, নাই, কিন্তু
After viva voce or before viva voce?
Before.
Before viva voce. The deputy beleg line ta koi dibo para. The petitioner had submitted the COP before the interview held on 9th and on subsequent dates.
9/9/2025.
9/9/2025 and on subsequent dates. Upot তেতিয়া সেই petitioner কৰা এই notification আদুপত. So what happened after that? Now the students will also submit their COP and other particulars.
other candidate.
Now what is required? He has given you and the viva voce is on.
Lordship.
With
our
respect to
not
other-
completed, Lordship.
Now his rejection he has gone. Because
Rejection-
rejection that he was not submitted the COP, that's why
That is gone.
now that is gone. So my lord, that
Now you will be considered as per your merit.
my lord,
Right. What were your other prayers? To allow them to continue to sit, so you were allowed to sit.
Lordship, we were allowed to see, we appeared on the examination.
Hmm. So what prayers are left?
The only observation that his
Practice to be considered.
from the date of enrollment. That-
no, if there is some rider, my lord, your lord
Huh.
kindly see that
That's-
annulment certificate was issued after passing the LLB.
Like we have.
Within 2 years, he has to pass bar council exam, my lord. That is COP
No,
will get.
he had
so
passed.
He has passed. Whether it is, if he did within what 2 years, then no problem.
No, he had given his pleadings are there.
Yes.
So when was your enrollment date?
Lordship, kindly peruse page
2020, right? No,
10/1/2020, Lordship, page 17.
page
17 of the repetition.
17.
17.
I'll take that. I'll go to that. So as far as the grievance of the petitioner is concerned, as far as the grievance of the petitioner, as far as it is concerned, as far as the grievance of the petitioner, that he was rejected on the ground of non-submission of certificate of practice, the same has been meted out in the facts of the instant case. As it has been seen above, as stated above, that the petitioner was allowed to appear in his viva voce and was allowed to submit his certificate of practice. The petitioner for the counsel for the petitioner submits that the certificate, that his practice before the courts should be considered from the date of his enrollment. And for that, he places, page number?
Page number 17, Lordship.
17.
That is certificate of enrollment.
Page number 17 is the?
Annex right for the Lordship.
Wait. This is his enrollment 2020.
Lordship, 10 January 2020.
Places the enrollment certificate, which shows that he was enrolled as a member, as what you say, as a
Advocate, Lord.
as an advocate under the Bar Council of Assam, Nagaland, Mizoram, Arunachal Pradesh and Sikkim on 10th of January 2020.
And also cleared the bar council exam within 2 years.
And it is also placed and submitted that petitioner has cleared his All India Bar examination within the mandatory period of 2 years. That is on 30/3/2021.
Correct.
It is also stated, full stop, it is also stated that petitioner was issued the certificate of practice to that effect. The learned counsel for the petitioner has also placed a judgment of the Honorable Supreme Court in All India Judges Association and others. All India Judges Association and others versus Union of India, reported in. This is the fourth judge's case or what? 2025.
Actually, my lord, till now it is as it is, my lord. Even again, it was probably
Acha.
forwarded to.
Acha, reported in.
2025.
SSC, it's not reported. What AIR? INSC or SCC online? Acha, tell me that. It's okay, you can just tell me. 2025 SCC online. These citations we hardly know. SCC online. Yes, 2025 SCC online SC 1184. Where is the relevant paragraph?
86, Lord.
88.
86, 87.
86.
87 also.
By which the Honorable Apex Court had held
That leaves us,
this is which provisional registration is given.
Lordship.
That is enrollment.
Huh? That is enrollment, provisional registration. Wherein the Honorable Supreme Court has held that experience of an advocate should be counted from the date on which provisional registration has been granted to a candidate. In view of the same, the learned counsel for the petitioner submits that the petitioner's practice should be counted from the date of enrollment. Mr. T.J. Mohanta, learned senior counsel, submits that the same will be considered by the authorities concerned. In view of the same, this court directs that the APSC, that the Assam Public Service Commission would consider the case of the petitioner by reckoning his practice from the date of enrollment, if not found otherwise ineligible. Enrollment for the post of her, for the post of,
He applied.
for the post that he had applied, for the post that he has applied, if not found ineligible for other reasons.
Then next one is also same.
Petition is disposed of. What is the next one?
Next one, same.
He depends on.
No, there will be some difference.
Date
Date of enrollment and this.
Date of enrollment.
Oh, the petitioner is different.
Petitioner is
Petitioner is different.
same ground of rejection.
Same fact and
Same ground of rejection, but then তুমি হেৰি পাবা এটা date to বেলেগ হ'ব নহয়
Date of enrollment would be different, Lordship.
date of enrollment বেলেগ হ'ব এটা practice time বেলেগ হ'ব
POP
এই
is
প্ৰথম number 2 paragraph টো পাই যাব number 2 paragraph টো পাই যাব rest will be advertisement and all will be same
all same.
Are
Rejection order also same.
rejection is also same এইবোৰ সব same হ'ব খালি number 2 paragraph টো change হ'ব
But,
you show me I'll
but interim order would be different, Lordship.
that interim order is what
That is 9/9/2025, Lordship.
not 10 and 11
No, interim order, Lordship.
Interim.
oh acha interim order date to বেলেগ হ'ব yes
Interim order of this one will go.
same interview 9 10 11
9/10/11.
interim order date to বেলেগ হ'ব that will be order dated 9/9/2025 huh?
He'll check. He'll check.
and no other difference right
No.
okay I'll read it and I'll find it
Lordship.
okay both the matters are
Both
disposed of
Oblige, your Lordship.
yes okay Mr.
Fourth order, my lord.
what
Nothing
was
as
this
such.
what is
Yes.
this I about
For my lord, granting us some further time to comply with the court's order.
Acha.
Here, in fact, the writ petitioner herein, my lord. He
you
approached.
have filed the IA
Yes,
acha
on behalf of the finance department. Lordship may turn to page 17 for a moment.
17
17, Annex B.
yes
Regarding granting of minimum of pay scale instead of regularization.
mm.
Now, Lordship will see the relevant part,
Mm.
page 20,
Mm.
para 8.
Mm.
Accordingly, in the light of the observations made by this court in para 20 to 23 of the case of Upendas, this court is inclined to direct that the same protection and benefit of scale of pay, which is presently in force in terms of notification dated 3/10/2019, shall be extended to the petitioner along with other master workers, workers employees, and similarly placed employees working since last more than 10 years with effect from 1/8/2017. We hope and trust that the concerned respondent authorities shall do the needful so as to extend the benefit of minimum pay scale to the petitioner with effect from 1/8/2017 along with the arrear pay, etc., preferably within a period of 4 months from the date of service of certified copy of this order to the Director of Social Welfare, Assam. Well, this order was passed on 24/2/2021. Now, my lord, for non-compliance of this particular order, no contempt was preferred.
no contempt
No contempt. But he instituted a writ petition again in 2024, reiterating the same prayer that these orders should be complied. Considering the, my lord, status of the petitioner being a master worker, this honorable court directed, issued notice to all the respondents. Now, my lord, thereafter, the honorable court directed us, that is the finance department, to consider, my lord, and my lord, comply with the court's order. Time was granted, my lord. Now, my lord, in this process,
Page
Lordship will see.
Page 16.
Yes, now, my lord, everything has been verified. Lordship will see page 43 for a moment
43 of the IA
of the IA, my lord. There is a chart.
yes huh
Here, the name of the petitioner appears as serial number 14.
Khoghan Saikia
Yes, and Lordship will see at the top, consolidated statement of government, grade 4 and grade 3 employees prior to AFR BM Act, periods 1/9/2005. These are the persons who will be now entitled for
minimum scale.
minimum of the pay scale, my lord.
Huh.
Here, my lord, on the last
What is
occasion,
prior to FRBM period?
that is, my lord, Assam Fiscal Responsibility and Budget Management Act.
Oh, acha.
There is a cutoff date that has been prescribed, but he comes within that, my lord. He is eligible. Now, my lord, on the last occasion when the matter came up, this instruction was furnished before the honorable court.
Now, by this IA, you want some further time.
Some further time, my lord.
comply
Maybe
with the order.
By end of this month, probably it all will be done. That's what.
The order was of 21.
No, my lord, after, my lord, this honorable court directed us, we sought for proposal from the concerned department. They have not submitted.
I mean, you are dealing with not few candidates,
Yes,
but
there are lots of.
so many master
Order
roll
notice on it,
workers.
Yes, some left out, some, my lord, where directions are there, all has been, my lord, clubbed together.
And
Hmm.
probably it will have to be placed before the cabinet for the final note. And my lord,
You want a cabinet decision on
well,
for
because
this?
the other cases are also pending, my lord, where my lord proposals have come from the department directly.
That the name of the petitioner Kogan Soke was submitted by the so-and-so and is included in the list prepared after receipt of additional information which is under process. Final decision.
Yes, that my
Now
lord,
here you are talking of only one.
no, my lord, what has happened is, my lord, when
Hmm.
we place this particular instruction, that last line lordship has read, my lord, the final decision.
Hmm.
Honorable court was bit aggrieved by this line because, my lord, there is already a mandamus, my lord, of this honorable court. So there is no question of us reconsidering it from our side.
Hmm.
That was, my lord, not properly drafted, but it is under consideration. We have directly placed him along with the, my lord, other candidates who are eligible. And by end of this month, probably it will be done. So I pray Lordship will, before the vacation, Lordship will fix a date. And
Yes, Mr.
we are working on it. Nothing to do, my lord. We are not
Otherwise
against the
complying,
petition.
my lord, if they are.
By the
free-
end of this month, they have said.
Yes, yes, Lordship will fix that date.
Let it be, my lord, because the vacations will come.
Huh.
She will grant us to comply it by 30th, my lord. Immediately on the reopening, we will place the compliance.
No, July,
Okay.
it is not last one.
No, nine,
Okay, I'll fix it on 24th, 23rd,
Yes.
whatever date suits you, Mr. Chetty.
No, Lordship, can it be on 13th of July? We will comply it by.
After vacation.
Yes, but before that we will comply. Lordship will give the date. By 30th of June,
Huh.
we will comply it.
Hmm.
And on reopening, we will place the compliance. By that time, we'll get the benefit.
No, let us take a chance
Hmm.
before July.
Then 26th,
Then-
my lord. 26th, my lord.
Last ever, last day
My
of the
lord,
month.
cabinet has been formed. It takes some time. Otherwise, my lord, honestly, we
No,
have.
on that day, I will not, on that day also, I will not object, but let it be on, before the.
Then, my lord, 25th.
25th,
I will
okay.
not object if it is, going to be complied.
Only thing is, my lord, there was a direction that, my lord, if it is not complied with before the last day, personal appearance is there, my lord. We are working on it. That's why we have
No,
filed
it
I.
will not be, because.
Probably it
already-
will not hamper the petitioner, my lord. We have sworn an affidavit. Lordship will kindly have a look at para.
It's okay, it's
Yes.
okay, I'll give you time. Heard Mr.
12 and
Chetri.
13, ma'am.
12 and 13
Yes.
of your IA.
Of the IA, Lordship, we have made the categorical statement that he has been put in the list of eligible candidates and we are working on it. 12, man. 12, my lord, last two lines. And in fact, 3 lines and similarly placed, so which includes the present petition. Because of that instruction, my lord, this was not properly drafted, my lord,
Hmm. Okay, heard Mr. Chetri, learned counsel for the petitioner, and Mr. B. Gogoi, learned standing counsel for finance department.
I appear as additional element here.
The instant I is filed for extension of time.
My lord.
Where is that prayer? For extension of time to, this is what, writ petition for modification, alteration, recalling?
The
Yes.
recalling, my lord, to the extent that, my lord, that date will be extended, my lord.
What is this order, 7
Yes.
for 26?
Lordship will have a look at that.
Order in the writ petition?
Order in the petition, that is at page number 15. 14 it starts, my lord.
15.
14 it starts.
The relevant.
Then, my lord, relevant, Lordship will see the paragraphs, my lord, 4, 5 and 6. 4, 5, 6 and 7, yes, 4,
Page
paragraphs.
16.
Page 16, my lord.
Oh, it was honored before 11/5.
No, before 15/5/2026, last para 8.
Acha.
In fact, my lord, before this date, we have filed the IA. On that day, my lord, the concerned court was not there, so my lord, it got delayed. And on 2 occasions.
Acha, what happened? This matter didn't come up after
My lord,
15/5?
yes, on 15/5, my lord, the court was adjourned for some reason, my lord, the court could not resume. Thereafter, my lord, the matter was listed before this honorable court. It was in the end of the list.
Oh, didn't reach.
Could not be, yes, did not reach. I prayed for a next date. On that day, my learned friend had a problem. So it is
Acha,
today.
acha,
So I updated it, man.
Okay, Mr. B. Gogoi, learned Koluna. By this interlocutory application, the petitioner has prayed for modification, alteration, and recalling of the order dated 7/4/2026, passed by this court, by which it was directed that the petitioner should comply with that the respondents should comply with the directions passed by this court by order dated 24/2/2021 on or before 11/5/2026. It was further directed that if the compliance could not be done within the said date, the personal appearance would be directed for of the Commissioner and Secretary, Department of Finance, as well as the Secretary of Government of Assam, Department of Secretary to the Government of Assam, Department of Women and Child Development, Assam. It is stated by Mr. B. Gogoi that the order dated 24/2/2021, passed by this court, was looked into, and every endeavor was made to comply with the same within the stipulated time. But since there are a number of master role workers, work charge employees working in different departments all over the state,
Yes, ma'am. In
all
various-
over the state, the exercise had taken some time. And he assures the court that by the end of this month, the entire exercise will be finalized, and that the relief sought by the petitioner and similarly situated employees for getting minimum scale of pay would be given to them as per the order stated above. In view of the said assurance, this court, although reluctantly, but allows some time to the respondents to comply with the said order and allow the relief to the petitioners and similarly situated employees. List this matter on 25th of June, by which date Mr. Gogoi will place the instructions.
Madam.
This application has been filed by the finance department, madam, that I have accepted, madam. But here direction was also there, the women and child department secretary.
Women and Child.
They are not filing any affidavit to that regard. At least they should also come forward by filing. the IA.
Ultimately, proposal is pending with the finance now. ma'am.
Women
So
and Child,
when
what
give
will
that
they do?
approval, Yes.
I'm not saying, just I'm pointing.
Yes, yes. And their affidavit will do. They are the master to pay.
Only thing, my lord, lordship is in the last line stated that, my lord, petitioner along with the similar situated persons, pursuant to court's order. All are not under, my lord, some order of the.
Covered by the court's order, right?
No, all are not covered by the court order. my
And,
lord. Only
I'll
limited
say
to the
covered by
petition-
the court's order.
Yes, that may be.
Similarly situated employees covered by the court's order.
No, not covered by, my lord. Some cases are there where there is no court's order, but
Acha.
despite that, we are, my lord,
Okay,
processing.
good.
So that
Pursuant to
will-
the court's
lordship
order.
will modify it, my lord.
Pursuant to the court's order. In view of the same, they said order dated
Yes.
7/4/2026 is modified to the extent mentioned above. The IA is disposed of, right? The IA is
Yes,
disposed of.
Yes.
And the matter may be fixed on 25th.
List this matter, list this writ petition diva. In view of the order passed in the IA, list this matter on 25th of June. Or I'll keep it pending.
No, we have prayed for modification. Lordship has given the extension, my lord, till 25th.
Okay.
So in the writ petition, Lordship will pass it.
Will
that
be in
my
the main writ petition.
That order has to be, otherwise how will we know?
Yes, yes.
That order, subsequent order will be in the writ petition.
Hey to Koiriba,
List
the
on-
same you type it here also. As in view of the order passed in the IA, which is quoted herein below. List this matter on 25th of June. It will
Obliged.
be in the writ also.
Obliged.
I disposed of, इसमें दो बार आ जाएगा. 30? एक मिनट बुद्धक दीजिए. Yes, 31, yes. What happened in 31?
May I please,
Hmm?
Lordship?
Yes.
Lordship, matter pertains to promotion and
Promotion and
transfer.
whatever it is,
Transfer.
you are required to file affidavit.
Lordship, 4 weeks' time may be granted. So
You are
for all the respondent.
all the respondents.
Sorry.
Mr. S.S. Roy was the CGC.
Yes, Lordship.
CGC is the party here.
Yes, Lordship.
Okay. Miss
P. Rabha on behalf of Miss A. Gayan.
P. Rabha on behalf of Miss A. Gayon, learned CGC, makes a prayer that she be allowed some time to file the response. Prayer is allowed. List this matter on 24th of June.
That's it. Obliged.
In this matter, my lord, we have filed our affidavit. on-
You have.
Yes, 15/5. We have
Uh-huh.
on 15th of the
Hmm.
last month, my lord, filed.
So any other affidavits are required?
No, Lordship.
So this can be taken up?
Yes, Lord.
Okay.
The petitioner has challenged an order dated.
My lord, they
18/11.
haven't filed any reply to this.
They
No,
will
the
not.
reply is not required.
Not-
Lordship. The termination order itself is valid in law.
Hmm. Even your affidavit is not required, I believe. Right.
Yes.
Okay.
Lordship, the petitioner has challenged an order dated 18/11/2023, 25, whereby he was terminated from service on the ground of misconduct.
Hmm. He's a
He was a probationer.
casual
Probationer.
probationer,
A regular
a
employee, but
probationer.
a probationer. but in-
sent on probation.
Yes.
Okay. Where is that impugn order?
At page 34.
34.
The third para,
Hmm.
may I read, Lordship?
Hmm.
And whereas in compliance with the order dated 26/9/2025 of the Honorable Guwahati High Court passed in the writ petition filed by Sri Deepak Thapa, a departmental inquiry committee was constituted under this division to review his suspension and to conduct departmental proceeding. And whereas
Deepak Thapa is the petitioner here?
the petitioner here.
Hmm.
Before that,
And
I'll
where
just-
is the said committee?
And whereas the said committee examined the written statement of defense submitted by Sri Deepak Thapa, the relevant police documents, including the charge sheet, received from the superintendent of police Hamden and other connected records, and upon due consideration, concluded that Sri Deepak Thapa was under probation at the time of his arrest. He has been named as an accused in the above mentioned criminal case. And whereas the inquiry committee, after completing the proceedings as per rules, has held Sri Deepak Thapa guilty of misconduct and recommended that he be dismissed from government service.
Hmm.
So before that, I'll just take.
So
a
he
note.
was arrested. What happened to the criminal case?
That is pending trial before the learned JMFC at
Hmm.
Hamden. The charges are yet to be framed.
Hmm. What is the offense? Criminal breach of trust or something? What?
Lordship, probably 468, that your lordship will find at page 30.
Hmm.
It's a letter issued by the executive engineer PWD Tinsukia District Territorial Building Division,
Hmm.
letter dated 4/10/2025, whereby the petitioner was asked to submit his written justification and appearance before inquiry committee in connection with Hamden PS case number 14/2023.
Hmm.
Your lordship will find
So 419 cheating, forgery, all this.
498, 468, 471, 120B.
Hmm.
The petitioner was posted in Tinsukia. The case was registered in Hamden
So he was on a probation for a period of 2 years or something
for 2 years.
after appointment?
Yes. Your lordship may kindly see the letter dated 4/10/2025, the last para,
Mm-hmm.
letter dated page number 30.
30. No, what happened after this? Just a second, wait.
My lord,
When was he appointed? 2023 something?
In that case, I'll take your lordship to page 17.
Dismissed from government
On
service.
22/5/2023, page number 17, lordship.
Yes, page number?
17, 17.
Yes, 17.
On 22/5/2023,
Hmm.
the petitioner was appointed. as MTS, multitasking staff,
Hmm.
Chokidar. At serial number 2, your lordship will find the name
Hmm.
of the petitioner.
Yes.
Deepak Thapa,
He was appointed as a chowkidar.
Chokidar.
Hmm.
Thereafter,
Under the Department of what?
PWD.
PWD, yes. Hmm.
My lord, may I
At
suggest
phase-
one thing? Here record will be necessary, my lord. This is the dismissal from service. So my lord, this way we cannot do a hearing, my lord. Because unless I bring the record, my lord, if I have to go. through the
Records are necessary.
records are
in
necessary.
my humble submission, that is
My
not
lord,
necessary because it is an admitted position of the respondents in their affidavit that the no departmental proceeding was conducted because there was no experienced person to conduct the departmental proceeding. That is their stand.
But in the imping order, it is shown that department
It is
is.
shown, my lord.
No, it is just an inquiry.
Huh, inquiry only.
Yes, but not
Acha.
departmental proceeding.
My lord,
DP is required.
whether.
May I humbly place before my learned
Hmm.
friend submits.
But my lord, still
But
I
if
will.
the law is very
my
settled.
lord,
Hmm.
that let the record come, my lord, because I have to go through the record, what has gone through, my lord, because record is not before your lordship. I cannot.
Okay, let us see the records if
Because
any
without
proceeding
that,
was
Okay,
initiated.
next week, lordship, they can very well.
Okay, you bring the
Basic.
records.
My lord, it is from Tinsukia, my lord. The hard.
Lordship, he is not going to collect it from Tinsukia. Some
Hmm.
officers will.
In this
I'm very sorry to submit that.
time, you say that things are very difficult to get from far off places. Hmm? You bring it by 10th of June?
Lordship.
My lord, 10 to.
10 days I'm giving you. Heard Mr. Bora, BP Bora, right?
Arbor.
R. Bora, learned counsel for the petitioner, and Mr. R. Dhar, learned standing counsel, learned what? Government advocate.
Standing counsel.
Learned standing counsel PWD. Mr. Dhar submits that submits that the records would be necessary for adjudication of the instant case, and as such prays for getting the same. Prayer is allowed. List this matter on 10th of June. On which date Mr. Dhar will produce the records. Respondents may complete the instruction.
Lordship, we are yet to complete our instruction, Lordship. The appellate authority has filed the affidavit, but the disciplinary authority has not yet filed, Lordship.
Acha.
So I just require 2 weeks' time, Lordship. Within this, we will be filing, Lordship.
Disciplinary authorities affidavit will have to be there.
Yes, Lordship, that's what.
What do you think? Not required.
It is required, Lordship. That's why I'm just praying before your Lordship.
Okay.
Then my lord, record may be called for, my lord.
Yes, there's record also.
Records also
Yes,
you
Lordship.
place.
Only
Heard
issue, my
Mr.
lord, second marriage, my lord.
Second marriage.
Lordship.
And
marriage.
that
On the ground
for
of second
pension.
marriage, he has been dismissed from service.
Oh,
It's
acha,
missed
acha.
from service for committing second marriage.
Yes. That is allowed. That will be considered as a misconduct.
My lord,
This
this on
misconduct as
this-
per some service discipline, there is nothing, Lordship.
whether the punishment is,
Commensurate.
yes, my lord. And this on our.
Any Lordship, we will file our
division bench,
affidavit
my
and Lordship may
held that,
hear
my
the
lord,
matter.
disproportionate.
There are judgments to that
Yes.
effect.
Yes, my lord.
Marriage is a he is dismissed from service.
Yes, my lord.
Yes, from
He is a
service.
government servant.
Government
He's a
servant,
constable, my lord.
constable.
Civil service, my lord, and
Okay, let their
They has been,
affidavit
my lord,
come. I'll see your
DP
judgments
has
also.
been started, my lord, on the basis of a notification. Notification has been issued in 2024.
Hmm.
He married in 2019.
Doesn't have a retrospective effect also. Okay, she wants to file affidavit, okay? Heard Mr. R. Ali, learned counsel for the petitioner. Miss M. Bhattacharjee, learned additional senior government advocate, submits that although the appellate authority has filed the affidavit, the affidavit by the disciplinary authority is required for proper adjudication of the case, and as such has prayed for some time. Prayer is allowed. List this matter on 22nd of June,
Lordship.
Some short,
Twen-
my lord, he's.
No, no, Lordship.
15th of June, 15 days.
22nd is Lordship, is all right, Lordship.
Last week, it will be motion days.
Lordship, anyway, we have to obtain instruction, then we'll prepare, then filing, Lordship.
Okay, 17th of June,
Sure.
2026. It is also directed that Ms. Bhattacharya would place the records of the instant case. List accordingly.
Oblige, Lordship.
Yes, Mr. Bora?
Yes, in this case, they have already filed their affidavit. The lordship can take
Sim-
it to disposal.
Similar matter, in the similar matter, coordinate bench already passed order, Lordship.
So I can place that judgment also.
Oh, so it will be covered.
Yes.
What is this matter about?
It is,
Lordship, I'll just place the facts. On 5/9/2024, the Staff Protection Commission issued a notification for recruitment to the post of constable in CAPF, Central Armed Police Forces. So in terms of that notification, the petitioner applied. He was called for the physical standard test, wherein he was made to run 4 kilometers in 25 minutes. He completed them. And on a different date, he was called for detailed document verification as well as detailed medical examination. Because prior to appointment, a medical examination has to be done. So detailed medical examination was done. He was found unfit. And then, as per the rules of the respondents, once a candidate is found unfit in the detailed medical examination, he is given an option, an opportunity to file a statutory appeal before the appellate authority of the respondents for review medical examination. So in terms of that appeal, they conducted the review medical examination. In the review medical examination, he was found unfit on account of hypertension. Now, the rule prescribes, mandates the rules which is issued by the department. It says that 6D says that if a candidate is found unfit on account of hypertension, certain tests are required to be carried out. I'll just take a lordship to that rules.
So he underwent those tests?
No.
yes, Lordship, he was
Let
admitted.
me place
Ah,
the text. What tests are required at page 55, your lordship will find.
55.
Page
He
55.
was found unfit for, what do you say?
Hypertension.
Hypertension, yes.
Page
Okay.
55, your lordship will find serial number D at the top of the page.
Mm.
A review medical board may obtain opinion of concerned specialist or super specialist of government medical college. Your lordship may kindly take note of that. Government medical college and hospital in case of any doubt. Therefore, in cases of rejection in review medical examination, clinical findings should be corroborated with confirmatory test, investigations, opinion of specialist, super specialist of government hospitals, medical colleges, government approved private medical centers, whichever and wherever is applicable. Now 7E or 7, your lordship will find.
Wait, 1 second, a medical board will obtain opinion from
Of the
specialist of
government
government medical college
Yes.
and hospital.
In case of any
Any
doubt.
doubt?
Yes, yes.
Therefore, in case of, again, why two different hospitals? Therefore, in case of rejection in review medical, clinical findings should be corroborated
With
with confirmatory test,
investigations and
opinion
opinions of specialist.
super specialist of government hospitals,
Medical colleges.
colleges, government approved
Approved
private
private
medical
medical centers.
centers, whichever and wherever applicable.
Applicable.
Okay, these are corroborative materials.
Yes, these are required to be done. So in 7E, the bottom of the page, your lordship will find. For candidates who have been rejected on the ground of hypertension, tachycardia, should be admitted, hospitalized by the board before giving their final opinion regarding the candidate's fitness or otherwise. The hospitalization report should indicate whether the rise in blood pressure is of transient nature due to excitement, etc., or whether it is due to any organic disease. In all such cases, X-ray and electrocardiographic examination of heart and blood examinations like cholesterol, lipid profile, creatinine, that is serum creatinine, etc. Test should also be carried out.
Okay.
Then our contention is that, lordship, those tests are not carried out in terms of 7D, 7E, and
Those tests were not carried out.
not carried out. And the hospitalization report
Not
nowhere
done.
mentioned that whether the rise in the blood pressure is transient in nature or due to any excitement, that is not mentioned. Therefore, it is violation of their own guidelines. And 6D, that is page 55, which I have already shown to your lordship, that in case of any doubt, the government medical college and hospital opinion has to be sought for. In their affidavit, I'll just in their affidavit in opposition,
So many tests has to be undergone by the professor.
yes, they cannot simply reject.
Everyone has
because
hypertension.
It's a matter of employment.
Any doubt.
These candidates,
This-
they belong to villages.
Similar matter, coordinate bench are already passed this order.
What was the direction there?
They have to directed petitioner to file representation.
No, that's different. There are contradictory opinions by the doctors after the review medical examination.
Yes, here also.
So here I am not saying that I am not placing my argument on a report, on the basis of a report, that after review medical examination, rejection was done and I was examined by doctor and I was found fit. My contention is that
I
they
was
did not
never
follow the
examined.
guidelines.
You were never examined.
No, he was examined, but not in terms of the guidelines.
In the hospital.
Not in terms of.
Not exactly according to the guidelines.
Not according to the guidelines.
Yes,
Now I'll take your lordship to page 60.
60.
60 of the affidavit in opposition filed with the respondent.
Yes.
Para number 5, your lordship will find. The last 4 line, as per the existing policy in vogue, has your lordship found? The RME board may obtain the opinion of the concerned specialist, super specialist wherever required. So this is in terms of the 6D which I have placed, your lordship. Accordingly, the opinion of physician, medical specialist who was one of the board members was taken. The requirement is that the opinion of a specialist from a government medical college or hospital is required to be taken.
It cannot be a board member.
Yes. That is their violation, firstly. And secondly,
In case of any doubt, lordship, there is no doubt.
no, there is doubt. That is why they have taken the opinion of the
The
medical
petitioner
opinion.
was admitted in the BSF Composite Hospital, lordship, for 3 days. And his BP was continuously found, multiple reading of BP 140 by 90 first day, then 154 by 100 second day, and third 150 by 92. 3 times he was found, and 3 days he is admitted and test BP was monitored and it was found higher than required BP, lordship. Then therefore there is no doubt. A BP blood pressure patient cannot be served in border area, lordship. Their high tension is there, lordship. And as per medical guideline, that is in case of any doubt. And
No. Let me go through the guidelines again. Where is that?
Page
that is-
55.
that is
55. No, what happens is
main
first,
guideline is 2015.
first he will be undergoing a physical test. That there
Medical exam.
he was successful.
No,
Thereafter,
successful. He was
no, that physical test.
a physical state there.
Thereafter what?
First computer-based test, he qualified. Then PST, PET, physical standard test and
Physical standard test and
qualified.
qualified.
Yes. Then detailed medical examination, and on the same day, document verification is done. So after document verification,
So,
he was
Acha,
taken.
where is
physical
that
medical
physical examination? The physical, no, the third stage that you said?
The detailed medical exam.
That document they do not provide to us because since we have to file an appeal accompanying the detailed medical examination report, therefore that is not provided to us.
So
We have
detailed
provided-
medical examination report you don't have.
No, we have that. We have only. Lordship, may kindly see page 49.
So he filed an appeal and then in the appeal it is set for review.
Yeah, no, they.
No, in appeal,
they
he was
filed the appeal.
again rejected.
They filed the appeal, they conducted the review medical examination. So in the review medical examination also, they say that I was suffering from hypertension.
Hypertension.
And your lordship will kindly see page 49, the report of the detailed medical.
And this review medical board said that he is suffering from hypertension. Then review medical board may obtain, this is again, it's discretionary.
That is,
May obtain opinion of the concerned specialist or super specialist of government medical college in case of any doubt.
Yes.
So in case of any doubt that whether he is suffering from hypertension or not.
That is why I have taken to your lordship to para number 5 of the affidavit in opposition. They were in doubt and therefore they have, in accordance with the guidelines of 6D, they have taken the opinion of a medical specialist who is the member of their own board.
Who is
that
the
they
member?
cannot do it.
May I please lordship one thing? He was at the first day detailed medical examination, he was rejected. After that, when he is applied before opportunity has given to him, to.
By way of an appellate order.
Yes, Lordship. He appealed before the RME and review.
RME is
Review medical board.
Oh.
Then review medical board again examine and by admitting him in the hospital, Lordship, for 3 days. And that is, review medical board.
Acha, wait. When it is required, I'll just see, huh? In case of any doubt,
Yes.
review
Yes.
medical board will
No,
take.
no, that is reviewed office memorandum dated 31st May 21. Original medical guideline is
The first guideline
2015.
was issued on 25, 2015.
2000.
It's a
Yes,
revised guideline.
Guideline. Kindly come to my affidavit, Lordship.
Where is your original guideline?
Yes, Lordship. Page 76.
This is
General
original.
grounds for rejection.
Mm.
It is the main grounds there.
Mm.
And number, first number,
Mm.
indication of any chronic disease like tuberculosis, syphilis, or other venereal diseases, rehabilitation and type of arthritis, hypertension, etc. These are the ground for rejection. And if there is any doubt, then next office memorandum is to be applicable. If any doubt is there, then following examples, page number 55 of the writ
Yes,
petition.
I've understood.
Seven.
Yes, in
These
case
are
of
the
any
examples on
Acha, in case of any doubt, because his case was rejected on the grounds of hypertension.
hypertension.
And how did the doubt come? Where will the doubt come?
If the board, RME board is in doubt that he was a hypertension, why that doubt is not
Okay.
there.
If there
Because
is
he
any
was
doubt, then
no
they will
doubt
call for
because
a report from the specialist of the government hospital.
that if no doubt is there, then report is not required.
Not required.
Yes,
Mm.
he was admitted in for 3 days.
No,
in office.
admission part we will come later. 6D provides that if there is any doubt, then they will call for a report from the specialist. 6D, right?
6D.
Therefore, in case of rejection in review medical examination, so review medical board will obtain opinion from the doctor, and in case they also reject, review medical board rejects it.
Yeah.
In cases of rejection in review medical examination, clinical findings should be corroborated with confirmatory test. So these clinical things are not very clear. Clinical findings means the findings of the doctor from the government college, government hospital.
No, review
Clinical
medical board.
findings should be corroborated with confirmatory test investigation opinion of so and so, whichever is wherever applicable. Anyway, if there is any doubt, they will call for a report.
Yes.
Then 7 provides following examples are
Examples.
cited for guidance.
Yes.
Right,
Examples,
guidance.
these are the-
Okay. For candidates who have been rejected on ground of hypertension, should be admitted in hospital. So this doesn't talk of any doubt.
Doubt. Yes.
E doesn't talk of any doubt.
Doubt, no.
So for candidates who have been rejected on the ground of hypertension by the medical board,
Yes.
perhaps, right? By the board,
He says that if you are rejecting someone's candidature
by the board. Board.
then it has to be corroborated with confirmatory tests such as serum creatinine, lipid profile, those tests are required to be carried out.
This is in D itself.
Yes, D and it has to be read together, D and E.
Okay. Well, if it is rejected on high, then he will be admitted. In the admitted, hospitalized by the board before giving their final opinion regarding the candidate's fitness or otherwise. The hospitalization report should indicate whether the rise in for so and so, whether it is due to any organic disease, organ so and so has to be done. Okay. So, okay, these are the guidelines. But then in this case, this is not done. He was admitted, okay.
Yes.
You
doctor.
say that he was admitted.
Yes.
Then admitted, then thereafter what happened? His clinical findings was backed by test and all.
In
That
the affidavit, there is no whisper of that.
for about the test, there is not in mention in the affidavit, Lordship.
So then the guidelines are not for, what they have said is that
For hypertension is down.
opinion of the concerned specialist wherever required. Accordingly, opinion of physician who was one of the board members was taken. This is actually not done. Board member, there will be a board And board, before taking final call, will have
Cannot-
to go through all
Yes,
this.
you cannot take opinion of the same board member.
So before giving a
If-
final
if
opinion,
the board have any doubt, here in case of petitioner, the board have no any doubt because he was found hypertension. His BP record is found.
okay, in the,
There was
as far as,
at all.
as far as your contention
Yes.
goes, there was no doubt,
No
and
doubt.
they found him a patient of hypertension.
Yes.
So
Lordship.
they rejected.
Yes. Lordship.
Yes.
Yes.
And then come to E, who have been rejected on ground of so and so should be immediately hospitalized. So he,
Treatment is not required by the not RME board not required to give him treatment. Only diagnosis is required. Whether
but
it be
see,
hypertension-
should be admitted, hospitalized before giving
If
their
any
final
doubt-
opinion.
all are depends any doubt.
Admitted to measure the blood pressure, actually.
We have RME board admitted him to measure the blood pressure for 3 days, Lordship.
No, you are saying no doubt, and at the same time you are saying he is hospitalized.
He has been hospitalized to monitor his BP.
Before giving his final opinion,
Yes.
the medical board.
Yes, Lordship. Monitored and
So
found
medical board had not rejected, finally.
rejected. Rejection order is there, Lordship.
But no, according to the guidelines, before giving any final opinion, they should get him hospitalized.
These are
See, should be admitted, hospitalized by the board before giving their final opinion regarding the candidate's fitness or otherwise. The hospitalization report should indicate whether the rise in so and so, and this has to be carried out. For any suspected case of CAD is what TMT test should be conducted. But here, before rejecting, I don't know, they have also drafted it in a very clumsy way. At first point, they say the cases which have been rejected. And then again at the same breath, they say they will not give their final opinion. What is this? See, for candidates who have been rejected on the ground of hypertension, should be admitted hospitalized by the board
May I-
before giving their final opinion.
Yes, may I make the Lordship? The DME board, when it rejects a candidate, suppose a candidate is rejected on the ground of hypertension. Now it is the RME board who will examine the candidate again in terms of, since an appeal is required to be filed. Now, once a DME board found a candidate to be unfit on account of hypertension, the RME board should first admit.
RME is what?
That is
Review.
medical examination.
Huh.
That board has to admit the candidate in their own hospital, in the CRPF hospital. And then the confirmatory tests are required to be carried out. And then they have to take an opinion. If there is a doubt in case of the reports, they have to take an opinion of specialists of the concerned field from a government medical college and hospital. And then they have to finalize their opinion. My contention is that firstly, 6D, which specifically says that in case of doubt, you have to take an opinion, obtain an opinion from the specialist of the concerned hospital, concerned specialist of the government medical college and hospital, whereas in para 5 of their affidavit in opposition, they say that since the existing policy invoked, the RME board may obtain the opinion, and they obtained the opinion, and therefore there is a doubt. Since they obtained the opinion of the concerned specialist. But unfortunately, that specialist was from their own board, which they cannot do.
Yes, your affidavit shows that there was some doubt. Otherwise, why will you take opinion?
RME, that is the head of the RME board,
Acha.
Dr. Lordship. His opinion is required before.
But that is not contemplated in the guidelines. You have to get the opinion from a government doctor.
That is in case of doubt. The preliminary objection is
There is doubt. That's why you have called for the opinion.
Exactly.
Without doubt, if there is no doubt,
Where is the request of asking for an opinion?
RME board constituted by a doctors, team of doctors. There are 3 or 5 doctors are there,
Three doctors,
headed by one doctor, Lordship. That is, his opinion is necessary, Lordship.
no. His
Yes,
opinion
Lordship.
is a member of the board is not required.
Not a separate opinion.
If the board feels it doubtful, if it finds it doubtful.
If the head of the RME board think that realize that it here
Not
further-
head, RME board. The
RME
combined
board, yes,
opinion of all
Lordship,
the three
RME
doctors.
RME board conducted by 3 doctors. If they require, think that further opinion is required, then they call for some report from other civil doctors, Lordship.
Huh.
Here, no doubt, they are, because he was hypertension is there, Lordship. For 3 days, they have monitored the.
Hypertension is provided in your original rules.
Yes, Lordship. Number 1 point.
Huh?
Main
There's a grounds of rejection.
rejection, that is hypertension.
So you mean to say he was simply rejected? There was no doubt.
No, he was admitted, and I think some other trace or opinion or may be there, Lordship, in record, Lordship. I don't know. That
Acha,
is
but then things are confusing. You also making it confusion. No, no. What I can see is
one
what-
guideline is there, Lordship, detailed guideline, 6 November 2025, page 84 of our affidavit. Here, page 86, 9.15 point. There is no provision for appeal in the candidate is declared 9.15.
Yes.
Unfit in review medical examination.
No, we are not, this honorable court is not.
No,
saying-
unfit in review. That stage is yet to come. See, here he is 7E giving their final opinion regarding the candidate's fitness or otherwise.
Yes.
And all these reports. He is right in saying this E has to be read along with D. D talks of a later stage. First stage, they speak of an doubt and they will call for a report. Report means what? The government doctors has to again undergo certain test. Otherwise, how will they report? Just by seeing a person will not do. So E has to be read. So there will be an hospitalization. There will have to be some reports. On those reports, the board will take its final call.
The report must reflect that whether the rise in the blood pressure was.
Whether it's a transient or some organic disease, because one has to go through tests in order to report. And here you are saying that you have called from a report from the member of the board. But member of the board cannot give. They have already said it's doubtful or whatever.
DME detailed medical board is different. And
RME board has given the opinion.
yes, that opinion is given by the RME board, Lordship.
I don't know about DME, RME, but here it is said
Both are different. Lordship.
review medical board. He placed only review, RMB.
RME, but earlier he had to appear before detailed medical board, and detailed medical board rejected after rejection of detailed by.
Where is that detailed medical board? Where is that? Different from RME.
Yes, Lordship.
RME or RMB?
RME examination board, review examination board, RMEB.
Acha, RMEB. So where is the first stage?
First stage is
Page 49, your lordship may kindly.
49.
Yes, the review medical rejection report itself reflects the.
No, this is.
No.
No, I'm talking about the rules. Where does the rule provide that he has to be first taken to a medical board, then review? Review comes only after he files an appeal.
Yes, Lordship.
Right.
Yes.
And before that, he was declared unsuccessful by a medical board.
Yes.
In the physical test.
No.
In the examination.
In
the medical examination.
So where is that requirement, medical examination? That is by a board.
Yes.
Some
Lordship.
other board.
Yes, Lordship.
That is where?
Page 84 of my affidavit, Lordship.
84.
Yes.
Yes.
Point 4. Documents verification and detailed medical examination must be conducted strictly in accordance with the guidelines, instructions issued from ADG so-and-so from time to time. Revised uniform guidelines are issued by MHS so-and-so dated 25/2015, OM that so-and-so dated 28/4/15, and OM so-and-so dated 31/5/21 for detailed medical examination and review medical examination. The booklet containing revised uniform guidelines may be provided to each medical officer by the respective CAPs. As per the scheme, the detailed medical examination candidates shall be conducted by a single medical officer. Only one medical doctor has. Then 85. Composition of DME board.
Acha, where is that appellate power? Otherwise, in this notification, DME and RME are interchangeably used.
Yes.
See, DME/RME, recruitment centers.
No, at first he had to appear before DME.
DME, document
DME
verification and
rejected
DME.
He-
And
he-
RME. RME is the third stage.
Third stage. But it means when he was rejected by DME, then he may apply before the RME through a format. There is a format through that format he have to apply before RME. Then RME board.
So it's okay. We'll not confuse the matter anymore. But the fact remains, you had sought an opinion from the member of the board, which is not proper according to the guidelines. You do proper exercise.
Yes, Lordship, that is also similar matter. I have
Oh,
produced
acha.
all
This
the-
is what?
That is different. That is, in that particular case.
Here also
the
he.
direction to file a representation and to consider. My
Okay.
case is not to file a representation and then the respondents will decide. Here it is apparent in the face of the report that they have not followed the guidelines.
Filed a private hospital.
No, but here
report.
you see the case is different. Here the review medical board by the opinion rendered on so and so concluded that a petitioner was unfit on the
Here,
ground.
RME concluded, Lordship. Kindly say RME report,
Hmm.
Lordship, that is.
That particular petition was filed on the basis of a contrary opinion after rejection of the review medical examination. That contrary opinion was given by a government doctor when the candidature was rejected by the review medical examination board. He himself went to the.
RME
Civilian doctor.
already passed their order, Lordship. It is on
That is slightly different.
page 49 of the writ petition, Lordship. This is RME board findings, Lordship.
Where? 49?
49 page number. Unfit. Here.
This is RME.
RME board findings, Lordship. Then last note, the decision of review medical board will be final. No appeal will be entertained against the findings of the review medical.
This is the RME's report.
Yes, Lordship.
Then why did you say that you had taken a opinion from the member of the board?
Before this passing this order, Lordship, he was admitted in the composite hospital and RME board examined him. 3 doctors were examined him and found high blood pressure. Patient of high blood.
Those 3 doctors need not examine him. The hospital will do with its own doctors.
Hospital BSF composite hospital, Lordship.
The doctors work there.
Work there, Lordship.
Lordship, these are the doctors of the department. There are 3 members of the board. There are 3 doctors. They have to examine and give a final opinion. While examining a candidate in the review medical examination, the doctors or the board members, they have to seek an opinion from the if there is any doubt. Now, at para number 5 of their affidavit in opposition, clearly they say that we have sought an opinion of the medical specialist who was one of the member of the board. That cannot be done in terms of 6D, firstly. Secondly,
No, from where will they get the report? From other government hospitals?
yes. Yes.
Not the government
And therefore,
hospital.
government medical college and hospital is recorded.
Doubt. The 3 doctors.
But see, where is the question of taking an opinion from their own medical specialist if there is no doubt? They could have simply rejected it by saying that no, you are unfit on account of hypertension.
No, one note is.
My learned friend is confusing
If
the facts.
This is what?
There is an opinion is.
I'm thinking maybe I'm not able to understand what exactly the things
My
are.
learned friend has appeared in so many matters in this kind of matters. I don't understand why she is so confused.
No.
I'm very sorry to say that.
confused. Lordship, he also submitting again and again, but simply
Lordship, I have placed this order of this honorable court, repetition number 6099.
Hmm.
On a similar fact situation, this
Hmm.
honorable court has granted, has set aside
It
the order
was
of the
passed
legal-
earlier.
legal-
This order, which is submitted by the petitioner, passed it earlier.
Obviously, I
After
cannot.
But then this point was not raised in your case.
Yes, but this point was.
This
raised
point
by-
was
On
not
his
raised.
petition, he has saying about the private hospital's report, Lordship. Kindly see.
No, I am not relying on that. I am not making any
Now they're
submissions.
not relying, but.
I am not
here-
making any submissions on the private hospital.
Yes, page number 5051, Mukalmua Civil Hospital. It is
Acha,
a-
you follow the rules properly. I'll not go into all these findings
This
and all.
order will assist your lordship.
And no,
dated
enough of assistance. And I'll pass an order. What I'll do is you properly follow the rules because
Yes.
you have doubt. Otherwise, you will not have called for a report from the another doctor. If you have no doubt, simply reject his case.
Exactly.
And RME cannot give their final opinion unless the person is hospitalized and reports are sought for.
Reports may be there, Lordship, because he was hospitalized.
Huh.
Yes, hospitalized by RME board, not by own Lordship. Petitioner admitted by the
RME board.
And
And
when he was admitted and stayed there for 3 days, there may be some records or testing reports may be there, Lordship. That's why for that.
then what was the necessity to make you that to make you write that sentence? Because see, he will get him hospitalized.
Kindly-
Then thereafter he will give a final report regarding the so and so fitness. Right.
Yes.
He will undergo this test. And if after that we read D, therefore in cases of rejection, in review, clinical findings should be
That's it.
corroborated with.
Yes, Lordship.
Clinical findings should be corroborated with confirmatory test opinion of specialists, super specialists of government hospitals, medical colleges, government approved private medical centers, whichever and wherever applicable. This can also include the hospitals of the
Yes, Lordship.
army.
RME board's report, kindly see once again, Lordship.
Yes,
Until-
Mr. Bora.
Lordship.
This can be a government hospital, mean this can be a hospital of the same what? Army hospital, you said
That
that.
is why it is recorded as government medical college and hospital.
This is not government where these
Yes,
doctors are working.
It's a government. They can obtain an opinion from some another doctor, but cannot from their own board member.
No, that of course the bar is not there. If requirement is that they should get an opinion from a concerned specialist or super specialist.
Lordship, what I
Now,
cannot
if the
understand-
member of the board is a concerned specialist or super specialist, there is no bar
No,
that
I understand.
Yes.
What I could not understand that, Lordship, how could a member of the board can give two opinions? Firstly, being a member of the board, and then on a separate opinion by a specialist, being a specialist.
No, that is a.
no, that is
How
after
could that be?
after all those inquiry done.
He was rejected.
Because what I feel is E should be read first.
Yes.
Right. It was rejected on the ground of hypertension. The review board will immediately hospitalize, get the reports and all, and then give final opinion. Right.
Lordship.
Huh.
That is
Before
okay.
giving their final opinion.
Yes.
D suggests that they should get an opinion from
If any doubt.
super specialist or of the government medical college. The hospital where these doctors work, it's a government medical college.
Opposite hospital.
Yes.
A government medical college and hospital in case of any doubt. Therefore, in cases of rejection, they are very, what do I say, bizarre.
Lordship.
Therefore, in cases of rejection, in review medical board examination, clinical findings should be corroborated. So, clinical findings should be corroborated by these reports.
Therefore, the guideline nowhere says that the opinion of their own doctors can be taken into account.
No,
Therefore,
that
it
they will
says-
not say, but
Not said, but-
super specialist of the same hospital can give an opinion,
Yes,
even
Lordship.
if he's a member of the
But-
board.
But he cannot be a member of the same board.
Doctors from their hospital is the member, are the member of this board, that's it.
Maybe assisting us with that video.
Page 49, it is.
Show me from their affidavit what else they have said. Petitioner was admitted at so and so CS BSF and the petitioner was found to have multiple reading of so and so, which is more than the prescribed limit. Petitioner was declared unfit by review on so and so. However, date on the form of review was erroneously mentioned as so and so. So the review medical examination after finding found him unfit. Due to, but then he was found unfit. See, Mr. Bora, he was found unfit after a detailed examination. He was admitted. He had undergone those tests and he was found unfit. Forget about whose opinion they take. But the fact remains he was found unfit.
And in order, it is clearly mentioned, Lordship.
No, the affidavit nowhere says that they have undertaken the tests which are required to be done in terms of 7E. Firstly, the affidavit nowhere says that.
That they have undertaken. No, he was hospitalized, he was
No,
admitted.
hospitalized just for monitoring the BP for 2 days. But the tests were required to be carried out within those 2 days. Those are not carried out. I have just placed the order of this.
That is on another ground.
No, it's on same ground.
No, another ground of your ground.
Petition.
Acha, where is that? This have taken so long. Where is that?
Just the order passed by.
Guidelines for review. Okay,
Yeah.
so they will give a final report.
Order will be sent. Okay.
And the report should say whether this blood pressure, this variations in the blood pressure is of transient nature or of some organic. Those reports are not there.
Yes.
You bring some reports, detailed reports.
There is no report. That is why they could not annex it with the.
If there is no report, then I can of course take. In all such cases, X-ray, electronics, and hard blood examination should be all taken. You conduct a review examination again, as far as this petitioner is concerned. Okay. So by following these rules.
Remand back to the RME board and they.
RMA will again do it. Heard Mr. R. Bora, learned counsel for the petitioner, and Miss So-and-so Fukon, or as Borua, learned standing counsel for?
Central Government Council.
Oh, CGC, learned CGC.
For all respondents.
For all the respondents, representing all the respondents. The petitioner, by filing this petition under Article 226 of the Constitution of India, has paid for setting aside the report of the Review Medical Board dated 19/11/2025, by which the petitioner was declared as unfit to join the services of?
I'm unfit by the RME board, Lordship. After that, all document.
To join the services of?
Central Police Service Constable.
Join the post of constable in the Central Reserve Police Force, CRPF.
No, not only CRPF, Lordship. CAPS it is, Central Armed Police Force.
Central Armed Police Force, dear. That will include CRPF.
Yes, that will include.
Central Armed Police Force. Full stop. The petitioner has also prayed for a direction to the authorities to reevaluate the fitness of the petitioner in accordance with the guidelines for medical examination dated 31/5/2021. The case of the petitioner is that
Both guideline, Lordship, 2015 also mentioned.
that I'll say. The case of the petitioner is that pursuant to an advertisement dated 5/9/2024, published by the Staff Selection Commission for recruitment of constable in Central Armed Police Forces and Riflemen in Assam Rifles and some other post applied along with other candidates. Full stop. Along with other candidates. Full stop. Thereafter, the petitioner appeared in the computer-based test in which he was successful, and petitioner was also selected in the written test.
No, only computer-based test is there, Lordship. He was selected in the computer-based test.
And what about this being selected in the written test? That is the written test.
Yes, yes.
Acha, katitala etoi rakha, huh? Computer-based test wherein he came out successful. Full stop. The petitioner further states that after declaration of the select list, he appeared in the physical standard test or physical efficiency test,
Physical eligibility test.
wherein the petitioner again came out successful. Full stop. The petitioner was thereafter supposed to appear for detailed medical examination. And upon, examination, which was to be held on 15/11/2025. The documents of the, full stop. The documents of the petitioner were verified on the said day, that is on 15/11/2025. But the result of the detailed medical examination was furnished to him, by which it was declared that he was found unfit on account of hypertension. Thereafter, the petitioner filed an application for review medical examination. And on 19/11/2025, the biometrics of the petitioner was taken and his blood taken and was subsequently taken to the Narayana Hospital, Amingaon, where his blood pressure was checked and on 21/11/2025, the report of the review medical examination was furnished to the petitioner, by which he was declared as unfit. He was again declared as unfit, was again declared as unfit on account of hypertension. The learned counsel for the petitioner submits that as per the guidelines, more specifically guideline number 6, clause D, the review medical board is required to obtain opinion from specialist or super specialist of government medical college and hospital in case of any doubt with regard to the physical condition of, with regard to the medical condition of the candidate. It is further provided therein, statement he further submitted that in cases of rejection in review medical examination, clinical findings should be corroborated with tests and investigations, as well as opinion of the specialist and super specialist of government doctors or doctors from government approved private medical centers. Full stop. He further cited clause E of guideline number 7, wherein it is provided that candidates who stands rejected on ground of hypertension should be admitted in a hospital by the board. This board is review medical board, right?
Yes.
Review
Madam
medical.
Chair.
By the board before giving their final opinion. He also submits that before giving final opinion, regarding candidates' fitness, regarding candidates' fitness, he also has placed that the hospitalization report should indicate whether the rise in blood pressure is of transient nature due to excitement, etc., or due to any organic disease. And that in all cases, different tests should be carried out. Para. He submits that none of these requirements were done in case of the petitioner, conducted there. None of these requirements were conducted with the petitioner, and that the affidavit filed by respondent number 4 and 5 reflects that the review medical board, review medical examination board, review medical examination board obtained the opinion of a physician within opinion of physician, that is a medical specialist who was one of the board of the member. Ki boli question, how did I kaise start kiya tha line? नहीं, and that से पढ़ो. And that the affidavit reflects. उस वहाँ से पढ़ो. नहीं, and that the affidavit. Who was one of the board of the member. He as such submits that this is not contemplated under the guidelines. Full stop. The opinion should be from a specialist or super specialist of government medical college, which has to be taken in cases of doubt by the board. Ms. Borua?
College or hospital? Government.
Ms. Borua submits that the review medical board admitted the petitioner upon finding that petitioner is suffering from hypertension, on 19/11/2025 and discharged him on 21/11/2025. And during the said period, the petitioner was found to have multiple readings of his blood pressure. Full stop. She therefore submits that petitioner was found unfit by Review Medical Examination Board on 21/11/2025, and as such his case was rejected. As such his case was rejected for appointment as a constable in the Central Reserved Armed Forces.
Central Armed Police Force.
Oh, Central Armed Police Force. Para. It is not in dispute that the petitioner had passed all other preceding examinations and that the medical board and that the key, what do you say with this?
Detailed medical examination.
Detail. and that he was found to be unfit in his detailed medical examination, to which he applied for a review medical examination. It is provided in the guidelines. Where was the original one? Ah, yes. It is provided in the guidelines, namely, Uniform Guidelines for Medical Examination Test. Uniform Guidelines for Medical Examination Test, within bracket MET, capital, MET, for recruitment in CAPFs. CAPF will be in capital, S will be in small, comma, NSG, capital, and AR. And it is provided in the said guidelines, more specifically in clause number 6, that hypertension is a ground for rejection of appointment to such post. And in the revised guidelines, promulgated in the year 2000, no year, but yeah.
Yes, the revised guideline is 6 November 2025.
Promulgated in the year 2025.
Then is 31 May
No,
Oh, promulgated in 31 May
2020.
2025.
21.
2021.
One.
Yes.
2021, It is provided
31 May.
It is provided that the cause of unfitness may differ in respect of the detailed medical examination and the review medical examination. And that it is also provided that नहीं चाहिए. And it is also provided that medical officer who had conducted the detailed medical examination cannot be a part of the review medical examination board for the same candidate. Under subclause C of clause 6, इसमें clause 6 लिखा है ना? Yeah. Under subclause C of clause 6, it is further provided that a candidate can be declared as unfit only after a thorough examination, and that the findings must be supported by proper investigation reports. Wow. Thereafter, in subclause D, it is provided that review medical board may obtain opinion of concerned specialist or super specialist of government medical college and hospital in case of any doubt. The word used in the set subclause is may, which reflects that it is the discretionary power of the review medical board. It is further provided in the said subclause that while rejecting the candidature of a candidate on the grounds of being unfit, in review medical examination, the clinical findings should be corroborated by required test done in a government hospital or in private centers approved by the government. Full stop. Under clause 7 of the said revised guidelines, certain examples are cited for guidance of the review medical board. And in the same, in subclause E, it is provided that for candidates who have been rejected on grounds of hypertension, he should be admitted in a hospital by the board and after obtaining all the reports, such as whether his blood pressure is of transient nature due to excitement or whether it is due to any disease, and all other reports which are mandatory in nature, the board, mandatory in nature, the board should give its final opinion regarding the candidate's fitness or otherwise. Full stop. Para. In the affidavit filed by respondent number 4 and 5, it is simply stated that the petitioner was admitted in the CHBSF Patgaon Hospital and his blood pressure was checked. Which blood pressure was checked, and it was found to have multiple readings more than the prescribed limit. And as such, he was declared unfit by the Review Medical Examination Board. It is further stated in the affidavit that the Review Medical Examination Board had obtained the opinion of a physician, within bracket medical specialist, who was one of the member of the board. Full stop. Although it was stated in the affidavit that Review Examination Board, Review Medical Examination Board, had followed clause 6. No, para 6, right? It is said para 6. Para 6, subpara 1, which is that? That is your original, right? Yes. have followed. I've said, right? Para 6, subpara 1 of uniform guidelines. But in the affidavit, have you stated that you have followed the revised guidelines? But in the said affidavit, even I did not find. It is not stated as to whether paragraph 6 and 7 of the revised guidelines published in the year 2025.
21.
Oh, published 2021 was followed. It is clearly mentioned in the revised guideline.
We have stated about in paragraph 7, Lordship,
Hmm.
on last portion,
Hmm.
issued by memorandum dated so and so 31 May 2021, all candidates declared unfit during detailed examination will be allowed to undergo review medical examination, provided that they give their written consent by appearing their signature on the intimation indicating the reason for being unfit. Further, as per para 3 of the said guidelines dated 31/5/21, RME of
Acha, acha. So there's something. The last line you cut it, huh? No, is a agot je dilo. Although it is stated that they have followed, it is a 661 of the guidelines, but 6.1 of the guidelines.
In guideline, Lordship, there is
No, it is not mentioned. What did I say? Just read it, that last line. Although से start करो. No, no, अब उसके पहले से. Hmm. 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 In the said affidavit, but in the said affidavit,
here also it is, may I please say one thing? Here also it is.
it was not
mentioned that-
stated that the that the review medical examination board had followed the guidelines provided in the revised followed the requirements provided in the revised guidelines, that is guideline number 6 and 7 of the same. This is also 6, 7, that is also 6, 7. How can the number be same?
Yes, here 6, 7.
Acha, this is again 1, 2, 3, 4, 5, 6. It's okay. What were you saying?
In same para, we have also mentioned that we have taken consent, second line of 64, page number 64. It is submitted that the petitioner applied for the RME and accordingly the RME board examined the petition.
I have seen.
The guidelines on the subject and also corrected, correlated the opinion of physician, medical.
Okay, these are
specialist
same
who was-
things
yes,
that
ma'am.
was unfit. It is clearly provided in guideline numbers, para number 6 and 7 of the revised guidelines that the review medical board has to first it is not clearly provided. It is वहां से start करो. A careful reading of the said revised guidelines would show that the review medical board should admit the candidate whose case has been rejected by the detailed medical board on grounds of hypertension, comma, in a hospital, and get all the tests done, and should also see the cause of the blood pressure, and then give final opinion. And by a conjoint reading of para 6 and 7, it can be deduced that the review medical board may also obtain opinion of concerned specialist or super specialist of government medical college in cases of doubt. It can be further deduced that while rejecting the candidate by the review medical examination board, the clinical findings given by the super specialist or the specialist should be corroborated with the test reports. The said, full stop, the said exercise seems to have not been done in the instant case. Which is discernible from the affidavit filed in the instant matter. It is seen that only by measuring the blood pressure of the petitioner, which was found to be fluctuating, the candidature of the petitioner was rejected. Full stop. There was no finding as to the region of the fluctuating blood pressure, whether it was due to some disease or it is transient in nature. Full stop. Further, it is also seen that test reports were either not done or the reports were not considered. Tests were not done. Report to tapat katida. Tests were not done, nor the reports of the said test were considered, while declaring the petitioner unfit in the said examination. Accordingly, it is directed that the petitioner may be subjected to medical examination by the review medical examination board once again by following the mandate of para 6 and 7 of the revised guidelines of 2021. The petition is partly allowed and disposed of.
May I pray for a time frame to conduct?
It is further directed that the authorities would complete the exercise of reviewing the medical health of the petitioner within a period of 2 months, not 2 months, 1 month. 1 month.
3 months.
I'm saying 2 months, I have made it 1 month, now you want 3 months. No, maybe other posts are filled up.
They have already started the recruitment of 2026. This is of
So,
2025.
2 months, let's say.
2 months from the date of the whether there are posts available.
Yes.
Achha. 2 months from the date of the receipt of this order. The petitioner to place the certified copy of this order before the authorities as soon as possible.
It's also published, Lordship. Whether post are vacant or not, it's not known. Here, no stay is there, Lordship.
Lordship, in Assam, Thousands of candidatures was rejected.
But then no, he was the candidate of that selection process.
No. In that particular selection, thousands of candidates were rejected because of non-production of their NCL. They were medically fit.
The authorities are further,
50 of the
are further directed to adjust the petitioner if found fit
Yes.
in any post,
available.
even without the same being included in the selection process where he appeared, or any other process similar.
Yes.
If vacancy available, Lordship, then it will be.
In fact, they do have a.
No, if vacancy, then they will give a report, vacancy is not available.
Yes.
It's okay. Petition is disposed of.
Yes.
Take your judgments, Ms. Borua. Item 30? 5. Yes, 35, Mr. Bhuya.
My lord.
Lordship,
My lord, this in this petition, my lord,
Complete his instruction and file rejoinder affidavit. You file.
Lordship,
G. Bora, you are Miss
Lordship.
Bora.
affidavit has been filed, my lord.
affidavit and file, Lordship, in affidavit in reply, Lordship, we have seeking instruction from the department, Lordship.
Instructions are not there. Awaited.
In affidavit, reply awaited, Lordship, 1 week time may be given, Lordship.
My lord, what has happened, affidavit in opposition has been filed. And in that opposition, we have, my lord, rejoinder affidavit has been filed. Now in that rejoinder affidavit, my learned friend is asking for instruction, my lord. My lord, I am without salary and I am now 60 years old, my lord. Only ground is that, my lord, I have, my exit age is already over. Now, my lord, we have searched the entire guideline. There is no any exit age had been provided, my lord. So therefore, the similarly situated other persons, my lord, has been I have been informed, my lord, that they are also working.
Without salary.
My extension has not been provided, although earlier decision was taken that I should be work till 65 years of age, my lord.
Acha.
Now, from that decision, they have now deviated, my lord.
Okay, you bring her instruction as soon as 1 week's time only.
My lord.
Lordship.
Okay.
Lordship, actually, it is a contextual employee, Lordship, scheme-based project, Lordship, and their automatic, their extension is. not
Doesn't
automatic.
matter, you will take their services as contractual employees. You have to pay them at least.
Some people, my lord, after 60 become more efficient, my lord, in this type of post, my lord.
As per my instruction.
But he's not getting salary, he
No,
said.
my lord, at least the last few months salary till the date of my work, that should be, my lord, may I give a direction for that payment of my salary till the date I work, my lord. That has not been,
That I will take instruction, Lordship.
that is available on record, my lord, already.
Then what instruction you want? In view of the rejoinder affidavit?
Lordship.
Rejoinder affidavit, what have you stated?
Lordship, they have relied on a document, Lordship, like, Lordship, notification has, Government of India has communicated to the Agriculture Department regarding the exit upper age limit, Lordship. They had said that although there are no upper age limit, but the extension cannot be granted beyond 60 years, Lordship. On the basis of this communication, Lordship, the Director of Agriculture issued a notification whereby it is said that, Lordship, the
That he completed his age.
upper age limit
60
fixed
years,
on
now
60
that he is 60 years, he will
has
be,
completed 60 years, Lordship.
so he has to retire.
Lordship.
But my,
Their
Payment, salary? So you bring the instructions next week,
Lordship.
okay? What about salary?
Lordship.
Okay, he'll have to retire at the age of 60, okay, I understand.
Lordship.
So you did not get salary from what period to what?
my lord, I have not received this salary, my lord, from, my lord, from March to, my lord, March.
Acha, you have prayed for extension also, but then they are denying.
My lord, they are denying.
Because from 60 onwards, they cannot.
My lord, but there is no any such guideline, my lord. Now, basing on which guideline these amendments are made, that is also not specific and clear, my lord. So therefore, my lord can examine.
But the retirement age is of course 60.
No, my lord, but this is a scheme based.
This is scheme based, yeah.
And, my lord,
Huh.
they have taken a decision that they will allow me to work till 65 years of age.
Where is the decision? It is in written form.
Written, my lord. My lord, may kindly turn to page 27, annexure 3, my lord. Page 27, my lord. For the smooth implementation of the scheme, agriculture extension under the Krishnawati Yojana, the services of the contractual functionaries working at state level and district level as per list enclosed so and so.
Or 65 years.
Hereby extended up to 31/3/2023 or 65 years of age with effect from the respective dates of expiry, my lord. So, my lord, till now I have not attained the age of 65 years, my lord.
But this is or
Or
extended up to 31/3/23
2023, my lord.
or
Thereafter-
65 years of age.
Thereafter I have been extended, my lord.
Acha.
Thereafter I have been extended, my lord.
Extended for lordship, for 1 year. Yearly
Hmm.
basis extension.
That
lordship.
doesn't matter, then the 65 years will
Fine.
come. Here you see are hereby extended up to 31/3/2023 or 65 years of age
Lordship.
with effect from the respective dates of expiry of the term
My lord.
of each individual functionary. After 23, your services are extended.
Yes, my lord. My lord, may kindly turn to page 32.
So what is the basis of making this? Extended up to so and so or 65 years?
My lord, the basis is that, my lord, because there was no any such qualified or.
No, why is this two dates, 23 or
That-
65?
That, my lord, it is their policy maybe, my lord, as per the scheme, my lord. Now, what is the basis? That basis is not made available in the affidavit, my lord, also. So everything should be, my lord, transparent and fair, my lord, that suddenly
So
there.
you bring the instruction that 65 years, okay?
Lordship.
And then within 1 week, you have to get the telephonic instructions, affidavit is filed, right?
Lordship.
My lord.
One
Ms. G. Bora, Learned Standing Counsel for Agriculture Department submits that in view of the additional affidavit filed by the petitioner,
Okay.
she will have to obtain instructions from the department and as such has paid for time.
Okay.
Ms. G. Bora is also directed to bring instruction on the issue of allowing the contractual employees work till they attain the age of 65 years of age, as has been provided in the notification issued by them only, right?
My lord.
Notification
No.
as per the order issued by the director of the Agricultural University.
My lord.
Lordship, Director Samiti, Lordship.
A director of what is this Samiti?
Samiti.
Agriculture. Samiti is what?
27.
It's okay. This is agriculture only.
Lordship.
Agricultural department. Agricultural department, huh?
My lord.
Please list this matter on 10th of June.
Lordship.
On which date Ms. Bora will bring the instructions sought for.
36 same, Lordship.
Is also similar matter.
Acha. Order will be same.
Same.
Okay. 36 may well.
Oblige.
37.
My lord, in this case, some instructions is required, my lord,
Hmm.
to file the affidavit, my lord. 3 weeks time will be granted for filing affidavit, my lord.
Acha, you are for
Respondent number 1 and 2.
1 and 2.
In this case, man, I make him a.
You had all, yes.
Let them file affidavit, my lord, but the short date may kindly be given,
Mm.
my lord.
Heard,
And matter
Mr.
may kindly be fixed, my lord.
Yes.
The
Heard, Mr. M.H. Rajbalhuria, Learned Counsel for the petitioner, and Mr. D.
Shekhar.
R. Shekhar
For respondent number 1 and
for respondent number
1 and 2.
1 and 2. Miss M.D. Bora, Learned Standing Counsel for respondent number 3. Mr. Shekhar as well as Mrs. Bora. Acha. Mr. Shekhar, Learned counsel submits that he requires some time to file the affidavit in opposition. Prayer is allowed. List this matter on 24th of June. Yes, Mr. Major? Yes. 24th of June. Six Yes, Mr. Gogo, you are there?
Yes, my lords, I am in this matter, madam.
Hmm.
To be honest, madam, I couldn't go through the file it's a matter of 2022. Lordship, I'll seek one last final of, I'll just plead and finish this off. madam.
Acha, acha. So you want some time for
Some-
preparation?
just a week.
Okay,
But
Mr.
I have-
Gogoi,
This is a case, it's going, I know what will happen to this.
22 matter. Here,
Yes, madam, just a fixed date, madam. Next.
Mr. D. Gogoi, learned counsel appearing for the petitioner, prays for some time to prepare the case. Prayer is allowed. List this matter on 15th of June.
15.
15th of June.
Hold it.
$37 हो गए 38 hmm 38 39 yes 38 39 yes why has it come up for orders?
This contempt petition, this contempt petition of 2020.
Is there? Why is it taking so long?
What has happened after 5 years?
Who is appearing for the respondent?
The respondent, the Mr. Kaushik was also there.
No, this is contempt.
No, Lordship, I think the administrative department, Lordship, the council is on legs. I've been just informed. Lordship.
But there are so many.
Education department.
Pritam Sakya, Shyam Jagannathan. There are 11.
What is education?
There are 11 contemners.
Yes, but yeah, I've been just informed that the council is on legs, Lordship. Just
After some time?
Yes, my lord, because the earlier also, my lord, the council was not there.
Mm.
This matter has been advanced. This matter is since pending 2020.
Mm.
The meanwhile, one person has already been expired. And even they filed an appeal. Appeal has also dismissed.
So
But since then, my lord, they are sitting over, they are not bothered about the High Court's order, my lord. What can the litigant do, my lord?
yes.
This 2019, this order has been passed. But every time, my lord, you go through that they have, and the last order, my lord, they clearly stated that they should place the 23/4/2026.
These are the replaced contemners, new incumbents.
Yes, my lord, they have appeared. New incumbent has filed the appeal also. Appeal recently dismissed in 2025. They have filed appeal. (23/4/2026) a detailed order is there.
Earlier, Mr. Kaushik appeared.
Yes. Attorney also appeared.
So, Mr. B. Kaushik is there today in the court.
Here, somebody else has been engaged. Lordship. I'll be just informed. I'll just inform them.
Okay, after some time.
Yes.
I'll just inform them.
This is
Yes, 40.
Yes, ma'am.
Again, a
Sir.
contempt petition.
Yes, but this one I could directed.
Lordship, the Arnav Phukan is on another lakes.
Acha.
14. Now they have taken a stand good name mismatch, madam. Shahnaz Parvin and Shahnaz Parin in the
Acha.
CTET certificate. The P was missing. Now that has been rectified by the authority of BSCD. Till then, I have not, my case has not.
Of
got the-
corrective wait, last order was to the effect that placed on record copies of communication issued to the University of Burdwan for back office verification. And a letter is also issued to the petitioner for submission of certain documents from the CBSE as mismatch was found in the name of the CTAT mark sheet cum certificate.
Now
CBSE has done, man.
So they were sending your documents to Budwan, West Bengal University. So let Mr. Fukon come after some time. Go on, Chief Engineer, did you want to-
May I please?
Yes,
My lord, this case is ready for disposal otherwise, and it's also covered, my lord. Judgment is there.
Yes,
If
Mr.
the lordship-
Mahanta, you are there.
I am here, my lord. Your lordship kindly see is not covered. What covered, I do not know. It's a clash between two wives regarding their pension. So, my lord, she is claiming that her marriage was instituted as per the affidavit, and our claim is that our marriage was instituted as per the registered marriage act, my lord. So, as per registration.
So who is first and who is second?
So who is first? Because it will be how it will be decided, my lord. And that's why, my lord, I made a suggestion. Let it be, my lord, let them decide among them and let it be said to the, my lord, mediation, then they will decide it. Because otherwise it will be very difficult. So now he want to say that one judgment that in case of pension, there is no succession certificate is required. Because now government, my lord, because they are unable to dispose of the matter. There is a one judgment that, my lord, in case of pension, no succession certificate is required. When there is no dispute, when there is a dispute, something has to be, my lord, produced before the authority. Then they will decide, my lord. So that is why I am submitting, my lord. If he is agreed.
Who is made the nominee by the dead husband?
Nominee, my lord, and actually process of nominee, my lord, he was died in harness. So
he died in harness.
Acha. In 2023 he died, probably, no? Actually,
I don't fight for
my
2023.
name was in the nominee, my lord. But that was probably not accepted because of her claim.
Acha.
So that is in that stage, my lord.
So, Mr. Purkasta, let it go for mediation.
No, if he
My lord, here in this case, we have put to challenge, my lord, Annex 10, which is the letter issued by the department asking us to submit the succession certificate. Issue is confined to that only, my lord. We are not
But
here.
where there is no dispute not required, but when there is a, you have to show who is actually entitled.
I am the first wife, my lord. They have hijacked my children also. They have hijacked, my lord. Your lordship will find Annex 2, page 26 is the birth certificate. Birth certificate of my daughter. They have taken the daughters. They have both the daughters have been taken by them.
That marriage is have dispute because it is by way of affidavit. Can it be a marriage between, my lord, two persons by way of affidavit, my lord?
Her name is there. Her name is
Reality
there
is
in the
that, my lord,
register.
out of the marriage, my lord, 2 children have been born, my lord. So, my lord, if
But
they
then
pray
there
for,
are
my lord,
disputed facts. So go before the mediation, settle it.
let
Why
it be tried
shunning
once.
away? You
As
place,
your
both
lordship,
of you place the case before the mediator, disputed facts, they will settle. Okay? Okay, go for mediation.
If they agreed, otherwise I am ready to
Yes,
argue.
Mr. Purkasta will agree. You have to convince your client, that's it.
yeah, I will try, my lord.
Had heard Mr. B. Purkasta, learned counsel for the petitioner, and Mr. T.J. Monta, learned senior counsel, assisted by Mrs. P. Sharma, learned counsel for respondent number 7, and Mr. B. Bora, and for respondent number 1 to 6. As agreed to by the parties, this matter is sent for mediation. The Gauhati High Court Mediation Center to appoint a mediator and who will hear the case and would submit the report on conclusion of the mediation.
Because otherwise,
Yes,
my
they will
lord,
also
nobody will be benefited.
Yes.
It will take time.
No one will get money
My
also.
lord. Money is
So we'll furnish a report to this
Till
court.
the lifetime of, my lord, till the lifetime of my husband, I was getting the maintenance.
that was an expertise order from my lord.
Maintenance?
Yes, there's a
Maintenance?
divorce case, my lord. The
Oh, there is a
maintenance,
divorce proceeding going on.
No. There is a, my
maintenance
lord,
case was there, my lord.
order was, my lord, yes, taken, my lord, and send it to my lord office and not directly deduct it, my lord. Even husband do not even know. When he know he, my lord, my review petition, my lord, that was he, by this time he died.
Such things also
My lord.
happens. Okay, huh? Mediator will furnish the conclusion of the mediation.
Obliged.
Wait, please, Your Lordship.
Hmm.
Lordship, apologies, my lord. I was actually in court number 18.
No,
for the
it's okay.
Delivery of judgment.
It's okay. You were supposed to give some instructions.
Lordship, in this matter,
Oh, this is Mr. Kaushik's matter.
Yes, exactly, madam. What has happened is, my lord, Mr. Kaushik, he's unwell, my lord. He's not recovered as on date.
Acha.
So he has requested me to, my lord, request the court, my lord. That
What has happened to him?
He's, my lord, he's got fever.
Oh, acha.
So he's requesting,
Fine.
my lord, can the matter be taken up on Monday? This
Okay.
Monday, because then it'll.
You are there for the petitioner?
He's there.
38 and 39.
39 days.
Mhm. Okay.
My lord will have it on
Yes.
Monday. He'll
Huh.
bring the instructions, my lord.
A prayer is made on behalf of Mr. B. Kaushik to take up the matter on Monday next. That is on 8th of June.
My lord.
Prayer is allowed, list accordingly.
Deeply obliged.
Well, that may be mentioned that the instruction has to be placed as per the order dated, my lord, 14.
It is already written. B. Kaushik has some
No,
so,
he would have
instructions.
finished today, my lord. Unfortunately, he's not well.
He is not well, so let on 8
Right.
will come.
I do
42.
40.
Lordships, I appear in item 42.
40. Oh, no, I'm taking up first 40.
All right.
Yes, Mr. Fukon.
Lordship, in this matter,
Hmm.
I have, I'm about to get my instructions, my lord. I think the compliance order will be there, my lord, because we were asked to basically give them a re-verification. So I think that order has been complied, but my lord, I need some time, just 1 week, my lord.
If
I'll
the
get-
compliance is there, then
Because
good.
my lord,
1 year, madam, this matter has.
this,
been set
the
after
case, my lord.
1
is-
week's time only.
Yes, my lord.
Okay.
Case is very peculiar, my lord. The order was for re-verification.
Hmm.
I think he was called for re-verification, but I don't think she has appeared before the hearing committee. So
Hmm.
let me get that instruction, man, whether she appeared or not.
Already.
Because she was.
He appeared.
Yes, my lord.
For verification of what? Document?
Re-verification.
Re-verification.
Because she had appeared and then there was some communication misgap, so because of which she could not come. So another direction was given as per the last order that you appear before the committee, but whether she appeared or not, that has to be a certain, my lord. And if she has appeared, then, my lord, accordingly, I'll place the thing on the next date, my lord. So 1 week, my lord.
Mr. A. Fukon, Learned Standing Council for Elementary Education submits that the process for compliance of the High Court's order is on and that he would place his necessary instructions on the next date. List this matter on 8.
My lord, deeply obliged.
Yes, 42 year appearing.
Lordships, I am S.D. Sanjay, Additional Solicitor General, Supreme Court.
That.
Now, my lord, so far this contempt is concerned.
Acha, let Mr.
No difficulty.
Because being the petitioner's counsel before my learned senior friend starts, I need to place the facts.
Acha, Mr. D.
Lordships, no difficulty. Let him place the facts.
Petitioner, let him place first and then we will go to you. Okay, Mr.
My lord,
Chakraborty.
page number 18 is the order not complied with.
Acha. Page number?
18.
Hmm.
Now, I'll take your lordship straight away to the operative part at page number 22.
My lords, before, may I interrupt, my lord, for a moment?
Hmm.
Before my learned friend makes his submissions on fact and merits in detail, my lord, let me bring to your lordship's notice one fact, that if my learned friends want the solution of the problem, because there is a typical situation arose in this case, which can't be sorted out unless and until, if your lordship will kindly see page 19, page
So why
19,
does it come up for orders today?
So this is a contempt proceeding.
contempt case, my lords. Now, my lord, if your lordship will see page 19, respondent number 6 and 7, Assistant Provident Fund Commissioner employees, Provident Fund Organization, and it is also Assistant Provident Fund Commissioner, unless they are called before your lordships, because it is not a question of non-compliance. It is a question of dual payment of pension, which is not permissible under law. So, my lord, if they comes, my lord, because Government of India has already said that they are going to pay pension, But the problem arose because this Employees Provident Fund Institute said, no, we can't discontinue the pension. So as a result would be that two pensions has to be paid, my lords. And she is in fact receiving two pension, my lords. But
Okay,
the
we will
question
go
is
into
only of arrear.
Acha, no, we will go into that later, whether they are still the parties here.
Yes, they are party. At page 19, they are the, oh no, in
this is the
contempt they have not
contempt.
been. In contempt, they have not been impleted as a party. So they have to
not
be impleted as
required.
a party so that the matter can be resolved.
No, not required. What? I'll see the directions first, then I'll decide.
My lord
Let
comes
me
to
see.
page number 22.
Hmm.
Your lordship kindly sees the very second paragraph of page 22. It is submitted. If your lordship has got it, it is submitted by the learned senior counsel for the respondent number 6 and 7, that an affidavit has also been filed by respondents number 6 and 7 on 11/1/2024, wherein they have stated that the pension payable to the petitioner under employees pension scheme will also be continued to be paid. There is a categorical averment in the affidavit that the benefits of pension of the EPF Act and EPF scheme 1995 being a statutory benefit, this benefit cannot be cancelled or announced to provide any other benefit to substitute thereof. On 7/6/2023, notices in the matter were issued, and today when the matter was called up, Mr. R.K. Dev Chaudhary has placed before the court a communication issued by the Senior Accounts Officer of the Regional Pay and Accounts Office, Government of India, Ministry of Civil Aviation, by which the office has forwarded the original PPO bearing number so-and-so along with other relevant documents. Mr. R.K. Dev Chaudhary submits that in view of the PPO being issued, the petitioner will be entitled to the family pension on the enhanced rate of rupees 9,910 with effect from 1/1/2024. It is further mentioned that the area pension with effect from 18/9/2009 to 31/12/2023 will also be paid by the said office. In view of the PPO now being issued and the submission of Mr. R.K. Dev Chaudhary, learned Deputy Solicitor General of India, that the pension will be released to the petitioner in view of the PPO having been forwarded to the competent authority. This court therefore does not find any further cause left to urge in the present proceedings. Accordingly, taking on record the submissions made by Mr. R.K. Dev Chaudhary, learned Deputy Solicitor General of India for the Regional Pay and Accounts Office, that the PPO has already been released along with the arrear as mentioned in the communication enclosed under the cover of the letter dated 9/1/2024. The writ petition stands closed, directing the respondents to take all effective steps to proceed for release of the pension of the petitioner in terms of the PPO number so-and-so issued to the writ petitioner. In that view of the matter, the writ petition stands closed with the above directions. Now, after this order, we preferred our representations communicating this order, and in fact this order was in view of the communication by the learned Deputy Solicitor General of India appearing on that date on behalf of the central government. Now, pursuant to this order, my lord, the pension which was halted, that resumed under the CCS rules. Now, in view of the submission made by the learned senior counsel appearing on behalf of the employees pension scheme, the pension of the pension under the head of the employees provident fund, that also continued in view of the submission made by the learned senior counsel who appeared on that date. Only thing that was not complied with, or that has not been complied with as of now, is the arrear pension under the CCS rules. Being aggrieved, we communicated, we preferred our representation, and eventually we have come up in contempt before this honorable court for non-compliance of the order of this honorable court to the extent of payment of the arrear salary, the arrear pension, which was very much undertaken by the learned Deputy Solicitor General at the time of, and on the basis of which there was a recording and there was a direction. Now, they have now come up with an affidavit stating that the predicament that they face in not paying the arrear pension under the CCS rules is because of the payment of pension which is being made on a monthly basis under the employees pension scheme. And until and unless the payment of the pension under the employees payment scheme that has already been made till now is recovered, they cannot make payment of the arrear pension under the CCS rules.
Now, my respectful submission here is twofold, my lord. Firstly, this is something that could have been taken up in an appeal of this order passed by the honorable court sitting in the writ jurisdiction. That was not done. This could have been reviewed. That was also not done. Now they are coming in this contempt proceeding and filing an affidavit and stating all these things. Now here also, there is still a scope for them to pray before this honorable court of the original side, that is under the writ jurisdiction, the court that has passed the order, for modification of the order. Something that your lordship is aware during the contempt proceedings also, if there is any impediment, if the rules do not permit, in that case, they can highlight it by filing an IA, or they can file a petition, a miss case after the disposal of the petition. They have that my lord, provision where they can seek for modification because of there being impediment under particular rules. Now, I am not averse to the fact that if I'm not entitled under the rules, I should still continue to insist to have this order complied strictly. My only difficulty, my only my lord, anxiety here is that under contempt proceeding, whether this honorable court will be able to modify this order unless until it is prayed for by the persons who are asked to comply. My learned senior friend who has taken the trouble of appearing all the way from Delhi, he has got this affidavits filed. But what was required to be filed, that has not been filed till date. And this 70 years old lady is suffering. This 70 years old lady has been deprived.
What do you mean to say, whether this issue can be taken up in contempt
I'll
proceedings?
concede to it. If they make a prayer by filing a petition, I'll concede to it. I don't want pensions under two heads if I'm not entitled under the rules. Why should I insist for something that is not legitimate to me?
So you are getting a pension under the
Both this-
EPF,
both now-
Employees Pension Scheme.
As well as CCS.
CCS, though, you have to get the arrears.
No, even under the CCS rules, I am being paid pension also, the monthly pension, the family pension that I am supposed to get, that is being paid to me after the passing of the writ court's judgment and order in the writ.
Under the CCS?
Yes. I am getting pension under CCS as well as under EPF. Now, what has come from them in the affidavit is that I am not entitled to pensions under both the schemes. And that is not permissible under the rule. If that be so, to that extent, my lord, this order of the writ court has to be modified. Now, for that, there has to be a prayer. Now, that prayer was not made by way of any writ appeal or any review.
Yes.
Even now also, if they make a petition, if they file a petition, I'll concede to it. I would only, my lord, request, in that eventuality, I would only request, let the EPF pension be stopped. Let my arrears pension under CCS rules be released. But for that, my lord, that has to fall from them first. They have to
Arrear under the CCS.
I am,
And the present pension is also under both the X.
yes. So if under EPF, I am not supposed to get.
EPF or what?
EPF is
EPS.
the employees pension scheme. And CCS is the central government, my lord, the
Contributory.
central scheme. So I am entitled under the CCS rules, and which has been taken note of by the honorable writ court. The writ court has given the direction to that effect that my monthly pension be released. Side by side, there was also an undertaking that the the area pension under the CCS rules from this particular date, that is 18/9/2009 to 31/12/2023. That is the concluding lines of the penultimate paragraph at page 22. Now, this was the undertaking given in terms of which this writ petition was closed with the direction. Now, the monthly pension has been released.
Monthly pension you are getting regularly.
I was not getting, for which I had filed the writ
Yes,
petition.
now you are getting.
I'm getting under CCS rules. Even under EPF rules also, I mean, under the Employees Provident Fund scheme, the employees pensions, the employees, the pension under EPF scheme 1995, that is also being paid to me. Now they have come up with an affidavit that I cannot get pension under both schemes. So far as this EPF scheme 1995 is concerned, that has to go, because in my writ petition, my prayer was for my lord, giving a direction to the authorities to give me pension under the CCS rules. And which was allowed.
It was a double amount or what?
It is a double amount. Earlier also, there were payment under the EPF scheme that was made to me. That was the monthly pension. Now, subsequently, I made a prayer that now that I'm entitled to pension, family pension under the CCS rules, so the pension under EPF rules should stop, and I should be given pension under the CCS rules. A PPO order was also issued to that effect. So I said that since that was not being given to me at that point of time, I said that EPF should be stopped and CCS rules should apply. So the EPF authorities at that point of time had recovered the amount from the date with effect from which the PPO order under CCS was issued. So that was taken away. Now there came a time when I was pensionless. I was not getting pension under any heads. So I approached this honorable court. Before this honorable court, my prayer was to, my lord, facilitate me with the pension under the CCS rules only. I had not made any prayer to give me pension under both heads. That cannot be. That could not have been my prayer.
Yes.
Now, there was a submission made by the learned senior counsel appearing for EPF authorities that even I am entitled to pension under EPF also. That is the second paragraph at page 22. And also by the learned Deputy Solicitor General of India to the extent that I am entitled to pension under CCS rules, and also arrears pension under CCS rules with effect from 18/9/2009 to
No, he
31.
did not say that you are entitled under both.
No, he did not say. The senior counsel appearing for the EPF authority, the second paragraph of page 22.
20.
22.
22, huh?
Yes. Now, taking those aspects into consideration, now what is happening is I am getting pension under two schemes. One is under CCS rules, one is under EPF. Now, at that extent, I have got salary, I have got pension for a few months. Now, in their affidavit, what they are saying is, first of all, this EPF has to stop. Secondly, the pension that I have got under EPF, that has to be recovered. And then only they will be in a position to make the payment under
That
the CCS.
EPF part was, partly it was recovered.
That was initially earlier recovered, the amount that I had got till then. Thereafter, since I prayed
After this judgment, you were getting under the both.
under both.
Now,
they are
one
saying-
part has to be recovered.
Yes, one part has to go, and whatever I have received from that part, that is EPF part, that has to be recovered. Only then they say that they are in a position to pay me the arrear pension under CCS rules. I am agreeable to that. I am not averse to this proposition, but the only fact is that they will have to come up in a prayer before this honorable court, not by way of an affidavit. Because unless and until they make a prayer for modifying the rate court's order to that extent, this honorable court sitting in my lord's contempt jurisdiction, perhaps not in my respectful submission subject to correction, will not be in a position to modify the order or the direction given by the
In a contempt jurisdiction, I cannot. I have to simply see whether orders are followed.
So, my lord, my understanding is this. Now, whatever my senior friend, my lord, whatever falls from my senior friend, my lord, will be important.
So, Mr. Sanjay, what do you
Lordship.
say? You file an
Lordship.
IA for
My
modification of the order?
learned friend has in fact, my lords, made my argument also. This is not a case of type of adversarial litigation. Now, it is not, no more. Because now, my learned friend himself has admitted that he is getting double pension, which is against the rule, my lord. Every month he is getting two pension. Now, my lord, the problem arose because of the fact that the client of my learned friend, he was the employee of earlier civil aviation department. Now, ultimately, my lord, all the employees of civil aviation department were in block transferred to airport authority. Now, that point of time, they started getting the benefit of employees provident fund. Later on, Government of India took a decision that no, the benefit of pension as the Government of India employees are getting, they will also get, and that is enhanced pension. So rather, the Government of India decided in the benefit of this, my learned friend's client. Now, the day PPO was passed, order of PPO was passed, prior to that day, Employees Provident Fund pension was also released. And after 7 days, the case was disposed of. So it could not be brought to the notice of your lordship, my lord, this honorable court, my lord. Now, a very simple thing has to be done, my lord. Now, what has happened? that the Employees Provident Fund Department, when we approach that you discontinue the pension, now they say ki we can't discontinue because we don't have any rule to discontinue unless there is an order of the court. So therefore, at the very threshold, it is not a case of Milord passing any order or in contempt. It is a case wherein simple calculation is to be made and this contempt can be disposed of, because there is absolutely no contempt, because contempt is intentional or deliberate violation of the order of this honorable court, my lords. There is absolutely no, he is getting double pension, my lords. Now, what is required is, and what my learned friend said, that it can go in the writ jurisdiction, all that. No, there is no need. It is before your lordships. And simply, my lords, a calculation has to be made and they have to be made party, EPF. And the moment they comes, they can be directed to discontinue their pension. And thereafter, whatever payment has to be made, both has to be calculated. And accordingly, the recovery will be made and balance, the arrears will have to be paid to them. And thereafter, she will start getting monthly pension as she is getting currently. Now, only thing is that the double exercise will not be done, that the duplicate pension which she is getting under the employees pension scheme, that will be discontinued. This is the simple exercise which requires to be done here.
It cannot be done in this contempt jurisdiction. All I have to see is whether it was followed or not. So in this
So, my lord,
petition,
in fact, that way it is the contempt has become infructuous because it is being followed. She is getting double pension. Where is the
but
question
what
of
about her arrear salary, arrear
not
pension?
arrears, my lord, unless there is a calculation that how much double pension she has received, unless that is recovered and unless the pension under the Employees Provident Fund is stopped, she can't be paid arrear. Otherwise, it will be amount to paying double amount. Now, my lord, this honorable court never directed to pay double pension. Had there been any direction, then that would have been contrary to rules, my lord. So
Yes.
it is a case.
So the best option is file some application, not in contempt jurisdiction. So
Now,
that even if this contempt is closed, again she will be remediless.
No,
So
no.
we'll have to give her some order.
Yes.
So you file an application.
Not we have preferred an appeal against that order. Of course, it is with delay, but since my learned friend has himself admitted that the moment it comes,
What happened to the appeal?
No, I am not aware of any appeal.
actually the appeal has just been filed. When the matter came to me, then when I saw it, I said ki there is no need, it has to be resolved.
Okay, let's see what happens in the appeal and we will take this matter up
So
after
your
that.
lordship may adjourn it in July. Meanwhile, our appeal will be taken up and we will try to sort it out in appeal. The matter will be resolved because it is only calculation.
That is a better option. Okay, heard Mr. D. Chakraborty, learned counsel for the petitioner, and Mr. Sanjay.
SD Sanjay.
SD Sanjay, learned additional
Solicitor General of India.
General of India. Mr. Sanjay submits that an appeal has been filed against the order dated.
It is an appeal is
Order dated 18/1/2024.
It is being filed, my lords.
It is not yet filed.
Not yet been filed.
Not yet filed. It is in the process of filing. Mr. Doloi is filing the appeal. It can be recorded, my lords, because Mr. Yadav Doloi is filing the appeal.
The judgment of 24.
Whether
That's correct. We have filed with we will be filing with the condonation application.
Acha ki kolo moi? Mr. Sanjay submits that an appeal is likely to be filed against the against the order dated 18/1/2024, passed in writ petition number 3260 of 2023, comma, the non-compliance of the judgment, which is challenged in this petition.
Okay.
As such, a prayer is made to take up this contempt application on a later date.
Lord, then I have my objection to my lord fixing this matter in the month of July, because they have not yet filed appeal. They are making a submission for adjourning it on the ground of filing appeal. Let it come up next week.
Okay, you file the appeal, then we will give another order. So we will fix this matter next week.
Instead of next week, my lord, can it be fixed in the last week?
No, last week
or
is
first
again
week?
before holidays. No, decision has, you have said the decision is already
No,
taken
no,
to file an
your
appeal.
lordship's appeal may be filed tomorrow or day after, because it is in the process.
So enough. So we will fix it on 10th of June. On that day, you apprise us
All
whether
right.
it is filed. Okay.
All right.
List this matter on 10th of June.
My lords, one request. May I pray that this may be taken up at 10:30 to, in between 10:30 to 11, because I
It's
am
okay, we will
traveling.
take it up as you, in your convenience.
Because my time zone will change. So there will be a difference of 10 and a half, 12 hours around.
It's okay, we will take it up at your
10:30, 10:30 or 11, whatever it may be.
Huh.
Grateful, grateful. I am deeply grateful.
It's okay. Amended cost title filed.
Yes, Lordship.
So today, why has it come up for others?
My lord, actually, all our respondents, I have taken steps.
They
against
are
them.
served. Now, what about their response affidavits filed?
No, Lordship, earlier, respondent number 1 prayed some time to obtain instruction regarding this matter, but not yet.
Lordship, instructions are not yet come with regard from
Hmm?
was 1 to 4. I appear for the industries department here, but here this earlier this Assam construction company, it was taken over by the AIDC. So now they have to actually, now AIDC has to actually respond.
What is this pension?
Your Lordship, it relates to as such pensionary dues, Your Lordship.
So you bring your instructions.
So those that aspect has to be actually highlighted by AIDC. So AIDC
Who appears for AIDC?
It's the D Nat, not Dipankar Nath, Deepjyoti Deka. He is standing counsel for AIDC. I'll have to let him know that.
You tell him, you apprise him of this.
So he will be in a better position, because this company has become defunct. This Assam construction company. So
where the petitioner was working?
Yes.
Or who? Petitioner died in harness or what?
Some
Father died in harness.
Corporation.
Huh?
Assam Government Construction Corporation, AGCL, it has become defunct. So now it is represented by AIDC as far as my instruction goes. So I have not yet received any instruction from the industries department, but let me get the instructions as to what is the
Miss,
status.
your name please?
H. Bora.
Miss H. Bora, learned counsel appears for the petitioner, and Mr. N. Bora.
D. Bora.
D. Bora, learned counsel appears for
1 to 4.
Respondent number 1 to 4. Mr. Bora submits that the petitioner was working or what? In the defunct company?
They have retired. Erstwhile companies, Your Lordship. Erstwhile employees of Assam Government Construction Corporation.
The petitioners were Mr. D. Bora submits that the petitioners were erstwhile employees of the Assam Government Construction Company. Corporation. Assam Government Construction Corporation, which is taken over by the AIDC. Assam what? AIDC is? Industries.
AIDC is Assam Industrial Development Corporation.
Whether it's a party here?
No, they have not been included.
So AIDC is not a party actually.
They have to implement them actually.
Is taken over by the AIDC. A2 Assam Construction Corporation. And he submits that the instruction should come from the AIDC. However, it is seen that Assam Industries Corporation Limited. No.
Industrial Development Corporation.
Industrial Development Corporation. Assam Industrial Development Corporation. AIDC, huh? However, it is seen that the AIDC is not made a party respondent in the instant petition. So you will implead?
Yes, Lordship.
As such, it is the liberty is granted to the learned counsel for the petitioner to implead AIDC as a party respondent for proper adjudication of this case. List this matter again on 17th of June.
After holidays, Your Lordship, by the time let them implead also.
List this matter on 13th of July. No, we'll fix it on an earlier date, let them implement, then he will bring in.
Because they'll anyways file an IA for implement.
So, but we'll take it up on a shorter, we'll list this matter on 17th of June. You file an implementing application, then we will tell them to get the instructions. Yes, yes, contempt.
Yes, Lordship, this is for appointment post of junior engineer
Mhm.
in the PNRD department. They've already done the document verification.
Acha, I'll just see the last order. Mr. S. Datta, who is S. Datta? Acha, wait. Hmm, 2 and 3, right? 2 and 3 has filed affidavit. Yes, 2 and 3 has filed affidavit. Because they are the ones who has to reply about appointing the petitioner. So today what needs to be done, Miss Counsel?
Lordship, may kindly fix a short date since they have gone ahead with the document. They have already gone ahead with the document verification, and it is perhaps in the last leg of appointment. So they will have to.
So let the counsel come or what? Mr. S. Daskan, who is appearing for APSC now? APSC. And respond number 2 and 3 are who? JB Ekka.
I have received an affidavit.
We are for respond number 1. Miss Das. Miss Das or what was the number? Only 2 is an, acha, 3 is later implemented. New incumbent, respond number 3. So respondent number 2 and 3 have stated that the appointment is in the process. So 2 and 3, there is no representation, or you, Mr. Counsel, you are representing 2 and 3. To respond number 2.
Number 3.
No, 3 is presently holding the charge of respond number 2. So 3 has filed affidavit. What does it say?
It is stated that on 29/5/2026, they have gone ahead with the document verification and the petitioners have appeared before them.
Appeared have been.
Yes.
They have done the document verification. Then?
And that much it is. They've said that they have gone ahead with the document verification. However, this affidavit is not tagged along with this record.
Respond number 3's affidavit is not tagged.
No.
There is, I think. No, Dusty.
Not there.
But it is in the office note that they have filed their affidavit.
They have filed the affidavit, but it is not tagged.
Pursuant to the Honorable Court order, no affidavit filed on behalf of 2 and 3. Okay. Okay, then you verify. Heard Miss S. Nazneen, huh?
N. Begum.
N. Begum, Learned Counsel for the petitioner, and Miss S. Das for respond number 1. P. Sharma, Learned Counsel for respond number 1, and Mr. A.K. Ghosh on behalf Ghosh, SE likhe. On behalf of S. Datta, appearing for respond number 2 and 3. It is stated by the learned counsels that respondent number 2 and 3 has filed affidavit, but the same is not found in the records. As such, the learned counsel appearing for respondent number 3 may verify with the registry and get the affidavit placed in records on the next date. List this matter on 10th of June.
Much obliged. Also, order is of my lord 25/2/2025, my lord. Regarding service of notice, my lord, Dusty.
This is some government appeal.
No,
No.
my lord.
Your
Content.
private appeal. Yes, what happened?
My lord, regarding service, my lord, we have filed Dusty, my lord.
Contempt case.
Content case, my lord. The affidavit is on record, my lord, page 23.
You have served the respondent by way of Dusty.
Dusty, my lord.
So you have filed your affidavit.
My lord.
Page
but no
20
representation.
my lord.
How many respondents are there?
2 respondents are there.
MK Yadav, IFS Special Chief Secretary, Sandeep Kumar, IFS Principal Panjabari. They are still the incumbents, they are still working.
My lord.
When have you filed the affidavit?
My lord, on 10/12, my lord.
10/12.
10/12/2025, my lord. But
And
on
now
the-
it is 6 months, they have not appeared.
If your lordship peruse order dated 13/2/2026, my lord.
13?
2/2026.
Yes.
R.R. Gogoi was appeared, my lord. He is the standing out.
It is for he is requested, has requested the matter be taken up after 1 week. Now he is for the forest department.
Yes, yes, my lord. But the incumbent has not appeared. They were not appeared.
Mr. MK Chaudhary, oh, so you are there. Already intimated a petitioner that so let the standing councils inform the officials, right? Who, whether this Mr. R.R. Gogoi is still the standing
Yes, yes,
council for forest department?
My lord, he is the standing out.
Okay, can you call him?
My lord, after some time, my lord.
Hmm?
My lord, I can, my lord.
Just try within 5-10 minutes. So if we can give the information to the officers, that will be better. Now, where is the office note that service is complete? Dusty, right?
My
Hmm. Both of them by Dusty.
both of them by Dusty, my lord. If your lordship peruse page 24, my lord. Para 2, my lord.
24.
24, para 2, my lord.
Hmm. Hmm. Okay, you try to call him or we'll fix it up day after tomorrow. You bring Mr. R.R. Gogoi.
Lordship.
Okay. On the prayer made by Ms. S. Tutia, learned counsel for the petitioner, place this matter on 3rd of June, day after tomorrow. Hmm? You inform R.R. Gogoi, let him be here. Yes, Mr. Sharma?
Yes, my lord.
Hmm.
The amendment petition has to be allowed, my lord.
Amended writ petition?
Yes.
You have withdrawn the earlier one or what?
No,
Or two petitions?
the earlier one is being amended by this.
Hmm.
And they have been already served, my lord. Submit notices come.
You are appearing for?
Health Department, Lordship.
Health
On behalf
Health
of the
Department.
Tribunal, yes.
Acha, I'll just see the amended writ petition.
My lord. Amending this,
Why are these tracking reports? So many tracking reports?
there are 35 respondents.
31 respondents.
35.
This is an IA, right?
Yes. This is amendment petition, my lord.
This will be the amended writ petition.
Yes.
Or you have to amend it by way of an IA. Your IA has to be allowed.
Yes.
Thereafter, you file an amended writ petition.
Then I file consolidated petition.
Consolidated,
Yes.
okay, consolidated writ petition.
Yes.
This IA is for amendment.
Amendment
And this has not been allowed till date.
till date, no. Just
Not-
notice, just notice is complete.
In this IA.
Yes. Notice was sent, my lord, notice was complete. And now it is ready for allowing this amendment.
No, for amending the writ petition, you want notices to be served. It
Yes,
is for the
notice-
court.
Yes, it is served.
No, there is no requirement as such.
But it is served as per the court's order and we have already served them.
All the respondents are
Yes.
served. You are only for health department.
Yes, Lord. For 1 and 2,
for 1 and 2.
Lordship.
And these are also official respondents.
They are private respondents also, 2, 3 are.
Oh, acha. Apollo, Jorhat Medical College.
Yes.
So, okay, you file the consolidated writ petition then.
First allow, lordship to allow this, then only.
Since the service is complete, by way of Dusty you have served.
Only one, someone, one from amongst them is served to the justice.
Only one by Dusty.
Others by the.
Others are by, so where is that?
Registered.
Where is that service order?
My lord, that registry has that. Because they are from, all from Gauhati Medical College. There is no private.
Service 4, 5 completed, 4, 5. 3 is by Dusty, right? And what about others? 1, 2, you are appearing, 3 by Dusty, 4 and 5 is complete. What about 6, 7, 8, those? There is no stipulation about 6, 7, 8. Tell your junior to once check and let me know. Okay, let your junior check. Otherwise, 6, 7, 8, I don't find any office note here. Okay, there are so many office notes. You please check and let me know. Mr. Sharma, you need not be here. You can go.
Yes.
If the service is complete upon all the respondents, I can allow the IA and then.
Otherwise also your lordship may allow IA and we will have to serve the consolidated petition again. Yes.
That you have to serve.
Yes.
Okay, you check. You let it come up day after tomorrow. You check. Okay, there's no time actually. On the prayer made by the Learned Counsel for the petitioner, list this matter on 3rd of June. You need not be here. He'll check and he'll let me know. Yes. 40? 48. Yes, Miss Ann Begum.
Please, Your Lordship. Lordship, as per the last order, we had taken steps on 241 of the respondents.
There are so many respondents. 6 to 246 by paper notice.
No, we have taken registered post on all of them. However, Lordship, only 58 has been shown as delivered and rest insufficient address, and regarding 140.
It will happen. No, that is why I think paper notice would have been the best way.
Yes, Lordship, that is what I was supposed to pray.
Okay,
What?
you take notice by way of paper publication. Heard Miss N. Begum, Learned Counsel for the petitioner. Miss Begum submits that how many of them are served?
58.
That steps were taken for service of notice upon all the respondents, and out of how many? Out of
241.
Out of 241 private respondents, 58 were served, and the rest could not be served mainly on the ground of insufficient address.
Not all, only 27 shown as insufficient address. Rest for 140, they have not written anything.
They
Whether
have-
it is, registry has not written anything on the office note.
And the rest could not be served. As such, Ms. Begum prays that she may be allowed to opt for paper publication for service of notice. The same is allowed. The petitioner is directed to go for paper publication in 2 local newspapers which has extensive circulation, one in vernacular and one in English. List this matter on 17th of June.
Much obliged.
For service of notice upon the remaining respondents. 2 vernacular, 1 in English, hey, for service of notice upon the remaining respondents. It can call it? 5.
May I-
Yes, I.
This is the IA for substitution of the legal heirs of the writ petitioner, my lord.
Acha.
In the meantime, this writ petitioner died, my lord, on 5th April last, my lord.
Hmm.
So they need to be substituted, my lord.
So now substitution.
Yes,
So substitution by Sayada Perlin.
yes, my lord.
Three
She is
applicants.
the wife, my lord.
And the other two?
Other one is son and daughter, my lord.
Two is daughter and three is son.
Son, my lord.
Son.
Yes.
Yes, you are appearing for?
Yes, irrigation department, respondent 1, 2, 3, and
1, 2, and
then
3. Yes, you are for irrigation department.
yes, Your Honor.
You? Respond number 7, Accountant General. Buddha Gogoi can appear. Okay, it will come. Heard Mr. You will appear for 4. Okay. Heard Mr. Your name, please.
K. Uddin.
K.L. Hussain, Learned Counsel
K.
for
Uddin.
K. Uddin, Learned Counsel for the petitioner. This is an application filed under Order 22, Rule 4. Order 22, Rule 4, right?
Yes, ma'am.
Rule 4 of the CPC for substitution of legal heirs of the deceased writ petitioner. It is stated in the petition that the writ petitioner, that the erstwhile writ petitioner, that is the father of the applicants, died on 5/4/2026, leaving behind the applicants who are leaving behind 3 legal heirs. Full stop. Applicant number 1 is the wife of the deceased writ petitioner, and applicant number 2 is the daughter of the deceased writ petitioner, and 3 is the son of the writ petitioner. Deceased writ petitioner. What is this matter about?
My lord, this is the
Pension.
recovery from pension, my lord.
The matter relates to pensionary benefits to be given to the legal heirs of the deceased writ petitioner. The said substitution is allowed. The petitioner is directed to amend the cause title of the writ petition by filing a necessary application. I is disposed of. Writ petitioner there. In view of the order passed in the I, the necessary amendment to the cause title be made to the instant writ petition. List this matter on 17th of June.
Okay.
Oh, and Miss So-and-so for Harry. And all this. Buddha Gogoi for finance. Dhar for 4. And Mr. R. Boro for respond number 7. 7. Yes.
Deeply obliged.
51 and 54 together, need. Yes, 51 and 54 together.
Well,
Orders?
item 51, we have filed an affidavit today. Well, that homeopathy matter, my lord. That's.
Oh, is it?
Yes.
Oh,
We have filed an
Mr.
affidavit
M.K.
today.
Chaudhary appears?
Yes,
You have filed your affidavit.
we have filed that.
And in the other, Mr.
Well,
Laskar's matter?
same will cover, my lord. I will serve a copy to him, my lord. He can go through
Okay,
that.
then we will take it up for hearing.
Yes.
Okay.
Only lordship, only respondent number 5 have taken, have filed it.
No, their affidavit will clinch the issue. No issue,
That-
no
that-
problem.
Yes,
Okay.
that will cover the issue.
I have heard this matter at length. Mr.
M. Raman, lordship.
M. Rahman, Learned Counsel, on behalf of Mr. M.K. Chaudhary.
M. Raman in the.
M. Rahman, Learned Counsel for the petitioner, and Mr. No, 51, right?
Yes, lordship.
The Mr. B. Gogoi, Learned Standing Counsel for
The lordship will record as additional AG, my lord. I will take-
additional AG. You are now additional AG. Yes, from earlier on, I forgot. Additional AG submits that he has filed the affidavit
On behalf of respondent 5, my lord.
on behalf of respondent number 5.
Yes.
As such, list this matter for admission hearing.
Yes, my lord. Yes.
For admission hearing on
The motion.
on
Diligent.
on what date?
Litigation.
Any date,
Litigation.
On on 11th of June.
Lordship, Lordship.
Okay?
Oh, let's do.
The other matter also you write, SB Loskar and Mr. B. Gogo has filed. Oh, SB Loskar, huh? Mr. B. Buddha B. Gogoi has submits that he has filed the affidavit on behalf of respondent number 5 in the other analogous matter, and the said affidavit would cover the issue at hand. List this matter on?
My lord, 9 to 13.
No, same day, 12th of June. Ki kolu ichot?
After 13th
11th
or
of
before
June.
9th.
11th of
My
June.
lord, after 13th or before 9th, my lord.
After 9th, before what?
After 13th or before 9th, maybe fixed.
After
Then on
13th
15th,
or
my lord.
before 9th. Then okay, 15th of June.
15th of June.
Both the matters 15th of June.
Highly.
Hey, no, over. Over ne? Okay.